embarrass you a little bit.
That's okay. I had to wait almost a full minute to get in.
How shocking.
Touche.
All righty. Touche. On guard. And so everybody, good afternoon. And this is a meeting of the Town of Greenwich Planning and Zoning Commission being held virtually today, Tuesday, May 24th. We will begin with the regular part of our meeting agenda. We have all of our regular members. If anybody needs to recuse, Mr. Barilak would be seated for that person. This evening, we only have one postponement, and that would be our very last item, 11C, Enrico De Filippo, for a pre-application review to rezone 2 and 30 South Water Street. And with that, we go to our, I'm going to say the first and second applications, but I'm not sure we really should. Let's just do the first one. And let's do the rezone at 18 Armstrong Lane first, and then let's go to the site plan, because I think they're very different issues. And with that, Mr. Hegney, please begin.
Absolutely, Madam Chair. Good afternoon, members of the commission. Happy to take the applications in any order the commission sees fit.
Well,
Hegney.
Mr. Hegney, I think Katie and I are going to say the same thing. Go ahead, Katie.
Well, I was going to ask Mr. Hegney, would you like to have this portion of the meeting recorded, meaning Mr. Basili?
That would be preferable. We do have interested neighbors involved. To have Mr. Basili take a transcript of this application as well as the other two would be very helpful.
Thank you.
So yes.
Was that what you were going to say?
Too long didn't read. The answer is yes.
Thank you.
Okay, thank you. You get
Thanks,
charged.
Tom.
Do we
Appreciate
send the bill to Mr. Hegney?
Yes, I will. I will.
Okay,
and
Mr. Hegney.
we'll be happy to cover that bill.
Mr. Hegney, please go ahead.
You're probably wondering why we're here. I'd like to start with that. The Planning and Zoning Commission did look at this property in 2020 and granted a subdivision approval for 18 Armstrong Lane. That subdivision approval was appealed to the Zoning Board of Appeals and later to Superior Court. In that appeal are two issues which we're looking to resolve with our new set of applications here. The neighbors brought two issues to the court's attention. One, that the town, both the Planning and Zoning Commission and the Zoning Board of Appeals failed to properly review the CAM requirements as required under the town subdivision regulations and the CAM statute. And that two, the applicants or the successful applicants in that application did not provide enough information on the impacts to coastal resources that subdivision posed. Luckily, I believe that the applications we have pending before you today give us an opportunity to cure all of those issues for the neighbors. As I noted, their appeal is based on an interesting quirk of the subdivision regulations, specifically 6-266A20, and references throughout the CAM statute that say that as part of a subdivision application, the Planning and Zoning Commission or the local board in charge of reviewing subdivision applications is required to also review coastal site plans for the development of the properties. I could get into it here, and I'm happy to if the commission has questions. But it really conflates two issues that are separate. The subdivision is really a planning function that the Planning and Zoning Commission takes on, whereas reviewing coastal site plans is a separate zoning function. Did the developments of the lots comply with the town zoning regulations?
Right.
Furthermore, it ignores a large part of Connecticut case law, specifically the Poirier cases, that say that you can go pursue a subdivision and then later pursue development at several years in the future, and that subdivision would be developed in accordance with the rules at the time it was developed, which makes it strange that the coastal site plan statutes would seek both of those approvals at the same time. the town has been doing subdivision applications in this manner for the last 70 years, and I don't think that they're doing it wrong. As part of the appeal process with the state courts, we did file administrative coastal site plans for the development of the 2020 subdivision. We originally thought at the time that we would address the neighbors' concerns by showing with our administrative coastal site plans that there is no impact to coastal resources here. I do want to emphasize that we are almost 1,000 feet away from the coastal jurisdictional line. That's why we were able to qualify for administrative review, because the commission doesn't regularly see coastal site plans for properties that are over 900 feet away. It's just not an appropriate use of the commission's time. That being said, the court still had concerns. I don't think that they were very familiar with the administrative review process for coastal site plans. And on top of that, they felt that the subsequent review by staff did not cure the initial issue raised by the neighboring plaintiffs as part of the 2020 subdivision review. Luckily, again, we can cure that here with these new applications. By having both the subdivision and the coastal site plans reviewed at the same time, I believe we successfully address both the court and the neighbors' concerns. The court highlighted that in their latest ruling on our motion to dismiss, citing Able v. P&Z. It's a Connecticut Supreme Court case regarding defects to serve, and whether or not those can be cured under Connecticut General Statute 88. The judge didn't feel that was possible, so we're back. Under this new application, we're looking at it to create parcels XR, XY, and open space parcel P. And I do believe that we have a proposal here that not only meets the subdivision regulations and the building zone regulations, but also complies with the coastal site plan standards outlined in the CAM. I do note that the neighbors council has submitted an opposition package. I did want to quickly touch on that with the commission, just to note that we can't be forced to use the 2020 subdivision approval. Just because you get permits doesn't mean you have to use them. It's something that the town has seen on a number of occasions. This commission saw it most recently at 359 North Street as part of PLPZ 2022-22, whereas our clients there, the property owners, had the right to go back to use the lot layout of map 5605, the 1978 subdivision that they were adjusting as part of their re-subdivision. Further, we've brought our experts here with us this evening. We have our landscape architect and wetland scientist from Environmental Land Solutions, Matt Popp, here to talk about impacts to coastal resources on this property. And we have our engineer, Tony DeAndrea, to confirm that we do meet with the town's drainage standards and field any questions that the commission may have regarding the subdivision layout, drainage design, or improvements in open space. With that, I'd ask Matt to take us through the coastal resources as defined under the state statutes, and what we need to be concerned about here, and what potential impacts there could be.
Good afternoon. I'm Matthew Popp, landscape architect, professional wetland scientist from Environmental Land Solutions. As Attorney Hegney noted, this site is about 900 feet away from the waterfront, which is to the south. Just going to list maybe the coastal resources that are in the CAM Act, and you'll see that almost all of them are not on the site. I think there's only one or so that's on the site. But bluffs and escarpment, is not on the site. That's the first one. A rocky shorefront, not on the site. Beaches and dune and intertidal flats, nowhere near the site. tidal wetlands, again, not on the site. Freshwater wetlands and water courses not found on the site. Estuarine embayments and coastal hazard areas, again, not on the site. Developed shorefronts, again, just right along the shore. That's 900 feet away. There's no islands. There's no nearshore water, offshore water near the site. We are part of the shorelands was kind of a catch-all term because we're within 1,000 feet of the coastal boundary. So that's the shorelands or the upland area. So we are within that. And we're not within any shellfish concentration area. So this project does not or will not have an adverse impact to any of those coastal resources noted in the CAM Act. And I just wanted to comment on one other thing while I'm speaking here is the staff report from Alexandra Mock dated May 4th, 2022. And there was item number 4 regarding the planting of 4 additional trees, since we are removing 4 trees. Their review, the Conservation Commission review was on May 28th, 2020, so almost 2 years ago. Since that time, I think in November of that year, I did prepare a planting plan, and it wasn't referenced in a letter, so I don't think the Conservation Commission saw that. But we are planting trees. We're planting quite a bit more than 4 trees. Within the open space, we're planting 14 trees, 1 shade tree, 6 flowering trees, and 7 evergreen trees. And then elsewhere on site, we're planting another 11 trees. So we're planting a total of 25 trees on the site. So well above the 4 that they wanted. And we also are planting.
If I could,
Right.
we're getting into a little bit of a crossover between the
Okay.
development plan and the subdivision. When you start talking about what you're planting, you're talking to us about the site plan. Do you wish to combine? I think it's too late to combine the record, right, Katie?
That's fine. I can just fill up
So
that.
Yeah, I
just
mean,
if you
the
would stay
sub-
focused for now on just what's before
Okay.
us is the subdivision, and then we'll go to the site plans and we'll do it separately. I think that's better because
Okay.
we do want to talk to you about the site plan, but very specifically, but separate for the
So
subdivision.
again, no
The-
impact to the
yeah.
coastal resources.
Katie,
The only
Yeah.
thing is in subdivision regs, it does require the planting of 2 trees. So along those lines,
there you go.
you could
We got 'em.
state you're
You got
complying
2
with that.
trees.
We got 'em.
Okay, all right.
I think that was it. So again, no impact to the coastal resources, 900 feet away or so.
Thanks very much, Matt.
Welcome, John.
Madam Chair, I know that at the briefing yesterday, there were some questions about potential development within the open space. I'm happy to take that up now or happy to wait until we discuss
Site
the
plan, right,
development under
Katie?
the coastal site plans.
Well, the applicant does have to prove with the subdivision regulation that the lots can be developed. So there has to be some discussion of the developability of the lots.
Well, but this is very specifically the fact that they've got the drainage in the open space. So do we want to go there right now, or do we want to wait till we
I-
get to the site plan?
I think you should go there now because
Okay.
if the lots
right.
cannot be developed without that, then that might be a problem for the commission. It might not. I don't know. That would need to
All
be
right.
discussed.
So that would be, you want Mr. DeAndrea to speak,
I-
Mr. Hegney?
I'd ask him to explain what improvements we're planning on putting in the open space and why we think that's appropriate for this project or for this subdivision.
Good evening, everyone. We did design the drainage system for the subdivision. We have a comprehensive development plan that affects both lots. We do have an ultimate discharge overflow of a level spreader located in the corner of the open space. And the reason for that is it accommodates the runoff that would enter the property from the northerly section on the off-site portion of the neighboring property. Under the drainage manual criteria, we're allowed to intercept that water and discharge it around the development without treating or detaining that runoff. So we have accommodated that on the topography by saving trees and discharging the water to where it would ultimately end up. By intercepting it along the northwesterly corner of the property, we're able to protect the neighbors to the west, which are lower in elevation. And we thought that was a good plan, and we've implemented that in the design. We do have two level spreaders there. One of them is located within our property, and the other one is located on the number 51 contour, following the natural grades. There was a comment in conservation that we were filling into the open space. The fact of the matter is we're doing a very minor bit of grading around the level spreader. Keep in mind that installation of anything does require some temporary disruption. So naturally, we're going to regrade that and bring it back to its natural grade. The other element of the design incorporates permeable pavers under the driveways, which the conservation staff, Alexandra Mock, thought was a very good portion of our plan. We also have additional detention in the rear yard of each lot to reduce the peak and the peak rate and volume of the runoff. It should be noted that the DPW has reviewed this application and finds the drainage reports acceptable. We've been through several reviews on this application, and the answer is always the same. We meet the standards of the town drainage manual. So in summary, very minor intrusion into the open space. I would also point out at this point that, anticipating the requirement from the commission, we did install boulders along the proposed open space. There may be slight risk that you wouldn't want them, but I believe that it was appropriate in our plan to place them. So you will note on the plan that there are boulders already placed along the boundary of the open space so as to clearly delineate the extent of development. So there won't be any question during construction. If there are any questions, I'll try to answer.
Yes, the question would be, would you be able to develop this site without intrusion into the open space?
The elevations are such that it would be more disruptive around the 3 trees in the southwest corner of parcel YR that we're attempting to save. The installation of the level spreader at grade, which is actually minimal disruption, if you will, I think is an appropriate situation. So could we develop it? Yes, we would have to remove some trees. We would prefer not to do that, but it is imminently developable without the minor intrusion of the level spreader into the open space.
The level spreader, and you also have some other infrastructure, as I remember.
That's
You have-
incorrect.
Okay,
All we have
it's
is a
just the level.
spreader. We have, as I said, 2 level spreaders. One is in the southwest corner of parcel YR. The other one is in the open space. The one that's located within parcel YR straddles the line for about 2 or 3 feet as currently proposed. We positioned those 2 level spreaders to protect the 28-inch oak in the southwest corner of parcel Y-R.
If you had no intrusion into the open space with your drainage, what's the caliber of the trees? I don't have it open in front of me. What's the caliber of the trees you would have to remove elsewhere in the site?
It's just the one in the southwest corner. It's a 28-inch oak.
So it's one tree that's a 28-inch oak.
Correct. And what we would do, if I may, to suggest it is we would have the one level spreader, which would discharge more water through the same element. Whether that's preferable or not remains to be seen, but it could be done. I don't feel at all that the installation of the level spreader at grade with no regrading is at all at risk. I like to think that the open space provides conservation. One of the elements of conservation is water quality and treatment of water and controlling the discharge. And I think that it's done nicely with a level spreader, very minor intrusion into the natural topography. And that is, in my opinion, a strong element of conservation, utilizing open space with minimal disruption following the natural contours and the natural flow pattern. And I would reiterate again that this particular design protects the neighbors to the west who would otherwise be taking overland flow as they do now under existing conditions without any new construction.
So,
Mr. Go ahead, Katie.
Thank you. This is probably a question for Mr. Pop. So the planting that's in the open space area presumably is plantings that would be left natural, meaning you're not going to be manicuring it and trimming and whatever, unless a tree falls or something along those lines. So to that end is a two-part question. One is, I think Mr. DeAndrea might have just answered it, but when you have the water being dispersed from where it's being located, presumably that's a good thing for the trees that you have proposed. That's question one. And two is any future maintenance of the system within this now or soon to be, or geologically speaking, I suppose, but where it will, as it becomes more natural and just is on its own, how disruptive would it be to have to maintain the system of that naturally landscaped areas you have proposed?
Again, Matthew Pop, the intent is for the plantings in the open space to be left natural, no pruning. Again, there's a number of evergreens, so we do want the screening from the neighbors to provide that buffer. So again, no need to maintain those. And as far as I think the maybe Tony can answer better the question of what the impacts would be as far as if there's any modifications to the drainage or that have to be maintained. I think it's just like the level spreader and the water coming from those. The plants were kind of selected based on having it being not a low-lying area, but having the discharge of water. Then we do have shrubs down there that are kind of wetland type shrubs, the clethra, and I think it's the rhododendron maximum. So again, they're able to withstand those moist soils.
Katie, the only maintenance, I think you were concerned about maintenance. I think that's what you said, if you had to maintain it. Typically, the only thing we worry about on the level spreaders is whether or not the grass is growing over from the side. So that's just a trimming of the edges to keep the stone clean and allow the water to discharge. So in one sense, allowing the vegetation to grow around it is good for the absorption and also for the attenuation of the energy. So it works both ways, but very little maintenance is required for the level spreader.
Mr. DeAndrea, from the X parcel, these two level spreaders, the one in the open space and the one partially, they're serving that parcel, correct?
They're actually, if you look at the plan for the parcel XR, the northerly parcel, that drain starts at a level spreader, or in this case, an intercepting drain, at a low spot on the westerly side of parcel XR. And again, we're just offering something to protect the neighbors to the west. Under existing conditions, there is overland surface flow toward those people. They have those homeowners. They have expressed concern. When I walked the property adjacent to us to the west with the owner, I noted a rather simple system. I won't go any more than that. A simple system that does not prove or appear to be very efficient. And when I saw it, it was basically a wrapped pipe almost at the surface because I could see it, and therefore not very efficient for intercepting runoff. So in this case, we propose to have a curtain drain in an area that's definitely a low spot on the property to intercept surface water that comes partially from our property and partially from the property to the north, carry it down around the affected neighbors to the west, and discharge it into the open space where it will follow a natural corridor down to Armstrong Lane and then Gilliam Lane. So I think it's a well thought out plan designed to protect neighbors a little more, other than the additional galleries and detention that we've already provided for the new construction. We can eliminate it if you decide to do it that way, but I would not recommend it.
Okay.
So the level spreader that's now actually proposed in the open space is actually taking up not the system of parcel X, but overflow of the system into parcel X.
I would
So,
say, Ms. McRae, that it's partially intercepting existing runoff, if you will. In other
Right,
words, it's a
okay.
belt and suspender situation that after we have our detention and recharge and water quality in accordance with the manual that the DPW has reviewed and agreed, you'll notice that in a storm in excess of a 25-year event, there might be water coming out of our level spreader up there in the northwest corner of parcel XR. If that were to occur, then we have the curtain drain along the edge of the property as a belt and suspender system that would carry that small amount of excess water down and discharge it through the open space. So in direct answer to the chairperson, we
Whatever.
could eliminate it, but it's a safety factor if nothing else, and I think that it's appropriate to have it. We can do without it. I wouldn't recommend it.
okay, understanding, I'm looking at the piping diagrams here for the drainage and Mr. Pop's landscape plan. I think they need to be seriously coordinated. So you've got the layouts of where everything is supposed to move underground and the level spreaders. And I think Mr. Pop just needs to move the vegetation around to reflect actually where these things are going to actually be installed.
But that's a point well taken. And of course, ours is a graphic
And
indication of what we need to have. And then there's a coordinated effort during construction that we
Right.
accommodate each of the systems, We're not certainly not
to-
intending to conflict with that.
but to your point, Mr. McRae, I think we need to hone in on that once we're doing the site plan as well.
Okay,
I think we need to make sure that these points are clear and that the site plan is fine tuned to what we would want to see once we start working on that. Any other questions from this on the subdivision? Okay, hearing silence. Might we turn this to public comment then, Mr. Hegney?
Certainly, Madam Chair.
All right. And from anyone from the public who wishes to speak on the 18 Armstrong Lane subdivision, please raise your virtual hand. One. And so we have one speaker, Diana Neves, who is coming in, followed by Nick Shepard, followed by Albert LaVerge. Which one is council?
Good
Hello.
afternoon. I'm
It's,
counsel.
Okay, so please go ahead.
Yeah.
We have a long night ahead of us, so we will probably limit other speakers, but since you're counsel, please go ahead. Of course, we would ask you to keep your comments as brief as possible, but not all attorneys listen to that. Thank you, ma'am. If you would go ahead.
Certainly. Good afternoon, commissioners. My name is Diana Neves of Robinson and Cole. I'm here in lieu of Evan Seaman, who you may have seen before on this matter. We represent Kimberly and Ian Tribeck of 17 Gilliam Lane and Albert and Kate LaVerge of 8 Armstrong Lane, all 4 of whom abut the subject property. So just, and I will try to be brief. I know you all have heard this before. Sort of my game plan is I'm going to do a brief introduction, turn things over to my client, Mr. LaVerge. And then we have an engineer with us today, Steve Trinkus, and I did forward his CV to planning staff earlier this afternoon for the record. So there are 2 primary legal issues that we want to address this afternoon, both of which the applicant's counsel has already spoken on. The first, we submitted a letter yesterday regarding the lot merger or lack thereof. It's our position that the previous subdivision approval having been, the Mylar having been recorded has the effect of creating 2 lots. So there's no relief now that the Planning and Zoning Commission can offer the applicant when they come in seeking to subdivide property that's already subdivided. There is no longer one lot. That by recording the Mylar, there are two separate lots at 18 Armstrong Lane. And in order to apply to subdivide 18 Armstrong Lane, the lots would have to first be merged back together. So without legally being able to subdivide 18 Armstrong Lane, there's really nothing P&Z can offer the applicant now, and certainly could not move on to the coastal site plan applications based on a faulty subdivision.
I'm just not following that.
Sure. So
Let me, before you respond, can I just note that this plan is, correct me if I'm wrong, Mr. Hegney, but the lines are different than the original subdivision. So you're, I thought, asking for a revision of the lot lines as opposed,
Yes.
which since we don't have a quote lot line revision application type, we
Yes.
have a question of, is this a subdivision or a subdivision, re-subdivision, which is what the
Exactly.
finding is, it's being asked of the commission. Is that, Mr. Hegney, are we right on what your application is asking of the commission?
I would say that this is a brand new application, Katie.
Oh, okay. All right,
I'm
to
happy to let
us,
Attorney Neves
Okay, so-
finish her comments, and I'm happy to respond. You know, obviously
Okay,
we
so
have a
Mr.
differing opinion here.
actually, Mr. Hegney, I would like to clarify this with you, actually, if you don't mind, because in my understanding, we approved a subdivision. Our subdivision was upheld. The comment that, and we've all read the order, we all have the full text of the order. The comment in the order relates to the site plan, and that's why I wanted to separate the two items on as we discuss them with you. Our subdivision has upheld. You have withdrawn, you are now saying you're withdrawing that subdivision and you are submitting a new subdivision? That's how you wish to have this?
Madam Chair, I would like to clarify that.
Yes, please.
We're not looking to withdraw anything here this evening.
No, but
the
you're
site
saying
plans,
the old one, is dead for you. And this is a brand new, this is a de novo subdivision. And you are, even though we've approved a subdivision on this property, you are now filing a brand new subdivision.
that's correct, Madam Chair. That's
Okay.
why we have a different lot layout. We're
Yes, well,
seeking
but
a
to
different plan.
us, that could have been your different lot layout.
So
Could
you're
have just been a
rescinding-
revision. You've rescinded it, which,
Correct.
see, we
So
understood it to be, I'm sorry, Katie, but we understood it to be a revision of the previous approval.
That's what I
Yep.
had thought too, but so I just want to get the language correct because you're rescinding the previous one.
Yes, and we thought you were only modifying it.
We're looking for a brand new subdivision approval.
Okay,
We have no interest in rescinding the other application until we're positive we can proceed with this one.
That's what
Wait,
I'm saying. Not rescinding.
okay, and go ahead, Katie, what did you
Well,
just say?
I think Ms. Neves has a good point that unless he rescinds or vacates that other one, I mean, if you're looking to solve the problem in the court, I understood that could be solved by you coming in with a revision of lot lines, which I thought was what you were doing to the previous subdivision, and then pursuing the coastal site plans at the same time, which would then resolve your issues with the court. I mean, I think you can't have it both ways. It's either you're starting on this one or you're resolving the past one.
I would say that I don't believe that even with the recording of the Mylar, I think without conveyance of any of the lots into separate ownership gives the property owner the right to either pursue the subdivision as it was approved in 2020 or pursue this subdivision. I think that anyone who's pursued title insurance on a subdivided lot would know that it's not until that separate conveyance in which you're going to get that recognition. I would say that if the neighbors feel that a merger is necessary, I can't imagine why we would object to doing that. But I do think that we have a plan here and an application before the commission that it merits approval. Is something that the town does see from time to time with changes to subdivision plans. But I would say that this is a brand new application that
So-
we would ask. I'm sorry, Katie. Please go ahead.
So you're referring to the Porter case, I presume, which was the finding of the court that the subdivision is only effectuated when there's a sale of one property or a building permit is taken out. However, you did file the Mylar. So are you stating then that this is not, the previous subdivision was never effectuated due to the Porter case? And in which case, then I would ask Ms. Neves to respond to that, if that's in case what Mr. Hegney is saying legally, the legal ramifications of that.
Mr. Hegney, before you respond, Ms. Katie, in a sense, I think we recently did something similar to this, where a previous recorded subdivision was superseded by a new one, and that we required a note on that new Mylar to reference the old and that being it superseded. It was a wholesale change to the previously filed map. And just to kind of button it up, we required that the new subdivision map be recorded and have a specific note referencing the old one and indicating that that had been superseded and the current map, current date would be in effect. I
That's
don't
not
remember
what Mr. Hegney's asking for.
That's
Mr.
not
Hegney
what he
wants you to,
do.
he wants you to accept that there's this old subdivision which he can pursue through the courts, and he wants you to accept this new subdivision which he wants you to approve.
And
So
we
he wants
can't
there to
do
be
that.
two tracks.
So what you just said.
He's not
Nick-
asking to supersede it.
Nick, what you just said was what we thought we were doing yesterday. We all thought that was exactly what was being done, that a
almost like a lot
subdivision.
line revision, yeah.
Exactly.
Right.
But
But that's not what
what-
Mr. Hegney
What
saying. He wants
Ms.
both.
Neves, thankfully, I hate to say this, but because none of us had understood what Mr. Hegney intended, has pointed out is that he wants this as a brand new subdivision. So we can't, the revision is out of the question. Again, Mr. Hegney, from what I read of the trial record, of the court record, our subdivision has stood. You are making revisions to the subdivision, and I'm baffled, but I think I'm treading into territory that I should not. This is your decision. If you want to file anew, that is your call.
Madam Chair,
But you cannot do it at the same time that you have an approved subdivision from us.
I would disagree with that, but Madam Chair, I have to
Guess
to
what?
correct you on the
Guess who
record.
Yes, go ahead.
I'm well aware of whose opinion here matters, Madam Chair.
Just warning you before you.
I
Okay,
do
good.
appreciate good warnings. I do want to clarify here that the court, while the subdivision was upheld by the Zoning Board of Appeals, the court is still pending on the subdivision appeal that the neighbors have. What the order that you read was an order on a motion dismissed that I filed on behalf of the property owners, asking that the court dismiss the case because if the neighbor's concern is whether or not there are impacts
Okay.
to coastal resources, I would
right.
say that our admin
All right.
coastal site plan approvals would have addressed that.
Okay, got it.
The
I
the
stand
nuance
corrected
here-
because I saw your appeal
Sure.
to have it, I saw your request to have it dismissed and I stand corrected. Therefore, but we still go back to our basic point. The
I-
commission thought you were revising the subdivision. If you are doing de novo, you've got to do something about the old one we approved.
Madam Chair, and I'm happy to do that if that's the direction that the commission would like us to go in. It
Good.
is something similar to what Attorney Neves's clients requested, or colleagues, excuse me, requested at South End Court. If the commission feels that's appropriate here,
It's appropriate.
I personally don't, but I also know the status of my opinion on this matter.
Well,
Um,
it's just, you be in our shoes. We can't have multiple subdivisions on one property that are all valid. I mean, I'm not going to say it in legalese. I'm going to tell you it's just not a good idea.
Madam Chair,
You know.
it has happened in town more often than you'd think.
Not
And
recently. and not by us.
359 North Street, 259 Pembroke Avenue, and 99, 103, 105, and 107 Dingletown Road.
That doesn't make it a good idea, does it, Mr.
There you
Hagan?
go.
Mr. Lowe, I
Okay,
would,
all
I
right.
would agree with
So
that sentiment as
we're
well.
going to rest there, and you are going to have to do something about the existing subdivision. Katie, go ahead.
But making changes to subdivisions such as the 359 where there was a change to the declaration and all that, what you're asking for is two separate things. One is a recognition of the previous subdivision and the other is recognition of a new subdivision. So it's, if you're asking to rescind the last one and have this one take over, that's fine. But I don't think you're asking that.
No,
Katie,
he's
you
not.
know, to tell you the truth, following the court's denial of our motion to dismiss, I really thought we were here on a one-item grocery store run, and that was,
don't think
to get the commission to approve both our subdivision and our coastal site plans at the same time, and that's something that Judge Denario up at Stanford Superior felt was an issue. It's something that our
And we
colleague Attorney
we
Seaman did
understand
raise.
that.
And
We understand that. We discussed that yesterday. We understand that we got all that, but you've got a problem to solve. And to Katie's, I'm not recalling the specific subdivisions that you mentioned, but if Katie's correct, which she normally is, that
I
in
would
fact,
agree with
that we were revising or modifying previously approved subdivisions, fine. But in this case, you are not doing that. So there you go. Okay, so we've settled that question. You are going to have to do something about that subdivision. With that, should we let Ms. Neves finish her comments, or should we leave this open and have you, what's he going to have to do? Because he's going to have to come back. I mean, there's two more people from the public who wish to speak, but I don't see even the point of proceeding if this is incorrect.
Madam Chair, I would still argue that this is a perfectly legal way of proceeding.
Okay, but
Again,
I think you
just
heard
because
us.
the commission has issued permits does not mean that a property owner is obligated to use them.
I think you heard
don't
us
think that there's
say,
any.
you heard us say, Mr. Hegney, that in our minds, and a couple of people have now, said it, but, and our town planner has advised us such, that you can't have two active subdivisions at the same time on one property. You can modify a previous one, but you can't have two active ones. And therefore, you're going to have to make a decision. I'm done saying it. But my question is, why don't we just go ahead and let Ms. Neves finish? We'll let the two people from the public speak. And then Mr. Hegney can make his closing comments. Ms. Neves, go ahead.
Sure, thank you. I would, recommend that you all consult with your legal counsel on this issue. I think that you might find that helpful. And I don't,
Oh, we
I
don't
know,
do it to listen.
I know where my opinion goes with you all as well. So, I think to the extent you want to continue this matter to the next meeting or what have you for the applicant to address that, we would be on board with that. We were actually looking for that so that our engineer could have more time to review the recently revised plans anyways. But I can certainly continue my overall comments and presentation if that's how you'd like to proceed as well.
Okay.
So the second legal issue that we want to raise is the Coastal Management Act. And I think there is some confusion about what applies when. And again, I would recommend that you consult with your counsel about it, but my understanding of the statute and the BZR Coastal Overlay Zone regulations is that a subdivision application requires a coastal site plan. No coastal site plan application has been submitted for the subdivision.
Ma'am, there's a final coastal site plan coming up on this.
That's for the individual lots. The subdivision itself.
No.
No, ma'am.
That's
No, ma'am.
Your firm has made this argument time and before, and I don't agree with that. We are a home rule community. we have a planning function, which is the subdivision regulations, okay, a home rule that doesn't follow the state statutes. Then we have a set of zoning regulations. So under the subdivision regulations, there's language in there that talks about the environment, all kinds of other things. And once approved and lots are created, then yes, you're 100% correct that when the application comes in to be developed, it is subject to a coastal site plan application.
The
Okay, it's
court-
just, and
I know the
The-
court has found in our favor on this.
the court's finding
No,
our,
the court has not, with all due respect, the court found that a subdivision does require a coastal site plan.
Which
That is
we
what the
have.
court-
we
Which
have
we
them.
It doesn't have to be simultaneous. We have them, we have had them. We are, this process is,
Yeah,
sound.
it's two separate, it isn't all one package. This is the way we do it. What is before us is the way we do this. And it
And-
stood up in court, and you can't, and sometimes we do the final site plans for a subdivision, even on a coastal, we do them administratively. And that's that. If there's no problem with the coastal, we do them administratively, so they don't come before the commission. And that we've never been challenged in court on that I know of. And I've only been doing this for a couple years, but whatever. Okay, so, ma'am, what else?
I'm going to continue to disagree, but I do not. need
Yeah,
to
that's okay.
belabor it
Mr.
right
Hegney's-
now.
Mr. Hegney's continuing to disagree with us too, and we'll just move on.
we're doing our job perfectly, in other words.
Yeah, we're good.
So on that point, I will just want to state that with the coastal site plan, there are certain things that should be submitted and analysis that should be conducted under the statute and under your regulations, and those have not been done here. In particular, we're concerned about issues of runoff and flooding. And to that point, I wanted to hand it over to my client, Mr. LaVerge, who I think may have raised his hand.
Okay, so with that, I'm going to leave you here, Ms. Neves, in case you want to poke your client or anything. And Mr. LaVerge, I am bringing you in. And after that, Mr. Trinkhouse has his hand up. Is he with you, Mrs. Neves? Yes.
Yes,
okay.
he is.
All right. Mr. LaVerge, if you would go ahead. Mr. LaVerge, if you would just unmute. There you go. You're all set.
Thank you very much.
Hello.
Carolyn.
There you are.
Good to see you again. Thank you. Look, and again, I'm very conscious that you have a long agenda today. If I understand it correctly, this matter is going to be continued to the next meeting. Is that right?
I can't say that out loud to you until everybody on the commission agrees to it. So
Okay, of course.
that is
Well-
my read.
Okay, then I'll save my.
But no, but go ahead, and I think it's good to get everything on the
Okay.
record, because when somebody reads the record later, you're going to have a transcript of this. Please put your comments on the record. Keep them brief if you can, but put your comments on the record.
Okay, we'll keep it brief in that case. Instead of my lengthy objections, I'll just go to my very brief objections. And not just mine, but again, as you may have noted, this has opposition from every neighbor in the neighborhood. And largely because many of us have suffered the direct impacts of the flooding issues and the runoff issues in the neighborhood, and can already prospectively see what the impacts to this development are going to be. I will just say for the record, we have no objection to building on this property. We have no objection to the builder coming in and having a remunerative development here. We're not trying to get in his way or anybody's way of building another home in our neighborhood, or even his commercial aims. Our issue from the beginning has been, given the regular flooding and drainage issues in this neighborhood, which are well documented, going from 3,000 to 4,000 square feet of hardscape to, double that, you know, is a real issue about which we worry. And I think we've seen, you know, the amount of discussion and moving of plans and, you know, level spreaders having to be moved to the foot here and the foot there. It's just very clear that this doesn't fit, right? You know, the open space, which again, the committee has latitude to ask up to 8 to 15%, and that's always been the guidance. The committee allowed for less than that, which I also understand in a regular subdivision wouldn't be an issue. This is not a regular subdivision. Again, it's the coastal subdivision. It's also not a regular subdivision in the fact that it's a property that has issues, and it's going to continue to have issues. And to try to shoehorn, and it's very clear how shoehorned it is, because we're talking about square feet to the left and right, and the applicant is, you know, is working very hard to address those. But it's also our contention, if you have to work this hard to get something to work, there's a reason why it's that hard, right? Perhaps it just doesn't work and shouldn't work. And again, these aren't legal arguments, but the main argument is, as I said before, the flooding. And one last thing I'll say, you know,
Yes,
there
sir.
are experts spoke about coastal resources. He's talking about contiguous. If any of you walk the property on a rainy day, you will see the direct flow from this property directly down Gillingham, directly into Twin Lakes. And the groundwater runoff is significant. It's significant. And you see it after every rainy day. So
Okay, now hold all those thoughts, because we're going to talk about that when we talk about the site plan and the drainage on the site plan, okay?
So with that, I yield my
Yep.
time back, and
All right.
thank you.
Thank you very much,
I have
Mr. Laverge.
Mr. LaVerge,
Well,
quick question.
Wait, Katie, Katie
No,
and
go ahead.
Nick.
If I could go after
Yeah.
Nick, go ahead.
Mr. LaVerge, has your consulting engineer reviewed the plans Mr. DeAndrea's put together?
He has. I will say that these new plans were only filed last week, from our understanding, or at least that's when they became available to us. So he's only had a few days to look at it. He has reviewed it, and I know he does have comments. But again, it's Mr. DeAndrea and the applicant have had quite a lot of time to prepare these. We have not had quite a lot of time to review them. But our engineer does have views if the committee would like to hear those.
Okay, I would,
Madam Chair,
go ahead.
yes, sir. So the point that I made in the very beginning of the meeting is that when an application comes in for a subdivision, the job of the Planning and Zoning Commission is to determine whether the two parcels being created in this instance can actually be developed. So if you read through the subdivision regulations, you will see all kinds of things in there about environmental issues, drainage issues, sewers disposal issues, everything that is potential impact on the property and off the property is in those subdivision regulations. That's if the property is in the coastal area or if it's in the backcountry. So the point of the subdivision regulations is to require that the applicants provide development plans so that the commission can determine if they can be developed. Further, in the coastal area, we take that one step further and require that an actual site plan building permit sign off is submitted so that they can be reviewed against a different set of regulations, 6-111, and if it's in a flood zone, 6-139. So we go above and beyond where there's all these different reviews. So it's a little confusing in that you actually have submitted these coastal site plans. And I think the chairman's correct that we have, obviously there has to be separate motions taken if we get to that point. However, they are intrinsically tied in that we usually do these things separately, but you always have a development plan that has to be shown in conformance with the other regulations throughout town, the drainage manual, the sewer sign off or septic, whatever the case may be. Because the commission has to make that finding under the subdivision regulations. Just wanted to make that point.
Okay. All righty. Mr. Laverish is done. I'm going to bring in Mr. Trinkhouse. I started to bring, he didn't come in before. All right. All right, Mr. Laverish, stay tuned because we're going to do the final site plan as well. Oh, thank you very much, Patrick. I appreciate it. Mr. Trinkhouse, you're good to go. You just need to unmute. And Mr. Levy, can I remove the second version of you to the attendees?
Yes.
Should I just kill him from the meeting? No, you don't want. I'll just move you to the attendees.
I'll just.
No, that's all right. Okay, Mr. Trinkhouse, go ahead.
Yeah, good evening. My name is Steve Trinkus. I'm a consulting engineer from Southborough, Connecticut. I've been licensed in Connecticut since 1988. I'm very familiar with your stormwater manual. I did get these plans early last week. However, I was out in the field the end of last week. So while I had a cursory review of the plans, I have not done a detailed review. A couple things I noticed in the application packet. In the stormwater summary, all of the appendices, I think they go from A to maybe G or H, were not part of the application packet, and that's all the hydrological calculations. So I would request that that information be available on the website so they can be reviewed, because that's the meat of the stormwater report that has to be reviewed. Based on a quick review of the plans, I also have a degree in forestry, and I want to make a couple comments regarding the trees on the site. The root systems of trees go out and they mirror the crown of the tree.
Of course, we know that.
Well, but if you look at the applicant's plan, a lot of the construction, especially on these larger trees, the oak trees, which were discussed earlier, those crowns are likely quite a bit beyond what they're showing as the tree protection detail. So there might be greater portions of these level spreaders well within the drip line of the trees, which will adversely affect the trees over time, depending on the level of excavation. So the crowns of these trees should be determined in the field by survey so that the commission can really evaluate the potential impacts of the excavation around them. The system stormwater management in general consists of either permeable pavers or underground cultex. There's gravel layers under each of these systems. Gravel in and of itself provides absolutely no water quality benefit. It's a storage media, that's all it is. In looking at some of the test holes on the data, again, without a detailed review, I believe several of these systems do not provide the 2-foot separation from an infiltration practice that's required under your manual. So those are the only comments I have at this time, and would request, as Attorney Neves did, to continue this so that I can review the plans and provide a written review to the commission.
Great. Okay. Thank you very much, sir. All right. With that, those are the speakers. I think we did allow Ms. Neves to finally finish what she was going to say. And Mr. Hegney, would you like to make any closing remarks?
Certainly, Madam Chair. Just to say that, this is a new application because we are looking to have this reviewed and approved at the same time as the coastal site plans. I believe the coastal site plans that we have for the development of the 2 lots are what would be required under the CAM statute. I can't imagine what else a court would want to see. I'm happy to state that, I do think that this is a plan that complies with the regulations. I think that it will represent an improvement throughout the neighborhood. I would say that Public Works has reviewed this plan 4 times now, or development of this lot 4 times. Every single time they've come back and told us that they think that we've done a good job of developing the plan with good sound engineering principles in a manner that's consistent with the town's drainage manual. They have yet to come back and say otherwise. I also know that Joe Rizzoli took a look at this back in 2018. I am open to feedback from the neighbor's engineer, but I gotta tell you, from a bird's eye view, I don't see any comment or concern that could be raised that prevents 2 lots from being on this site. and happy to address the commission's concerns regarding the Mylar recording. Happy to do that so that we can have this conversation at a future hearing date.
All right, then. So, okay, Katie,
Well, to that end, I mean, I think the first question is, I think there's only two choices. Are you submitting this as a revision of lot lines, or are you submitting this as a new subdivision and therefore rescinding the old subdivision? So you don't need to answer that now, but I think that needs to be answered, which way you're coming in.
yeah,
And then-
if you, yeah,
And the second point is, whichever way you're doing it, if you're coming in with a new subdivision, there needs the development of the lots at this level, not at the necessary coastal site plan level. I mean, you see all the time when people come in for subdivisions, they provide a development plan, which could be different from the development plan. And in each instance, there is a revision and a review. It's not a revision, a review by the applicable departments, et cetera. So if there's some issue, Ms. Neves, that and as the engineer has said, you would want a chance to review it, but that needs to be handled obviously at the subdivision level also, so that they can determine that these lots, the commission can determine that the lots can be developed.
Katie,
Okay.
I have to agree. I would say that, normally you're looking at feasibility. Obviously we've come a
Right.
lot further here because we have coastal site plans ready for the commission's review.
Right.
okay. So given the situation, that, if you will, the technical status of where you are with the subdivisions, Mr. Hegney, I believe that we have to leave this item open at this time. Would the commission have any disagreement to leaving this item open?
No.
Please advise if anybody disagrees.
No.
All right. That being the case, I humbly request that you provide an extension to us, as you have this as a must decide by 5/25.
I'm happy to provide that extension. I would ask staff if we could be included on one of the June agendas for hopes that we can return to the court for a status update on June 22nd.
I'm looking at Mr.
Request.
LaRoe. What?
Request noted.
Request noted. Okay. He's
Pat, I
under,
feel like you've been saying no an awful lot.
no, he's not saying no. He's caught under pressure because we have another very long agenda tonight and we do like to finish in less than 7 hours.
He said
course.
noted and not no.
Note, he said noted,
Thank-
exactly.
Thank you for the
All right,
clarification,
so
Mr.
with
Law.
that, we're going to leave that application open, which at some level, it means that we would not therefore be able to give you an approval for the site plans tonight. However, I would like to give you some comments on the site plans and open it. It is your call on what you want to do.
Madam Chair, we'd be happy for that feedback. Happy to always interested in comments from the commission.
Therefore, why don't we now move to items 2 and 3 on our agenda, which are the 2 final coastal site plans at 18 Armstrong Lane. And we will hear them together and provide the comments thereon. And again, we're going to ask you to, of course, you only have that you've got these as a must decide by 6/2. So again, we are going to have to request an extension from you since the subdivision has not been decided. With that, Mr. Hegney, please proceed, bearing in mind that we have a very long evening ahead of us.
Of course, Madam Chair, I'll be brief. These are the coastal site plans that were designed and developed in order to accompany our subdivision. As noted under the town's subdivision regulations and the CAM statutes, both of these need to be reviewed at the same time. Again, we believe we have a plan that meets both the subdivision regulations and the building zone regulations and the town's drainage manual. It will represent what we believe is an improvement to the neighborhood. We're happy to field any questions from the commission.
Commission, any questions? Mr. McRae, I'm going to go to you because you raised a couple of points when we were listening to the subdivision that I would like you to make again as relates to the development plan.
Is that concerning the movement of the level spreaders?
Yes, and you made another point, which I'm blanking on, but we'll remember in a sec. Yes, go ahead.
Okay, I think we had talked to Mr. DeAndrea about possibility of moving the level spreaders out of the open space. It's X that serves that level spreader. We're just wondering if that could be moved farther up, or possibly adding another Coltech or something to parcel X, so we can get that out of the as part of that process, or part of the drainage plan, to actually get the level spreader out of the open space. Just kind of looking at it, his explanation of actually it's a catchment for an overflow to get it down into the corner. Also, Mr. DeAndrea, I guess you're aware of the notes about from DPW about an icing condition on the street. If there's a potential icing from how the level spreader drains. If you have a minute, can you just comment? Do you think that's a real possibility that there'd be an icing condition?
I don't think it's an icing. I don't think it's a realistic consideration for an icing condition. The conditions along that road exist today are that they have allowed the shoulder to erode. So what happens is the water does run down the gutter of the road and does not sit on the road to create icing.
Okay.
That can be readily seen in a field visit.
Right. Could any other subsurface or additional subsurface in lot X be added to negate that level spreader? So it's more storage on X than providing for the overflow?
The design was not intended to try to store the water that comes off the site. We've already stored the water from the design. One of the notes we made is that on the overall, we're only increasing impervious area on these two lots by 2,300 square feet compared to existing.
That's
So
a whole house. That's basically a whole house.
It's a very minor amount. It's a 50 by 40 foot box.
I
We
mean, you're
recognize-
okay, but you're talking to people, some of the people who are on this meeting don't have bigger footprints than that. So to us,
Some-
you're telling us you're adding a house to the
I will-
lots.
I understand what you're saying, and I will only qualify that by saying everybody on this meeting in the neighborhood has a house larger than that. So
All right, but
what I wanted to say was, we can eliminate that level spreader. We'll take it out of the extra level spreader, the extra curtain drain at the north end of the northerly parcel. Just keep getting, we've had so many changes, I have to keep reminding myself. We will take it out. All right, we will remove the curtain drain at the northerly portion of parcel XR. And with that way, we will not put a level spreader in the open space. And we will rely on the approval by our town engineering department, DPW, that we have met all requirements of our town drainage manual. And we have demonstrated sound engineering principles in the design of this subdivision. And
Okay.
therefore, we will rely on that design for
Mr.
approval.
DeAndrea, I would like to phrase it to you a little differently.
Okay?
From the feedback we have heard, the comments I've heard, there are two priorities here. The first priority, which is of course what's required by the town anyway, and I know you have expertise in accomplishing, is absolutely no stormwater impact to be added to adjacent properties. The
Agreed.
second thing that you have heard concern in regard to is the question of how environmentally satisfactory are your site plans. If you could get to the point where when you come back to us, not only have you documented with all the data that possible that there is no stormwater impact on the adjacent, but also that conservation feels that you have struck an excellent balance in regard to this plan and the impact on its environment in terms of natural resources, then you will have scored a home run. Those are the two things that these plans are looking for. And those are the two issues that have been raised repeatedly. Okay?
Yes,
So I would say don't marry yourself to, I'm going to do this and that right now. Try to accomplish those bigger, greater objectives and come back to us with that. come back to us with something that has accomplished that, if it in your mind does that. So conservation happy, and you meet the stormwater manual completely.
Okay,
Okay, thank you, sir.
understood.
All right, we've got one person who wishes to speak on this application. Counselor Neves, did you want to add anything to that? To this, where we are?
If we are treating these as separate records, then.
Yes, we are. These are separate records. Do you want to
Yes.
include your testimony from the first record? I'm not sure we can do that, but we could merge the records later. I've lost Katie.
Most of my testimony from the previous application is relevant here, so we could do that. I don't know if you can do that.
I would just recommend if you want to read.
Just say it again.
Yeah.
Say it again.
Say it
Sorry.
again. Be safe and say it again.
Sure.
Say it again, Ms. Neves. You're
Sure.
safer.
Sure, Diana Neves of Robinson and Cole. I'm here tonight with my client, Albert Laverge, and our civil engineer, Steve Trinkhouse. Also represent Kimberly and Ian Tribeck. Both the Tribecks and the Laverge families abut 18 Armstrong Lane. With respect to these site plan applications, we have two categories of concerns. The first is really the legal status of the subdivision. If there is no legal subdivision, these site plans cannot stand either. And the second is the Coastal Management Act. We heard from applicant's consultant that there is no impact on the coastal resources because there are no coastal resources on the site. That is not quite what the statute or your regulations require. It's really impact on coastal resources. So as our primary concern is with flooding and runoff, we do think there is an impact on coastal resources, and we think an evaluation of that needs to occur. And we think applicant needs to demonstrate that there will be no adverse impacts on the coastal resources, as is the applicant's obligation under the statute. So now I will again turn it over to my client, Mr. Laverge.
Before you do that,
Yes.
Mr. Levy, you have your hand up.
Yes, I did want to try again just to encourage the application about saving trees. Something that we talk about from time to time. There's a 26-inch oak, I believe, that's presently in the driveway as designed, and there's another 24-inch tree along the property line. I personally am not convinced that the driveway can't be reconfigured to accommodate the tree in the front yard, where they're presently looking to take it down. I think that's a pretty easy thing to try to adjust for. So I'm not sure why they are really not considering trying to keep the tree. On the side yard, I'm not sure why the tree is coming down, but I do want to encourage them to reconsider keeping these big trees. These big trees are a resource that are not readily renewable. I don't care how many new trees you plant, the resource of an existing tree of this size is really quite unique and simply just not replaceable.
So absolutely, Mr. Levy, thank you for your comments. So Mr. DeAndrea, there you go. Conservation as well as stormwater, and that those two have to be married as best as possible. We're ready to turn to the public then. Our first speaker is Sophie Coven. Ma'am, if you would go ahead. Hello.
Hi, how are you? Thank you for having me today. I'm here as a concerned neighbor and also as a member of the board of the Gilliam Lane Association. And I wanted to comment a couple of things. First, I just want to say I thoroughly agree with Mr. Levy. These mature trees are irreplaceable, not only for sort of their natural beauty, but also specifically in relating to stormwater. They hold an enormous amount of water in their canopy, and they, suck up a lot of water in their roots. And when we cut these trees down, that's not taken into consideration, is my understanding, because I spoke to the town engineer about this a few months ago. That's not included when we're thinking about what the stormwater runoff is going to be. And I have noticed over the past 10 years, as many mature trees have been taken down in our neighborhood, that we've had an incredible increase in flooding all along Gilliam Lane and Twin Lakes Lane. And specifically, I want to be super brief, but to address the 2,300 additional square feet of impervious surface, that's a significant increase. And then when you consider taking down several large mature trees, and that many trees will unfortunately die in construction. And again, we've all noticed this. We've seen a lot of construction in our neighborhood, even the trees that are fenced off, the roots get compressed, oil spilled on them, and they die. So there will be a lot more water. And it is true that right now Longview is a gravel road. So when water goes on it, it might not be as icy as an asphalt road, but there's a lot of complaints in the neighborhood right now about the fact that it's a gravel road, because when water goes down, it washes the gravel into Gilliam Lane. And we've actually had several people fall on bicycles and skateboards because of the gravel. So we're actively looking into fixing that situation, which may mean paving that road, in which case, if there's a lot of water on it, it would be icy. So we just do have real concerns as the association that this is going to create a dangerous condition for us, both in terms of flooding for our neighborhood and also ice in the winter. So just, and as we all have discussed previously on these calls, there's a lot of water coming down that road already. And if you add all 2,300 square feet of impervious surface and take down trees and have trees die, it's going to be a lot more water, and it's going to end up in the wetlands at the bottom of the lane, and it's going to end up in the tidal pond. Thank you very much.
Thank you very much, Ms. Coven. All right. Mr. Laverge, if you would go ahead again, and again, if you would keep it short, because we're well over an hour into this meeting and we have 12 more items. Thank you, Mr. Lauro.
I have a stopwatch on, so we'll just
thank you, sir.
Reiterate the issue that was stated before in terms of, there seems to be no practical way to mitigate the flooding issues, while squeezing two houses onto this property. And also to Mr. Levy's very, I think, apt observation, they're cutting down multiple large caliper trees, a 28-inch caliper, a 24-inch caliper tree, in order to squeeze these two houses into the lots, and all of the effects from that. So, and I'll again, I just wanted that spoken into the record, but we believe this is a serious issue.
Thank you very much, sir. Next speaker is going to be Nick Shepard.
Hi, can you hear me?
Yes, sir. Go ahead.
Yep. Thank you for giving me a moment. Just very briefly, my name is Nick Shepard. I'm a resident at 8 Longview Avenue, which is directly to the south, across from the overall property. I just wanted to comment that for those who aren't that familiar with the area, the overall topography of the site is that it runs towards Longview. And so, it does slope down in that direction. And Longview is a private road, which really has only been maintained by myself and, my direct neighbor to the west at our own personal expense. So, I'm primarily concerned about the drainage here. It's already an ongoing problem for us where after each major storm, there is significant erosion on Longview. And, you know, I personally have been out there with a gravel rake trying to kind of regrade the road. We frequently retain contractors to come and regrade the road as well, all at our own expense again. And so my primary concern here is just that with this increased development, we're just going to exacerbate that, and there'll be additional erosion on Longview. And, you know, while the developer is going to obtain kind of economic benefit of the subdivision and profit from this overall project, the expense of maintaining Longview is going to fall onto myself. So, you know, I think that's rather unfair, just in the big picture here. And, you know, obviously, I'm also concerned about the environmental impact, because during those significant storms, you see the water come down Longview and then run on to Gilliam, and then, you know, it all dumps down into the lake at the bottom of the hill. So, you know, again, I just ask that, you know, as you guys consider the overall project, you do think about the fact that it is gonna impact myself and the other Longview residents who maintain that road.
Right.
Thank you.
Thank you very much, Mr. Shepherd. All right, so let me just quickly, we are going to leave these two applications open. It is actually impossible for us to approve them given the fact that there's no underlying subdivision. So with that, I ask the attorney to kindly provide us with extensions on both of these items, and that would be the two site plans for 18 Armstrong Lane. And we will see you then when you return.
I'm happy to do that, Madam Chair. Again, I'd ask staff to consider us for one of the June hearings. I will tell you that these issues are not new. These
No,
are the
we
same
are,
issues that were
yes.
raised in 2020.
Well,
and
of course, Mr. Hegney, just to remind you, the commission did not see the site plans at that time, and we are currently discussing the site plans. So the issues that are being raised are brand new as pertains to site plans. Just
Certainly.
okay? Alrighty.
I would like to leave the commission with one other thought. It's because it's something that Attorney Neves and her colleagues have brought up a number of times with regards to coastal resources. I do feel that to a certain degree, we're chasing ghosts. You know, they're saying that we have the obligation to point out these coastal resources. We did bring Mr. Pop here this evening to tell the commission,
yes,
there aren't any coastal resources that we can find that we could try and impact. So when we're talking about impacts to coastal resources, I do worry that we're being asked to prove a negative here. And it's a very difficult task when there are no coastal resources for us to try and impact. So with that,
Thank you, sir.
I would leave the applications open. I will make sure that staff gets the appropriate extensions. Thank you very
sir.
much, Madam Chair.
All right. Now going on to our next application, Mr. Basili, you will be getting a one application break. Our next application, it's this application coming up. It's it's Bachi Biberi for a final site plan to construct a raised deck at 2 South Water Street. And representing the applicant, I believe, is Mr. Biberi. If you
I
somebody
thought it
would
was Mr. Bender, but I don't.
I'm not seeing anybody raising their hand.
2 South Water Street.
Mr. Bender? I'm shouting.
He must not be able to hear you, ma'am.
Okay. Okay, well, we're going to move on then. I don't see either applicant here. And we'll just, it's okay, right? We can just skip it, right? Katie?
If no representation, yes, I think we should wait on that, but it is a must decide.
Well,
maybe they're going to maybe show up and
if
while
they
we're-
don't show up, then we will have to decide it at the end of our meeting if they have not
Right.
come. All right, we will decide it. Well, actually, hold on a second. It's not a must decide. Oh, yes, it is. I take it back. So it's a must decide, and we would just, we can do that.
Well,
right.
meantime, get in touch with Mr. Bonder.
You could try and get in touch. I don't think it's fair to them to make the decision now, so we'll give them some chance and we'll go ahead. All right, Mr. Basili, we're going to put you back on then, because we're going to combine the records. I think that's the best way to do this for the next two applications. And with that, it's Byram Properties LLC for 14 and 16 William Street in the R6. First, for a final subdivision to revise the common property line between two adjacent parcels. And this is a 51 square foot impact. The second one is the actual final coastal site plan and special permit for a two-family house at 14 William Street. I know that one is the subdivision, one is a lot line revision for two properties, but I feel that there's enough common ground. We'll make the decision separately, but we should have a combined record, I believe, unless staff objects. Objections?
Only if the applicant does.
Okay. Applicant,
Good evening. or good
you
afternoon.
don't object to us combining the record, do you, Mr.
I
DeAndrea?
have no objection to combining the record.
Okay. All right. Go
I hope
ahead,
I can
sir.
Keep them separate enough to make it clear.
All
I
right.
am here on behalf of Byram Properties LLC. I'm going to present, and I hope you agree, a very good plan for the redevelopment of 14 and 16 William Street. And I trust that all of you have now had a chance to see the site and recognize that the building that we're going to discuss was constructed somewhere around 1900, according to the assessor. That's the best information we have right now. And I think we would all also agree that the side of the property at 14 William Street has certainly outlived its useful life. So if we can start with the subdivision that we're proposing, or the revision of lot lines, as I hope you will decide, we are proposing to demolish the portion of the structure which is primarily on 14 William Street, and then finding out whatever is left on the side of number 16 William Street, which we'll refer to as the westerly side. The proposal by Byram Properties LLC, the owner of 14, is to reside the building, the west side of number 16, and then define that as the outside or new boundary line between the two parcels. In order to provide for maintenance of number 16, we have also defined an easement for maintenance that will extend and run the full length of the building once it's exposed at number 16. And that's the essence of the application. Eliminate the encroachment of 14, eliminate the encroachment of 16 onto 14, which you can see by our drawings currently exists. We've shown that on the subdivision map, the zoning location survey used for the revision of lot lines. You can see that as a crosshatched area. The total is about 51 square feet. And then we will have had a reduction in the remaining parcel, which we refer to as parcel N, and that will be decreased by approximately 51 square feet. We won't know the exact area until the demolition is done and the re-siding is done. And as I explained to the Board of Appeals, when they granted the variance for the reduction of area on number 14 and the side yard, total side yard and minimum side yard on number 16, I told them that the area will be determined at the end, but it is approximately 51 square feet as best we can tell. So we just hope that the commission recognizes that the final delineation of the lot line will differ slightly, but the intent is the same. I did mention that we did receive variances for both.
Wait. The final lot line is going to be different from what we see.
We don't know exactly where the siding is once you remove number 14. We are unable to determine that until the outside of number 14 is removed.
Why do we learn these things at the hearing? Okay, so I'm not
Hope that's
sure.
not confusing.
It's not that it's confusing, it's just that I don't understand how we're gonna, well, maybe I am confused. How do you approve a lot line that you don't know where it is?
You do know where it is. It's going to follow the outside of number 16.
That's
after-
not, no, it's gotta be the location on the ground.
It will
I'm
be-
no,
it
I'm
will
no,
be-
I'm no surveyor, Mr.
No, I'm going to
DeAndrea.
try to explain it once more. We're going to ask the commission to recognize that the final delineation of the lot line is not clear. We're asking you to approve it as following the exterior wall of number 16 after it's resited. It's a very simple concept, I hope, and that's the way we're presenting it. There's
Not a
no-
legal one. It's not a simple legal concept at all because a lot line follows the land and it follows the actual citation of the land, not of a building standing on the land. So it's impossible for us to do that, Mr. I just don't see,
agree.
Mr.
Let's just
DeAndrea, how
try-
we can do.
let's try one more time. The current situation has a portion of number 16 where a gentleman resides extending over a defined property line. We need to revise the property line to eliminate the zoning inconsistency and nonconformity.
Let me give you a plan B. I'm going to give you plan B right now. It's this. You go get yourselves a demolition permit. You go demolish part of that part of that building that's got the intrusion on the other lot. You figure out where the lot line's going to be and you come into us with a lot line revision. Or you are going to have to come in and file formally for a revised lot line once you know exactly where it is. But we don't do it based on a building. We do it based on the lay of the land. That's how you do a lot line. You, come on, Mr. DeAndrea, you taught me a lot about what I know about surveying.
Well, you
Way
were
back when I was a baby commissioner, you taught me these things. So it
You
does
weren't
not say, no deed I have ever seen says where so-and-so's building stands, that'll be where the lot line ends up being. You can't do that. So you've got two choices in front of you. You don't do it right now and you get a demolition permit and you define exactly where it is, or we give you a subdivision, the lot line revision, and you come back in with a new lot line revision when you know exactly where your lot line is. And until then, we don't give you a site plan. Sorry.
Okay. So I totally disagree. I would hope that you could possibly take a polling of the commission members to see if they
We
agree
don't
with-
poll commission members, but I will ask staff.
This is
And
a
if not,
very-
I'll ask Mr. Wetmore. But my take is lot lines for any of us who have ever bought a house are not based on a structure. They are based on the land, the longitude, the latitude, the number of feet on the land.
The lot line will follow the exterior of the building after it's been resited to eliminate dual nonconformities of your regulations. We have a very practical approach. We can come back to you and document. What we want or asking the commission to do is to approve this process whereby we can move forward and demolish this blight on the neighborhood.
Totally agree with you on that.
Going
And
on for over 14 years.
no, Mr. DeAndrea, don't throw that one into the mix. We totally love the idea of getting rid of the blight. We're super happy you guys are going to move forward. We think it's great. However, from a legal standpoint, a lot line is defined not by a building. It is defined by the land. I've never seen it defined otherwise. Therefore, unless Mr. Wetmore corrects me, and I'm perfectly happy to fall on my sword if Mr. Wetmore thinks I'm wrong.
There's
I've
a
never
first
seen
part
it.
of this.
Go ahead.
Can I
Madam-
make a suggestion? Would
Yes.
it be possible, Mr. DeAndrea, if you had a proposed lot line, which it's, you do have a proposed, so
And
in
they
other words,
revise it.
yeah, don't talk about the following the exterior of the house, just propose a lot line and as to where you think it's going to be. And then proceed with, assuming the commission's okay with that, proceed with then getting the demolition and doing that. And if you were wrong, then come back in and revise the lot line.
That is okay, Mr. DeAndrea. That is your plan A. You tell us it's going to be 3 feet north and 4 feet south or whatever, and you give us the lot line. And then if it turns out you goofed and the wall wasn't where you thought, you come in and revise it. No problem. But you can't just ask us to say, well, if you move the lot line 6 inches to the north, we're okay with that, because we're not going to do that.
Mr. DeAndre, I have a technical question for you. What is the current plan to rehabilitate this facade of the building? After the existing building's demolished, or that side is there, what do you expect to be remaining?
The outside, Mr. McRae, will be the remaining studs, the outside of the studs unprotected. We need to have the ability to take the building on the west, on lot number 14. You can't leave it open for 4 weeks while we wait to come back to the commission for something that's very practical. Understand that the proposal you're making, which we will define on a follow-up map, which
All
you
right.
may call a revision of lot lines, but we will follow the exterior of the building. There's no other practical way.
Okay.
Madam Chair, perhaps I can describe it another way. When construction happens and the dimensions are not met, setbacks are not respected or just accidentally crossed over, we typically do get site plan subdivision applications after.
Different.
to address
This
that.
is totally different. You
Well,
are changing the boundary of the lot, Mr. LaRoe. I know that if a garage turns out to be into the side yard, encroaches the side yard, they get a variance, all that stuff can happen when people make mistakes. You are here talking about the lot line boundary being revised, and that is not something that one does based on a building.
I'm not, that wasn't what I was suggesting. I'm saying that we have approved lot lines and then revised them post-construction because
I have
of
no
the-
problem with doing that. I'm saying to Mr. DeAndrea, give us a lot line.
I don't think Mr. DeAndrea is hearing that. I think he's worried that we are going to hold up the
No.
process on it. and
No,
that's-
Mr. DeAndrea, we want you, we love the idea of getting rid of blight. Tell us a lot line that is based on the earth. And we will approve that lot line, and we have your hand in commitment that if that lot line is revised, as you discover the contours of the building that has to come down, you just come right in and get a revision from us.
You can
Or
approve-
the other way, which is the first way Madam Chair suggested it. I don't know if this is what you meant, but what if I understand the concern about you having this open building or whatever. So would it be possible, let's say if you took down the building on a Thursday and Friday, well, I guess where I'm trying to go is if you demolish the building and then time it such that you'll be on the next meeting in less than a week with your line, knowing where it's going to be.
Katie, there's all kinds of inspections that have to be done. Foundations have to be constructed. I don't see why you cannot approve it as is proposed. And we'll come back with a revision of lot lines if that makes it possible. But you're
Oh, good.
understanding that the lot line will follow the exterior of the building, that you do not know where it is, nor do I. And I can't in good conscience agree with you that it's appropriate to think we're going to leave this building exposed for a month.
No,
It doesn't
but
make
Well,
sense.
it says,
Mr. DeAndrea, you also can't in good conscience for your client, give them a lot line that does not exist because you can't make a lot line based on a building.
We've had multiple attorneys working on this for multiple years to have an understanding of how this will work amongst the neighbors so that it can be done quickly, safely.
Yes,
and
you're
appropriately.
absolutely right. But all we're telling you is that once you define it, you have to do it in terms of the ground and not the building. You may revise the lot line that we give you. Just come in and tell us that it's 6 inches further to the north or whatever, but you can't base the legal description of a lot line on a structure. So for example, what if there was a hurricane? I'm just telling you, you do it based on the earth. And you know that. Come on, you're a surveyor.
I have an idea.
No, I mean, he's got 2 ideas before him and they both work.
This will
Well,
solve this.
what's to prevent, just one quick question, if I may. What is to prevent creating a lot line that is just outside of the boundary of the structure, but on
The structure can do because the
'cause it-
structure straddles the property, remember?
Okay,
Okay, go ahead, Nick. Let's see if you've got a
Okay.
great idea.
Mr. DeAndrea, this is going to be a little bit more involved, but I think it will resolve our issue.
See if you can do it.
If you can take the line that's being proposed, that would be the building line of the renovated building, and just offset it by 6 inches, give us meets and bounds of those every turn and twist. That would be the subdivision map. It would actually give us meets and bounds of the way perceived property line. It'll also give you a little wiggle room and latitude to actually get the building repaired. And then when you come in, you're going to give us actually a revision that would
Yeah.
follow the building line, actually follow
That's what we're
the
saying, Nick.
foundation.
That's what we're
Okay.
saying, Nick. We're saying, give us meets and bounds now, and then come in and revise it later. That's exactly what we're saying.
Okay.
And well, let me ask one more favor then, following what Mr. McRae just suggested.
Okay.
Why don't you make it a condition of the approval for the revision of lot lines?
There is no condition on a subdivision, Mr. DeAndrea. No conditions can be.
Conditions of subdivision. You make conditions.
No,
on
sir. No, sir. We do not
It's a lot
condition
line-
us.
Yeah, so if
No
it was a-
conditions.
This won't be found to be a subdivision, Mr. DeAndrea. That's
No conditions.
It would. it'd be
Sorry.
found to
The
not be a-
best thing we can do for you is you give us meets and bounds, and then you come in, you can do what Nick said and give yourself 6 extra inches, whatever you want. When you're done, you come back and you revise those meets and bounds as appropriate.
Okay.
Now,
Mr. DeAndrea, I want to go back to what I was talking about before. This is actually a very critical issue.
okay, go ahead.
Do you
Critical.
know what is the status of the building once you remove the existing area? It's going to be open wall, but do you need to put a foundation? Does the roof need to be supported? You know, can you explain to me what they're going to rebuild, or do they not know yet?
All of the above. We have to build a foundation under the walls that are interior now, which are supported in a different manner than they will be after the demolition of 14. So that's why it's critical that we be able to move into that and get it done, because we'll have an exposed situation. It's
Yes.
not safe. It's just impractical to allow it, to not allow that to go forward.
Yes,
But
that's
no.
understood. Is
But
there,
I'm not-
is
We
there
understand.
a plan? Madam Chair, is there a plan to do this work, or is this going to be done after the demolition so you can see what's there?
Structural plan. Yeah. Are you asking me?
Yes, somebody who can answer that question.
Okay, the builder, the developer has developed a plan on how to underpin the foundation and provide for that while he besides the structure. So it's got to be a slam bam, we got to do it fast. And it's ready to go. And we have
Alrighty.
those plans. If you'd like
Okay.
us to submit those plans, we will.
All right, Mr. Barilak, you would like to say something?
No, Manager, my apologies. I just answered my own question.
Okay, good. All right, cool. Okay, Mr. DeAndrea, you tell us. We want to facilitate. We definitely are supportive of getting rid of blight. We want to facilitate this for you. If you provide meets and bounds and then come in and revise it, I think that's the easiest way to do it. What Mr. McRae was suggesting so nicely to you is that you give yourself some fudge room in the meets and bounds so you don't have a problem. Maybe you won't have to come in for a revision. And your decision is?
We have no choice but to follow your suggestion, and we'll get it done.
Okie dokie. Do you want to discuss the site plans themselves?
Absolutely.
Okay, so that concludes the regular meeting part of the discussion on the subdivision. And now we go to the public hearing portion, which is the site plans. And Mr. DeAndrea, if you would go ahead. Site plan singular, I should say.
Well, good afternoon. My name is Tony DeAndrea, and I am representing Byram Properties LLC, the current owner and proposed developer of a two-family home on a revised parcel, which has not yet been defined. So we're asking for approval by the commission of a proposal to do that. We're here before you because we need a special permit since the lot in its current configuration is less than 7,500 square feet. And after a conveyance of land from 14 to number 16 to render the building at 16 entirely within its property as to be configured, we will be more efficient. So at the end of the proposal as currently proposed, we would be approximately 7,426 square feet. We would be compliant with all side yards and front yard setbacks. We have provided excess parking because of the nature of the neighborhood. Parking is of a premium.
Premium, thank you.
You do know that directly across the street is a town parking lot, virtually exposed to everyone from the street, very little landscaping of any kind. So while we provided here a demonstration that we have 2 garages, we have the potential for 2 spaces on the west and east side in front of the building. We do have a certain amount of land in which we are proposing to landscape, and we'd have that plan prepared by Matt Pop, a resident of Greenwich and a neighbor of the in the neighborhood. So it's a very simple plan in that regard. We have excess parking. If you decided that's unnecessary, then one of the spaces in the front could be eliminated in favor of tandem parking in front of the garage. We happen to think that it's a better design to have 2 spaces on each side plus 1 garage, which would give us 6 parking spaces at the minimum. I think that's the appropriate way to do it in this particular location and in this neighborhood, and in consideration of the fact that there's a large town parking lot directly across the street. We have presented our plan for drainage with the DPW. There were a couple of minor comments about adjusting a couple of things to accommodate the patios in the rear. We have proposed that that be direct runoff to the surface. They want us to intercept it, we'll do so. We have permeable pavers in the front. We have a connection to an existing storm drain that runs across the front of the property. So all in all, we've met all the requirements of DPW. We have a zoning compliant plan as far as front and rear setback. We received a variance from the Board of Appeals for having a more non-conforming area of the lot after the conveyance of a certain amount of land to number 16. There are any questions? Oh, but there's one more major issue. We had previously been granted a permit to cap the sanitary sewer lateral from number 14. That was done. It was confirmed again yesterday that the lateral serving number 16 is totally independent from any of the lateral serving number 14. So therefore, we've satisfied the sewer department that we will meet all conditions that they've imposed in their preliminary review. After approval of the revision of lot lines and hopefully the site plan, we would apply for an individual sewer connection permit for the 2-family dwelling. That permit will require 2 laterals to the main, and they are shown on the development plan. Unless there are any other questions or concerns, that would conclude my presentation regarding 14 William Street.
Thank you, Mr. DeAndrea. Mr. McRae, you raised a suggestion at the briefing yesterday, if you would.
Is this concerning the rebuild?
Yes, it's considering the
Okay.
rebuild. I think you should mention it to Mr.
Okay.
DeAndrea now.
I actually, I'd like to talk to Mr. Pop real quick about the landscape plan before we get into that.
I don't know if Mr. Pop is still here, but he is.
Mr. Pop, are you still there?
I don't think Matt was intended to be to remain.
Okay, so let's not worry about
Okay.
it because I think
What's
this
the
is,
question? I'll relay it.
yeah.
Okay, there is a quite mature tree that's going to be coming down. It's actually in the middle of the parking area in the front. He's actually putting in landscaping as screening along the property line. I'd like to have him explore working with the town about street trees beyond the property line.
Sure.
And a little bit more of a good screen for the parking. And I wanted to actually, there is a tree in the back. I wanted to get some detail on that. So, Mr. DeAndrea, one of the issues I had looking at this and trying to understand what's going to happen with this building was that, okay, you're going to actually demolish one half of a building and then somehow reconstruct the open facade of the building to enclose it, so you have one full house completely sealed up.
Yes, sir.
My concern with that is that, and this is what I think I'm understanding from hearing this tonight, you really don't know what the conditions are with that situation. You'll actually do the demolition, it'll be exposed, and then you'll see what else needs to be done. My concern is that we're going to be moving ahead on this, but I would like to see that complete before anything else happens. So much to say that actually I would like to see that rebuild be done and have a CO prior to the zoning permits being submitted for the new two-family.
The attorneys have drawn up that agreement to clarify how and when and how fast that's going to be done. There's no question that it has to be done simultaneously. As soon as you take down 14, you have to start rebuilding the foundation and the siding for number 16. Mr. Fong wants to stay in his home. It's a very important part of the agreement. So we're going to make that happen. And therefore, I would ask you not to condition that on a C of O, because that could take a long time. We want to be able to do all this work simultaneously. We are working.
No, I'm talking about you're going to do the work. Number 16 would be rebuilt. But before you apply for the zoning permit for the two-family, the work on 16 is done, complete, and have a CO.
I would ask you not to do that.
Okay, so Mr. DeAndrea, all we're giving you right now, since you're going to come back anyway, Mr. McRae has kindly given you the heads up for you to consider that. What we're saying, what I believe his point is, we should make sure that everything is good with the property owner at 16 before the issuance of the permit on the work on 14. You could you could propose, for example, at a different place than from zoning permit that we do that. So I leave you with that option for right now. Just keep it in your head. We will be open to your suggestions, but he is saying to you that's what's on his mind for when you come back. And I just wanted to make sure you had heard it because he mentioned it yesterday.
Let me just explain to you why that's not.
But I would say to you, wait until you come back. Don't tell us right now. Wait till you come back, give us and tell us. Look,
Madam Chair, I'd like to hear what Mr. Diaz is about to say.
I'm trying to move on, Nick. We're leaving this
understand
open, so I'm trying to move on.
I understand that.
Just take me one more 30 seconds.
Okay, 30 seconds, go.
The foundation for the new dwelling is close in proximity to the underpinning that will need to be done at number 16. They need to be proceeding almost simultaneously. We're going to excavate to get the footing we need for number 16, and at the same time consider the foundation for number 14. We don't want to have them undermining each other. Asking you to go through the process of a C of O for number 16 and waiting to do number 14 again is an impractical imposition on the owners, not just the developer. So I would hope that in the meantime, you'll think about that while we give you a very close timeline of what has to be done to get this done safely and quickly.
Okay, all righty.
So you're leaving both applications open. Do I
Yes.
need an extension?
No, you do not. The second one, the site plan is a must open in September, but of course you're here now and we'll do everything we can to accommodate you. The first one, we would have to see it before the subdivision, the lot line revision, we'd have to see from you in June because it's a must decide on 7/7.
We'll get you a map of the proposal immediately.
Thank you.
Okay,
Thank you very much.
for your input.
Thank you, Mr. DeAndrea. Sorry to disappoint. Oh, wait, before you go, I believe you have members of the public here, and I was almost going to go. Does anybody from the public wish to speak on the two applications, the 14 and 16 William Street, as well as the 14 William Street site plan? Mr. Shahadi. Mr. Shahadi, anytime you're ready. Hello.
Yep. Good afternoon, everybody. Thank you very much for allowing me the time to speak. I'll just quickly reiterate the comments that we sent by email last night.
Thank you.
One, we are quite supportive of the subdivision. This is a complicated situation. We testified 2 weeks ago in front of the Zoning Board of Appeals, and this has been difficult for both the new owner of 16 and the existing owner of 14. So we would like to see the subdivision proceed, quickly to give both some surety. We have no comments on the new proposal. That's sort of outside of our bailiwick. And we've been following this for a while. The other piece that we'd like to throw out that was into comments is there are two portions to the blight at 16. There is clearly the blighted property, which cannot be addressed or likely will not be addressed until there's final plans and a final permit for building the new dwelling. There is what I'll call movable blight on the site. There's a dumpster, there's piles of debris, there's been various construction things over the past 3 years, and those need to be removed. And
Okay.
To hear it from the committee and not from the neighborhood might help speed up.
And what we will also do, once and if the commission has approved this application, I can guarantee you that the commission will drive by. At least a couple of commission members will be keeping an eye on this property. Yes, I took a look at it today, and I know the neighborhood is eager to move on, but you understand we just ran into a technical issue, and I apologize because I hadn't caught it, and yet I think it's just we just got to take care of it.
You have your T's to cross and your I's to dot, and I fully.
I got my
respect that.
homework to do. I got the job. We got the job that you asked us to do. Okay, Mr. Shahadi,
you.
thank you very much, and thank you for taking the time to send your comments as well. Anybody else in the public wish to speak on 14 or 16 William Street? No. All righty. With
very
that,
much.
Mr. DeAndrea.
Thank you.
Okay, so quickly, Commission, we've opened the public hearing. The 2 South Water Street property is here. I would rather go on with the public hearing right now and move them to the end, but I will defer to you, whatever people want to do.
I support your suggestion.
Okay, all right, so anybody else?
You don't want to hear them now?
Well, it's just that we're in the public hearing already. We've got Mr. Basili recording already. Everything's rolling. And we've already got Mr. Haslam here. I would say, let's just put them at the end. All right, okay. I know that's inconvenient for them, but on the other hand, I'd like to keep our record clean and not have a pause in it. Okay, so we now move on, continuing with the public hearing. We go on to number 7, which is the final site plan and special permit for Church Street. There's a whole bunch of addresses, Church Street and Sherwood Place, Putnam Court, and this is for an 830G with 192 units in it, of which 30% would be affordable. And with that, Mr. Haslam, if you would go on. Who is Tom Carmen?
He's our landscape architect, Madam Chair. I was going to
Gotcha.
introduce everybody that's on our team that is here tonight to respond to any
All right,
questions. that you
were
have.
you listening yesterday?
Yes, it was. Yeah.
Okay, so you know where the commission is. I would not bring in your team right now unless they are pertinent to the questions the commission is raising.
I'm only bringing in people tonight that you had indicated at the last hearing, and we've
Okay.
heard ever
All right.
since that you were mostly interested
Gotcha.
in sewer and
Okay.
traffic tonight, and then that kind of got a little bit expanded to fire and access as well. So
There you
the
go.
people that are presenting tonight are addressing those issues.
Okay.
And those are the members of the team that are most knowledgeable about those particular issues. And you may not want to hear from all of them, but I just wanted to
Right.
be sure that if
Okay.
they were, so
And by the way, I don't know how many people, we have about 70 people in the public right now. I don't know how many people are going to wish to speak, but just on the alert, once we get to the public comment, we will time the public comment because this is normally an application that gets a lot of interest. Mr. Lowe is the assistant timer. The commission has not found me sufficiently rigorous on cutting people off. So we now have a new assistant timer.
Be very careful what you wish for.
So Mr. Lowe has full authority to bring out the hook. All right, Mr. Haslam, go for it.
Yes, thank you, Venture. Chip Haslam for the applicant. We did listen to your briefing yesterday, and my takeaway, and I think the team's takeaway, was that there were several members of the commission that felt that we hadn't made much progress on this particular project and going through the various approval processes. I was a little taken aback by that because we feel we were making good progress, and one of my goals tonight is to bring you up to speed from our perspective of where we think we are, and hopefully you'll have the same takeaway that we do, that we're making good, steady progress here. I mean, obviously there are some big issues, but as far as the departmental comments in particular concerned, I think we haven't seen any surprises, and most of them we feel we can handle pretty easily. But in any event, with me tonight is Peter Cabrera, who's the owner's rep, Matt Ranelli, who's my co-counsel at Chittenden Goodwin, Stuart Johnson, who's an architect with Minnewaska, Chuck Olivo, who's our with Stonefield Engineering Traffic, Derek Donay and Len DeAndrea, who you know from Rocco DeAndrea, civil engineers, and Tom Carmen, who's the landscape architect. And as I said, our understanding is you want to focus on sewer, traffic, fire, and access. I just want to bring you up to speed on what we've filed since you last saw you or previously filed, so that you know that we are in fact being responsive to the departmental requests as we go along. Sewer, we just got the sewer comments last night at 5 o'clock, as you probably did as well. We'd actually met with the Commissioner of Public Works back in September of 21, Amy Siebert, at which time she indicated that there was ample capacity at Grass Island that would be able to collect whatever waste we had coming from here, but we would need to look at the lines and if they need any improvements from here to there. In November, our team met with Rich Feminella and Chris Mandris of the sewer division, and we're informed that they need to do a flow analysis, which we did. We filed this application on February 15th with the commission. We learned on March 28th that for whatever reason, sewer hadn't gotten the civil set and hadn't gotten our report on the sanitation sewer connection. We therefore filed with sewer 329, the civil set and the connection report. So they've had it since March 29th. And as we got closer to this hearing, we tried to nudge them along a bit to see if they couldn't get their analysis out and to the commission and to us so we could respond. So it's been 2 months, but we finally got it last night. There was really only one issue in that report other than the usual boilerplate that we have to look at and respond to, which is the recommendation that we install infiltration and inflow removal so that some of the effluents will actually not flow through the system as I understand it. But again, I learned this for the first time last night. Mr. DeAndrea can comment on that in a moment if need be, but we're looking at that issue and the request that they're making. With regard to traffic, we submitted a traffic impact study on February 15th. Beta sent back a memo dated April 5th in response. We responded to that memo on May 9th. And then on May 18th, we also just submitted supplemental studies, which we thought might be helpful to the commission. Weren't requested by Beta, but we thought, let's try to move this along a little bit. They included additional traffic analyses and trip generation counts, maneuverability on site, and also construction trip generation that we would expect down the road, so to speak, if this project goes forward. Beta simultaneously on May 18th filed a second memo, really just reiterating what they'd said in the first memo. And I have tonight our traffic engineer, Chuck Olivo, to discuss our response to that and possible changes that we could make if Beta needed us to further respond or make modifications. I also have Stuart Johnson with me tonight. He's the architect. He and some of the team met with Robin Sally, who's the deputy fire marshal. They had good discussions about the project. You saw the letter that issued from the fire department thereafter. There may be some issues that you want us to dig deeper on, and Stuart's here to do that as to how we could respond to some of the GFD comments. Aquarian is pretty basic. We always file with Aquarian a service demand form. I've never gotten anything back from Aquarian in 30 years. I don't think so. But I will nudge Aquarian and say, can you please respond to our demand form? And also, I understand you want something about the hydrants that are in the neighboring streets from Aquarian as well. We have ongoing discussions with Eversource about where to put our power sources. I spoke with Crystal Berry about the affordability plan. She was a little surprised that I was calling her at all. She said it really was just correcting some redundancies and where I thought a couple typos, et cetera. We talked about the amenities. We talked about that previously. We talked to the state, Mike Santoro, about amenities. That was really just a placeholder. We're told that there's certain amenities you can actually charge for, no matter whether it's 8-30G or not. That's a placeholder. When we do our final plan, we will make sure that whatever we put in that plan will be approved by the state and the law department and by Crystal Berry to be.
Hold on, Mr. Haslam. Katie would like to say, hold on, Mr. Haslam. Katie.
Yeah, I mean, this is your final plan. So I know what you're saying. Usually when it's like little nits and gnats, but it would be good to get that kind of ironed out while we still have time in the application, because this is your final plan.
Please do, Katie. I actually was about to start doing it while I was watching you tonight, because I think I can do it in about a half hour.
Perfect.
But you went faster than I thought you were going to do, but happy to do it. I think it's just tweaking it here and there. There's nothing really big there. I'm not that concerned about it.
There was a little confusion about, if you're saying building or units 1, 2, and 3 are the below market rate units, or if they travel around, either one is fine. And we've done both, but we just need to get that kind of outlined in there too. And so, yeah, I think it would be good to know what amenities you plan to charge for or not. We've had this get touchy at times. That's why we want to know what it is that's being proposed. Things like if you want to use the elevator, you pay extra. That won't fly, for example.
Right. That's fine. That's exactly what Crystal Berry said.
We had that come up then.
This creates a very bad situation with residents of the town in general, because there have been a lot of people saying, and it's not just you, Mr. Haslam, that an 830G can charge for amenities, and how far does this go? And in fact, we have separately talked to the state. Crystal has talked to the state significantly about this same issue. So I think it's excellent that you're seeking clarity and that on what amenities can be charged. Okay, go ahead, Mr. Haslam.
Oh, thank you. Yeah, we're not trying to really distinguish between one set of tenants and another. I mean, that's not our intent. As I said, it's just really a placeholder. We haven't really focused on this issue yet, but I'll get my team to focus on it. And I think the last one was really with the tree warden. And I started a three-way discussion with Katie in mid-April and with Greg Kramer. And we finally were able to meet with Greg last Friday on site. And there's about 6 trees in issue that he had written down. One was at 47 Church Street, which his department has already removed. It was dead. And then 37 Sherwood Place, which is not our property. He had 2 trees on that, and we explained that's not us, and he recognized that. And then there's 2 on Church that we could let stay. They don't really interfere at all with the project, but they're just not great trees, and they're kind of in the power lines and the telephone lines. And there's 2 on Sherwood that we would have to remove, one for our loading dock and one because an apron would probably kill it anyway. Again, not great trees. They, again, are going up into the power lines and the telephone lines. What we said to Greg on Friday is we're proposing to put in 13 trees on our property, but on the streetscape. So on both Church and Sherwood, which will be better specimen trees that will be in better condition, will not interfere with the power lines, et cetera. So we're hoping that when we go before him to seek the tree removals, that he will agree with us that we're actually improving the look of the streetscape and removing these obstacles from the power lines, et cetera, and for sight lines as well.
Can I ask, Mr. Haslam, can I just ask you a quick question?
Sure.
I believe the tree warden was indicating 6 of 7 of the 7 trees that were targeted for elimination. is what the first part of what you just said with regard to these trees, that 2 of those 6 are not on your property?
That's correct.
Okay, so we're not really talking about 6 having to do with your application. We're talking about 4?
I believe it's 4, correct. Because 1 is
Just
already
wondered.
taken down, which was on our property, adjacent to our property. 2 are on our property, that's at 37. And then we've got 2 on Church and 2 on Sherwood. So we're talking 4, that's it.
Okay, thank you.
There was another question raised at the briefing yesterday. How much have you progressed on getting those accesses?
You mean, well, we have access already. Do you mean the curb cuts?
And I also mean is it the Putnam Court one that was? Mhm.
Yeah, we actually, 6 out of our 11 properties, I know it says 5 in the staff notes, but it's 6 according to Peter Cabrera, who's done the research.
Katie's always right.
Yeah,
Start there.
have access across Putnam Court. Putnam Court has never been conveyed out of the original developer from back in the 1920s or so. There's an old case actually from Superior Court. I think it's from the 50s. I don't have it in front of me right now, which the court threw up its hands and basically said, we don't know who owns Putnam Court, but those of you who have easement rights over it basically just don't obstruct each other. And so we've used it for these 6 properties, and the Women's Exchange, of course, uses it too. We have rights to use it, easement rights, and we're going to continue to use it in that capacity. The law in the state of Connecticut is that you can actually add properties and use easements. So in other words, I can own property A, which has easement rights, and I can buy property B and also use the same easement rights. You just have to be sure that you don't over encumber the easement area to the detriment of the owner, in this case, long gone, or interfere with the use of the other easement holders, in this case, the Women's Exchange. So, but as you've said in the past, that's really a private issue between neighbors. It's not really a decision for the zoning commission. I can tell you we have access to those properties from here. In addition, we're of course taking half of our traffic and having it on Church and the other half on Sherwood and access from the 2 of them. So we will be dispersing the use over both Church and Sherwood, and it should not make for any more volume on the court.
So I thought the argument might have been that some of the parcels, there's no disagreement, have access rights over that area, but because that is being used to access other properties that aren't listed as having the right, that was in conflict, meaning unless of course you made a new easement from your parcels that do have the right to the parcels that don't have the right. Do you see where I'm going with this?
Yeah, I suppose what you could do is just make it so that basically the parking is allotted such that the people whose apartments on what were the former lots, they use that parking lot and the others use the other parking lot. But I don't think you have to go that far. As I say, I think the law is pretty clear in the state of Connecticut that you can add additional properties onto the easement. You just have to respect the ownership interests of the actual owner and the interests of the other users of the access point. But we do have a right of access.
Wouldn't they have to agree to that though? All
Right.
access holders or no?
No, as long as we're not interfering with their use.
Okay, that's not how I had understood it.
Yeah, no.
Well,
that's-
that wouldn't that mean though that I could, anyone, let's say you had an easement over someone's property to the beach or something, and you just kept adding people onto it. I mean, is that how that works then? You
Well,
see how you,
Yeah, no, not typically, because in
Right.
that situation, you are actually adding to the use of the easement area, or overburdening it, or possibly interfering with the other user. But as I said, we're distributing the traffic in a way that we don't believe we're going to be adding volume to that doesn't already exist because of the dance studio, the doctor's offices, the restaurant, et cetera, that people use that court to access. So that's where I think we're going to end up.
Okay.
All right.
All
But I
right.
think again, it's kind of, if it's an issue for the exchange, we'll have to deal with it, possibly in court. I don't know. But as far as the zoning is concerned, we have the right to use that to access. That brings up another point too, which was raised by the by Beta, which is this issue of making this road one way. I'll let Chuck get into a little bit deeper as far as the practical aspects of it, but from a legal perspective, I do think in that situation, we would have to get the exchange as the other user of the easement area to agree to make it one way. So that might be problematic. They use it as a two-way street now, and they actually park on the sidewalk and cars go in and out. My office is right across the street, so I'm able to observe it. But that might be an issue, but I'll let Chuck get into a little more detail. So that's pretty much what we've been doing. And I think, as I said, we feel pretty good, and we're happy with the comments for the most part that have come back from the various departments and from Beta, et cetera, in the sense that we think we can address them all and deal with them all as part of our plan and modify the plan as need be to deal with it too. So that's all been a positive from our perspective. But I know you've got questions. So do you want to hear from Len DeAndrea first and Derek Darnier from Rocker DeAndrea versus about the septic issues or where we are there, or would you like to hear from some other team about fire or traffic?
Let's hear from the commission. Commissioners, what are your key concerns right now? What do you feel you would like to see addressed first?
Well, the letter that just came in from Sewer Division, that's pretty significant to me. Greenwich Fire Department had some issues about access. Maybe there's some more detail on that. The one thing I didn't see any that we had asked for, but I don't see, was the shadow diagram. And it looked like engineering had some specific concerns with what's going on the site. They actually gave us 2 annotated drawings showing some things that they wanted to see specifically. So, whoever wants to step up first is fine. I think maybe talking about the Greenwich Fire Department comments would be great.
All right, Stuart, would you like to address your discussions with the fire department and where we are now with the marshal and how he might respond to some of his concerns? You have to unmute yourself, Stuart.
I just did. Can everyone hear me okay?
Yes, sir. Go right ahead.
Thank you. So as Mr. Hazelton said, we had met with Rob Natali, the fire marshal there in town, deputy fire marshal, as well as the construction subcode official, and reviewed the application prior to submitting it as a preliminary and cursory review. So we did review the project, and his report is in line with the discussion that we had. His report is correct where he states that the building as proposed is not currently classified as high-rise. I believe he cited the definition of a high-rise building per the International Building Code, the 2018 version adopted by the state of Connecticut. The 7th floor of the building is the highest occupiable level of the building. That measured to the lowest fire department emergency vehicle access point along Sherwood is approximately 74.5 feet, which is less than the 75-foot threshold. So the building is not classified as high-rise. The building as designed does fully comply with the building code, the International Building Code, the 2018 version, again, adopted by the state of Connecticut. It does comply with the local codes, and that also includes the NFPA fire protection codes. Per the recommendations or the notes that he makes, the fire detection and suppression systems, we will be, again, complying with that required by building code. So the building will be equipped throughout with a fully automated fire sprinkler system that meets the requirements in NFPA 13 sprinkler system. The building will be equipped throughout with a fully automatic fire alarm system, again, meeting the requirements of a NFPA 72 system. And the fire protection standpipes that are found within the egress stairs and elsewhere throughout the building will comply with that required by NFPA 14. Again, the building does provide the necessary means of egress, the stair towers, and life safety requirements that are required by building code and local code. I'm happy to address any specific concerns, but I believe that addresses the questions that we heard yesterday from various board members.
Mr. Johnson, what happens there? What is the code change when it becomes a high-rise building and it's at 75 feet?
That's a great question. So if the building is taller than 75 feet per the definition of a high rise, the stair towers require additional pressurization. There's pressurization of the stair towers, and there's additional mechanical and life safety mechanical systems that get added to the building. But one of the biggest things is the pressurization of the stair towers that you find typically in a high-rise building.
So we'd have additional mechanical systems added to the site.
That's correct.
To provide, okay.
The mechanical systems for the building would be improved to meet that required for a high-rise building. A building measuring taller than 75 feet.
And where is the top of that measurement? You're taking it from grade or grade plane to what point on the building?
Sure. Yeah. So I believe in Mr. Natale's letter here, he actually cites the definition. So by definition, found in the International Fire Code, the IFC, which is referenced in the International Building Code, a high-rise building is a building with an occupied floor located more than 75 feet above the lowest level of fire department vehicular access. So we have a 7-story building with a basement. The 7th floor of the building is the highest occupied floor. The building elevation shows this to be 227 feet above sea level, so that's correct. And I believe he cited here in his report that according to the grade plane map, the area measures to be approximately 152.5 feet is the lowest elevation for emergency first responder vehicles, and that's along Sherwood Place. So if we drop a dimension string between 152.5 to 227 feet above sea level to the highest occupied floor, the 7th floor, so that's the finished floor of the 7th floor, the top level of residential apartment units, we measure 74.5 feet or 74 feet 6 inches.
So you're just 6 inches below 75 feet.
That's correct.
That's a lot of latitude having there. That's
But
over
it is what
over
it is.
seven
I mean,
over
code,
7
right?
stories. Over 7 stories. That's a lot of narrow margin. Mr. Natale actually now talked about access around each one of the sides. So north side, he's indicating that there was no access whatsoever. And he's saying that the east side is relatively open, but there's utility lines and poles along that could potentially restrict the operation of the utility apparatus. And the south side has somewhat of a restriction because of the covered carriage area. I guess that carriage area, actually, it's under the building for 130 feet. That seems of a concern to me because we have people in the building. Yes, all of your code requirements are going to help out a lot, but if he needs to effect a rescue, he may not be able to. Any thoughts on actually, maybe trying to provide any kind of additional?
Sure. Well, my first thought is we met with Mr. Talley and reviewed the project. My sense was that he was generally okay and pleased with the fact that we had access on 3 sides of the building. There are many buildings in town that do not have access on multiple sides like this. There's a 7-story building across the way that has less access than this proposed building. The building as designed complies with our building code. As Mr. Natale cited in his report, it has full access on the west side and the east side along the Church Street or the Sherwood frontage. Along the south side, it has full access from Putnam Place by an apparatus. And underneath that carriageway, we have minimally 15 feet clear. So in the event that you had to get a fire truck or emergency first responder vehicle underneath that carriageway, you could. The building complies with the requirements and the life safety requirements found within the building code. It provides the necessary means of egress, the stair towers. It's a 7-story building with a basement. It's a multifamily apartment building. You egress through egress stairs. We have areas of refuge on every floor of the building. It's a fully sprinklered building. It's similar to that of a hotel or other multifamily apartment buildings. Other 6- and 7-story multifamily rental apartment buildings or condo buildings found within the downtown of Greenwich or the surrounding area or elsewhere in the nation. So it's a building that meets or exceeds, the building code and life safety requirements. I've designed and the clients have built buildings that have access on one side as infill projects. And I think having access on three sides, granted that the access on the south side, yes, there's a 132-foot length that only has a clearance of 15 feet, but there's a longer distance with direct access from Putnam Avenue.
Okay, just to kind of define something really quickly. The difference in height to the highest occupied floor level, is that the floor itself or the ceiling above that floor?
Sure, great question. So yes, that's measured to the floor as defined under the IOC and the IBC.
Okay, so actually
So
then,
it's measured to the floor level.
in a sense, I've got 74.5 to that floor level. Then I've got another 15 whatever feet of building above that. Is that correct?
That's correct.
Great, thank you. Okay, Madam Chair, I think I'm good with what I've had to say on
Okey-dokey.
this.
More questions. Mr. Wells, you just leaned forward, so I'm assuming, and Mr. Lowe raised his hand. It's tied.
Oh, who gets it? Okay.
Okay,
Peter
Mr. Wells
first
moved
and then
first.
me.
No, Mr. Wells
All right.
moved first. Go ahead,
Yeah,
Mr. Wells.
just sticking on the fire code. Thank you, Mr. Lowe. This building's a little unusual. Obviously, it's a newer one. You're going to have amenities on the roof. You're going to have gatherings there in the evening. Have you checked with the fire department to see if they would be able to evacuate people from the roof in case of a major fire below?
We did. So again, we met in person with Rob Natale, the Deputy Fire Marshal, as well as your construction subcode official. We walked through the drawings. We did a page turn, a building floor by building floor, looked at the elevations and the building heights. They were satisfied with the requisite means of egress that we were providing for the building and the life safety elements that comply with the building code. We have two means of egress, two stair towers that provide, egress and access to that rooftop in the event that there's an emergency where the first responders would have to gain access to it.
Okay, but do you know if the ladders could reach up to the roof to get people off?
We did not discuss that, but I don't recall that. But I believe the ladder height is typically about 75 feet. But again, you're not egressing. So typically in an apartment building like this, you're egressing through the stair towers.
Right.
You're not egressing through a ladder via the roof.
Okay, thank you.
Mr. Lowe.
Yeah, so two different issues. What I was going to ask, I guess, Mr. Haslam, do you know roughly how many people currently use or how many vehicles are going in and out of the access easement area today?
I doubt that'd be a question you'd have to ask of our traffic engineer from Snowfield, Chuck, who's on as well.
Uh-huh.
And I want to get to the traffic. It's the thing that I'm struggling with. So go ahead, Mr. Lowe, and let's.
And then how many people would ideally be dwelling in this new structure of 192 units? So I think we need to address that because the report claims that the current site generates more traffic during the critical evening period. And that seems somewhat of a restrictive statement anyway than the proposed development. But I'm struggling with that, how we're putting in 192 units. And I'd be curious what the actual number, what the vehicular movement is today versus what the anticipated is. With regard, Mr. McRae alluded to some comments that came in from sewer today. And I'm quoting, I think, pretty accurately here from the department. Quote, the anticipated additional peak flow would represent a significant increase over the existing peak conditions and would require a significant portion of the individual sewer pipe capacities to convey these flows. And I just wonder, do you have any comments that might provide us with any level of comfort as to this scenario?
I wanted to defer on your traffic questions. I'd like to ask Chuck to respond to the extent you can to those issues that were raised by Mr. Lowe. And then Mr. Lowe, after that, I would have Mr. DeAndrea and Mr. Donay respond because we just got that sewer letter last night. As I said, I don't claim to understand it and what the ask is. I'm told it's a pretty big ask from the sewer department of us, but I'll let them respond to that question. So first, if I could ask Chuck to address some of the traffic issues that were just raised.
Good evening, Madam Chair, members of the commission, the board professionals, as well as the public. Just for the record, my name is Charles Olivo of Stonefield Engineering and Design. We are the traffic engineer for the project. Commissioner Lowe, if I heard you correctly, you were inquiring about the amount of traffic volume on Putnam Court. Is that correct, based on our studies?
Well, I don't know that we would be confining this to Putnam Court, but I'm just saying, of the structures that are there today, do we have an estimate about the amount of traffic or vehicular movement, or however you want to measure it, versus what's anticipated with this 192 unit structure and the significant parking capacity that is attendant to it?
Understood. Yes, we do. We've conducted existing counts on now 2 occasions. We've been studying this project for about the course of a year. So we conducted an existing inventory of the access points that service the subject property. And then we conducted what we call trip generation counts of the driveways that service these various properties. That's all included within the traffic impact study that we submitted to the board. If you take a look at the existing trip generation, that's the amount of traffic traveling into and out of the site during the peak hour conditions. There's a table that looks at the net trip generation within that study. And under existing conditions, what we found is during the morning peak hour, the highest peak hour, generally from 7 a.m. to 9 a.m., we had 43 trips going in and out of the subject site driveways. During the weekday evening peak hour, we had 77 trips in and out. And during the Saturday midday peak hour, we had 84 total trips. Those are as counted, those are not projections. That's actually what we found in November and December of 2021. We then amended those counts with supplemental analysis. It's certainly in keeping with industry standards to look at 1 or 2 days. We've now conducted counts over the course of 3 different days. We've conducted observations over the course of about 5 different days. So we've really got a great amount of traffic data in terms of what's happening under existing conditions. Now, as it relates to the proposed trip generation, we are looking at a certain amount of traffic associated with each unit of the proposed inclusionary multifamily development project. So we have a 192 unit project. We look to the industry standards, the Institute of Transportation Engineers trip generation manual, as it relates to the amount of traffic that would be flowing in and out of these subject driveways should the project be constructed as we have before the commissioners this evening. What we've projected as part of the morning peak hour traffic volume traveling in and out of the site would be 59 peak hour trips during the weekday morning, 60 during the weekday evening, and 61 during the Saturday midday highest peak hour. So that you'll see
Okay,
that.
and on the existing, you're looking at the 59 proposed compares to 43 existing. Okay,
That's
so
correct.
there's an increase. Then you have weekday evening, 60 proposed, 77 existing. And finally, Saturday midday peak, you have 61 proposed and 84 existing. We said this yesterday. I don't know another way to express it. It's so counterintuitive to me. Can you just explain to me what that reflects?
I can certainly do that, Madam Chair. And I heard during the briefing the question, and it does come up a lot. What I
Thank
would
you.
suggest, and I'd leave it up to Project Council, that perhaps it may be helpful to go through the entire traffic impact study.
Yes.
I think it's going to be a bit challenging to do it piecemeal. I know Commissioner Lowe had some good questions, but I think over the course of testimony about how we prepared the study, I think we may end up addressing all of these questions and a bit more, if that's okay with with council and with the board. But again,
I'm almost thinking, and I keep wondering if we should have a standalone meeting on this, because I would like to spend time understanding the traffic. Those streets are narrow. And I just want to understand what is happening with traffic and if we have any significant issues. And you do have a lot of experience on this commission, Mr. Olivo. And to be honest, more than one of us is just trying to get our brains around. We're struggling to, a couple of people said it yesterday, struggling to get our brains around it. And we do see traffic studies all the time, but yours says something different from what I keep expecting it's going to say. Maybe we do just, maybe at some point, Katie, we go back and hone down on the individual items that are troubling the commission. The sewer question needs to be explored, and again on the traffic, because we need something more full blown and more time where we don't have 14 items to get through in the night, and to really drill down into it. Now, is there an overview that you could clarify it, sort of counterintuitive traffic conclusions?
all right, well, let me give that a shot first, and then perhaps we can discuss what would be best in terms of walking through a general overview and then really drilling down.
My question to you would be this, Mr. Olivo: what are the characteristics that you believe make up the existing traffic pattern that would change so that they are reduced, traffic is reduced in evening peak and Saturday, and yet not in morning peak?
Got it. Okay. Well, let's start with the fact that as a traffic engineer and a planner, I have to say that the town of Greenwich has an exceptional system of traffic facilities. I mean, this is the type of infrastructure, quite frankly, it's hard for me not to fall in love with it, but this is what we look for.
Oh, you'd be alone in that, so just don't go there, because I could give you like a long list of residents who think our traffic is a horrible mess.
I'd love to hear it.
You can live with us for a while.
Yeah, you can come live with us.
I would love to do that. I think as part of studying this project over the course of the last year, what you come to find is that in terms of a traffic network, it's more than just motor vehicles driving on the roads. And that's what I mean by a traffic engineer and a planner. You have some great infrastructure here, meaning that we're just a little bit less than a mile away from a great train station. I know it may not be perfect, and it sounds like there may be some people eager to tell me how it's not perfect, but you also have a great bus system. You have the 311 bus that runs along this corridor. You have a great shuttle system, and you have great walkability throughout this area in terms of the sidewalks and everything that you have interconnected in the system, as well as Greenwich Bike. So I think from an overarching, what we call a multimodal transportation system, you have it all. Some things that we could work on and improve, certainly, but this project is ideally suited to take advantage of all of that infrastructure and have the impact of reducing the need for having what we call a single occupancy vehicle. And within your plan of conservation and development, you actually talk about how the single occupancy vehicle is somewhat the enemy of great development and great design within our communities and with our downtowns. And because we have great and accessible bus, train, walking, and now fast forward to 2022, we have work from home, something as an employer, and I'm sure something as employees we've been dealing with mightily over the last couple of years, but it's changed the nature of land use and development, particularly with residential. So this type of land use, 192 inclusionary multifamily apartments in this location being so well served by different traffic facilities, makes it such an ideal project for this particular area. Now, how that relates to your question, Madam Chair. Yes.
Yeah, because now you just walked into, okay, but Mr. Olivo, your morning peak is lower, but in the evening you're higher. So these people are taking the train and the bus. We shouldn't be seeing that. So tell me, that's where I'm struggling.
Here's what's happening in the morning for a residential project. We'll start with the proposed. The majority of your traffic from 7 a.m. to 9 a.m. is leaving the site. If you think about the journey to work, most of us, some may get on the road a little bit early, the early bird before 7 a.m. But generally speaking, your peak rush hour is somewhere between 7 a.m. and 9 a.m. So with a residential project, the majority of your traffic is leaving. Now, if you look at the weekday evening from 4 p.m. to 7 p.m., we have the reverse. The majority of your traffic is coming back home, coming back to their apartments. And then on a Saturday, you have driving to sporting events, driving to retail destinations, you have more in and out traffic. It's a little bit more evenly distributed. Now, in terms of the existing uses, you have a pretty good mix here. You have single family, you have multifamily, you have medical office, you have a dance studio and spa, and then you have the townhouse restaurant. The reason that the morning peak hour is slightly more than what you see for the uses that I just mentioned when we look at the proposed versus the existing is that the restaurant as a generator is not doing any volume in those hours from 7 a.m. to 9 a.m. Generally speaking, you may have some employee traffic, you may have some service vehicles, but for the most part, the peak of those uses, the existing uses, comes later in the day. The residential, as I mentioned, you have that journey to work if you're working in an office happening via the motor vehicle leaving to exit onto some of the roadways around us. So that's the ebb and flow of the morning. In the afternoon, from 4 p.m. to 7 p.m., that changes. Now your medical office, your single family, your multifamily, the restaurant, now those uses are starting to peak and starting to see higher levels of traffic demand. And on the Saturday, during the Saturday peak hour, which is generally a 60-minute period from 11 a.m. to 2 p.m., everything is a bit active, both the existing and the proposed. You have medical office buildings that are open on the weekends, dance studio, restaurant, et cetera, have traffic moving in and out. And based on the counts that we've conducted, and also based on the projections for the 192 unit building, that's where you see the difference. Now, I imagine the part that we're struggling with is, Mr. Oliva, we have 192 units. How do you reconcile that against 4, 5, 6 different small uses that operate on the site today? How does that make sense? And the reason is because traffic generation has as much to do with the turnover of vehicles and the dwell time of those vehicles in the parking stalls as it does the size or the amount of units that you have on a project. So I'll give you an example. Across the street, Town and Country Development Project, condo project, has 2 driveways on Church Street that service, I believe we're at about 100 units on that site. And so we counted them. We counted them in the morning, the midday, and the evening peak hour, the same peaks that I just mentioned for the existing and the proposed. And in April of 2022, in the morning peak hour, the highest peak of Town and Country condos, those 100 units generated 9 vehicular trips in the morning peak hour and 9 vehicular trips in the evening peak hour based on our counts. So it has as much to do with how long the vehicles are staying in the garage. If you think about a residential parking structure, vehicles come in after work is over, they rest there throughout the course of the night, and then they may exit back onto the roadway system in the morning. So just because it's 192 units doesn't mean that it's generating 192 trips during the peak hour. Now, the reason for that is because not all of us leave in the same peak hour.
No, we know that.
Okay.
So I'm going to interrupt you for a second.
Sure.
I think you're making 2 assumptions. Just want to clarify. You're assuming that people are going to continue to work from home?
We are not assuming that.
Okay. So you are not assuming that you're assuming that everybody who's employed. Now, when you did your counts, of course, it's during the pandemic. So you don't have a fair count because there was work from home. So your current counts have all been pandemic. And from that, we can tell you, we know that there's a work from home component right now.
No doubt.
So it is very hard for you to really know what your trip generation is going to be, correct?
Well, let's
The
talk
other
about,
thing, and okay,
if
so
I may
let me-
answer that
okay,
question,
go
and
ahead.
I'll keep it short, I'll keep it concise. We do not make any changes for work from home. We do not reduce the amount of traffic based on work from home patterns. The traffic volume projections that we're using are based on real counts of multifamily projects throughout the country pre-COVID. We're not taking any reductions for that. Now, what I would also say is that the counts that we've conducted of the existing uses on this site are greatly impacted by COVID. We know this. We know that 2019, all of those uses that I just mentioned, with the exception of possibly the residential, likely saw more traffic activity. So what we do when we prepare traffic studies in 2022 is we've got to roll with the punches. We've got to work with the infrastructure that we have and where we are right now in 2022. But what we also do is we work with Connecticut DOT to understand the counts that we've conducted on the roadway system. Are those adequate now? And what we've been told by Connecticut DOT is what you counted is what we're using to design. We're not waiting for a what if things get back to normal.
No,
What if
no,
things-
well, on the roads, we're over 100%. The
Mm-hmm.
last data I saw on highway, and it was because we were working on our affordable housing plan, our roadway capacity is back over. Okay, Mr. Lowe, I do see the finger.
Okay, I just wanted to say, I go back to something you said a minute or two ago. And I'm wondering whether you're suggesting, at least in part, that this community, a portion of which is used to and can afford to do as it pleases, will now suddenly start walking more and taking public transportation. It seems to me there may be a leap of faith there that belies reality.
No, not saying that at all, Commissioner Lowe. Not saying
Okay.
that at all. What I'm suggesting is that you already do use it, that those trends will likely continue, but that we've taken no credit for additional use or more enhanced use. If you look at your census data, about 55% of those that live within the census tract commute via the single occupancy vehicle. Basically, you drive yourself alone to and from work. 45% do something else, whether it's a carpool, walk, bike, take the train, but we have certainly not taken any credit that is even remotely close to that. I think that it's hopeful and maybe as we've talked about, optimistic to say that people may do it more, but we're not counting on that. That is not included within this study. This study is a worst case scenario analysis, not taking credits for those types of things.
Mr. Yeski? Mr. Lowe, is that good?
I'm finished for now. Thank you.
Okay, Mr. Yeski.
Yeah, Madam Chair, I think you said it earlier. This is probably one of the largest projects we have ever seen in town recently.
The second
It's very
largest we've ever
large.
seen.
Yeah, it's very
Well,
large.
maybe
very
there was a
complex.
concrete, yeah.
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 And quite frankly, it's unfair to the town and unfair to the commissioners to try to go into minutia in a meeting like this. I thoroughly endorse the separate workshops here where we can get into these topics and have some lead time. Personally, on a side note, I work. To get letters on Monday morning or Tuesday just doesn't work. You need some time to absorb. And I think the traffic discussion is a good example. The fire explanation left me cold. Sorry for the pun. The sewer, wow. What I read was severe. And, I'm really not interested in hearing, oh, gee, they told us it was okay 2 years ago or something. That's not the relevant. And I'm really not interested in hearing how someone's built a building 50 years ago next door and it's okay. That's irrelevant. So I would really like to get down to the facts and suggest we do a series of workshops on these technical issues. We also talked about at one point bringing on our experts. It's some of these things get too much for.
Well, public hearings, we're going to have, we're going to have public hearings, but yes, we have, I think you're agreeing that we need to have an extra meeting that's just this.
Maybe a
Go ahead.
couple.
Yeah.
Maybe a couple.
And I think just to respond to Commissioner Yeski, I completely understand the degree of detail that we're getting into here. We've been working, I think, very diligently with Beta, your traffic consultant, to address their comments. And that's what we've been doing over the course of the last 3 to 4 months. And we now have generally a clean review letter that does talk about some of the items that we've spoken about this evening, which have to do with Putnam Court, access to bike storage for multimodal use, things like that. But we have really whittled down that letter. And I would like to think that we have an agreement or a meeting of the minds in terms of the traffic engineering related portions of this. I think what I'm trying to do this evening is speak to what Madam Chair spoke about yesterday, some of the other comments which have to do with wrapping our heads around how the trip generation works existing and proposed. But I'm happy to engage in any types of workshop sessions Madam Chair or Katie, whatever you would like, we're here and happy to work with your team.
And the other one more question on the traffic is, are you assuming that people would use, is there an assumption built in to your IT that this is proximal to public transit and therefore reduces?
We are using a 20% reduction factor on the trip generation of the residential. Now, what I will say is that the ITE because these types of projects are happening across the world, across the country, and particularly within this region. And so the ITE has done a great job of updating its information. And that updated information includes multifamily residential projects that are within half a mile of bus service and a mile of train service. And there is, as a result of studying actual built sites, there is a reduction in traffic associated with those. What we've said is, we're treating this site as if it were built in a suburban residential community with very little transit, and then we're going to take a 20% reduction.
One of the biggest struggles we have in town is to get anybody, there is a resistance. I'll just say there's a resistance to walking in many occasions. I would like to, so you're assuming there's a 20% reduction in your morning and evening peaks as a result of being near transit.
That is correct. Yes.
Okay. All right. So that helps us adjust it. But that pretty much leaves you, I'm just doing the math in my head, that would leave you with not a significant traffic increase versus your base case.
Yeah, you're absolutely right. It's right about where existing levels are. Even if you took that 20% away and you said, we're going to have a tough time making that case, conservatively, if you compared it without that, it's right there, Madam Chair.
Okay. All right.
Quick question.
Go ahead, Katie.
So what's the difference from the counts that you did of actually what was happening with respect to the restaurant and the office, et cetera, and what you would find in the ITE? Was there a big spread there?
Not a big spread. Not a big spread. It's challenging with a dance studio, for instance, Katie, to really drill down into ITE. There is no land use for a dance studio, but we can make some types of assumptions using that. Medical office is awfully close to what the projections are, but we have a whole host of information. Rather than me getting into the minutia tonight, we'd be happy to take a look at that with you if you like. But we did look at what the ITE projects versus what's there. Typically, if we can count it and we can really look at exactly what's happening in terms of these communities and neighborhoods that we're in, we like to do the real counts. But we do like to bounce it off ITE and see if it's close, and it's quite close in this case.
Okay, and I think this is probably something that we can get into when we go more in depth, but there is the obvious concern of a big development, whether it's kind of better traffic or the same traffic, whatever, but there's definitely a concern given the proximity to the one hospital in town and the need to get there usually through Sherwood or whatever, obviously there's options, but sometimes you are where you are, and it may not be on Sherwood or Church per se, but the road that actually goes to the hospital with people trying, they're all narrow, frankly. So does it make any sense, or did you study, or was it not even necessary to do so, but to look at the on-street parking scenario? I'm not suggesting that be removed by any stretch, but I do think that safety is, of course, one of the most important things. So if there's nowhere to go, how does an ambulance get around, or is there somewhere to go? Did you kind of look at that issue?
We did. We've heard a lot of comments about narrow, and driving through the network, you feel that when you're in a car. You can certainly feel the narrowness of the roadways. Church Street is about 25 feet wide, Sherwood about 28 feet wide, and then you have Putnam Court, which we've spoken about, is about 17 feet wide. Now, Sherwood and Church have parking lanes depending on which one you're on alternate sides of the road. So you're constricting the flow as a result of taking about 7 feet for the parking lane. But narrow streets are not necessarily a bad thing, depending on how much volume you have. In fact, some of your guiding principles and objectives within the plan of conservation and development talks about reducing roadway widths where you can. And Sherwood and Church are roads that carry somewhere around 2,500 vehicles on a daily basis. These are low volume roadways that are generally providing mobility for this particular neighborhood. The Post Road corridor is about 20,000 a day. It's almost 10 times as much traffic on East Putnam as you have on these side streets. So what we look at, Katie, is can the roads accommodate the volumes associated with our project without creating safety issues, significant degradation in delays, and things like that? And they can. In fact, narrow streets, sometimes called slow flow or yield flow, are used as traffic calming tools in order to slow down vehicles as they travel on the roadway system. Now, what that means—
Just to interrupt you for a sec, Mr. Olivo, there was a plan devised for the Post Road by the predecessor organization to WestCog, which was called SWRPA, the Southwestern Regional Planning Association. It proposed to the towns on the Post Road a road diet that narrowed our streets.
Yes.
It did not meet with favorable, okay? It was not well received by our residents. It got vetted by public. And why?
Yeah.
Because it did not intend to move people more quickly across the Post Road. It intended to slow people, and that was really, and to calm the traffic. And that was not well received because we have two east-west thoroughfares in the developed part of town, in the heavily developed part of town. And they are mostly congested and very slow. And we know that. So we were not receptive to the road diet. So yes, we say it in the POCD, but we are talking about a road that is not as troubled possibly as the ones immediately around that development.
Yes.
Okay, go ahead.
Yes, that's the challenge or the plight that Katie and I have sometimes is trying to make these things real, but certainly I don't think any diets are well received, whether it's a road diet or one having to do with what you eat. And part of what we found is in trying to design complete streets for walkability and for good development projects is that we have to look at right sizing the road and making sure that it can accommodate vehicular traffic, albeit perhaps, Madam Chair, a little bit frustrating for the driver that you have to pull into a gap in the parking lane and wait for somebody and oncoming traffic to come through. But what that does is it slows you down. I know it's frustrating, but it slows vehicles down, which when we think about the pedestrian vehicle interface, that's exactly what we want. Now, when we're talking about Church and Sherwood and this project, what's important that we get right as traffic engineers and planners is that the volume associated with this project can be accommodated by these streets and do so safely, and also do so in a way that's efficient.
Exactly.
And what we found in this study, and which I won't speak for Beta, but Beta has not contested any of these findings, is that the intersections continue to operate effectively. The approaches operate effectively. There are no safety concerns about having these driveways where they're located. The access management of the site is done, I would say, in a very efficient way, where you're breaking up the amount of traffic coming in and out of the garage by more evenly distributing it on an access point to Sherwood and an access point to Church as well, and then having the motor court, which is the minimally traveled type of passageway or alleyway. So in terms of, I guess, getting back to Katie's question before we dove down the road is the fact that, yes, we've studied these things and there would be no issue with safety or efficiency as a result of the driveway locations and the types of roads that we have here.
Okay. All right. Any other traffic questions right now for Mr. Olivo? Given the fact that we may want to go deeper, we've got two issues on which we want to go deeper. I'm sorry, Mr. Haslam, but I think we're going to want to have an extra meeting on this. But I think the commission needs to fully understand it's a large application for us and we really need to understand the issues. Anybody else got questions or comments?
We
Mr.
talk about
Yeske?
sewers?
Sewers, yes. If you would like to go back to sewer, please go ahead.
Okay.
Have somebody address, somebody was going, Mr. Haslam said you were going to ask somebody to address that.
Yes, Mr. Giangia and Mr. Donay, who are on the panel here.
Right. This is Leonard DeAndrea, and I will address the comments we received from the sewer department. In my opinion, it supports what we had presented to the sewer department. We certainly recognize there's a significant increase in flow from this proposed project relative to the existing conditions. He did not say that relative to the whole town of Greenwich, specific to this site. He also did mention that downstream in some circumstances. One of the pipes, one of the trunk lines may be running at 70% capacity, again, in some circumstances. And then that kind of leads into that second bullet where he looks at this project and says, okay, we recognize, one, that you're taking out 10 old leaky laterals and coming back in with 2 tight pipe laterals. So we've done our job to reduce the infiltration that typically the program wants us to do. Every new house, new additions now, quite often those laterals are replaced or repaired. What we don't understand is how they come up with this suggestion perhaps or request that we do something else for infiltration, meaning again, around our site, proximate to this site, there is no capacity problem. We know that because they didn't mention it in this summary letter here. And we brought it up in our first meeting with the sewer department where we said, do you have a capacity problem? And we are certainly willing to put in flow meters and video inspections to determine if you do have issues. No, that was clearly spelled out that that is not the issue in this case. Those immediate lines have sufficient capacity. Well, what they are asking for is to say, can this project do more for the town of Greenwich to reduce the infiltration? That is a program that Greenwich has, and they should be very proud of. Again, every project is doing something now to reduce that infiltration, but we're just not quite sure how he arrived at this number, which is a 6-fold number relative to our contribution. So we need to dig into that and find out what that exactly means. But what it's saying is it's not based on this development itself. It's based on a unit count and a contribution and say, hey, can you help us elsewhere in the town where we have an infiltration problem? So we need to dig into that. Other than that, when you flip over on the page and you go through his comments to be addressed during the sewer and building permit phase, to us, they're very standard comments. And it actually says in here, you work with us and we'll make sure those details are appropriate. So plant capacity, again, 12.5 million gallons per day. We got our initial figure of 7 million gallons a day of the current average operating from the Commissioner of Public Works. That's just been clarified that it's somewhere between 8 and 9 million gallons per day. And as a comparison, what this project would do would be over existing operating conditions, a 0.5% increase or 0.047 million gallons per day compared to 8 to 9 million gallons per day. So this memo, in my opinion, supports what we presented, that the infrastructure is available so that this development can go forward.
Mr. DeAndrea, I'm kind of think I'm reading this in a different way.
Okay, go.
He's as you stated, he's saying that there's a significant increase over existing peak conditions and would require a significant portion of the individual sewer pipe capacities to convey these proposed flows. Okay. I think what I'm seeing here is it's not your development as it connects to the street with the lateral, and it's not the plant processing, it's everything in between.
Well, no, that's not.
And
No,
that
sir, that's-
he's selling us here the downstream of the project. The flow is 70% full in some circumstances, and there's an area that sometimes surcharges. And I think what he's talking about, as I read this, is that to go ahead with this, you'll have to actually provide some kind of a removal of I&I of 146,000 gallons.
A very arbitrary number. You know, again, what is that based on? So let's take any other project. If you had a 4-bedroom house and you increase it to 8-bedroom home, we've never been asked to then go out and do something to decrease, other than the lateral itself, for infiltration. So we recognize that. We look at this, and there's only one other project we can think of, which was our firm's been working on, where this has come up. This is something new. It's certainly not written anywhere. And we have to dig into why they're doing this. But to get to your point, as he says again, the collection system downstream of this project currently flow nearly 70% full in some circumstances. And I take that to mean, because he's not very specific, that could be because of infiltration. leads to that second.
No,
excuse me.
Mr. DeAndrea, I'm sorry.
it-
Katie's been trying to get something in for several minutes. Go ahead, Katie.
Okay.
So yeah, I think what he's saying is that we all know that the town has an obligation to be able to provide infrastructure under current zoning. This is not that scenario. This is something outside of that. And so I think they're saying there is some capacity, but given now that they have the information that they asked of you, this is now beyond what they can handle and still, and so they're saying to you, under certain conditions, which are wet weather conditions, you are going to cause a problem. It's not the plant, it's the distribution lines. And so they're saying they need you to do something about it. And one of the things you can do is solve the amount of things coming from up sewer shed to create some space in the distribution line.
I would agree with that. That's exactly what I think they're driving at, is to say our plant capacity can handle it, but we have infiltration issues. And basically they're asking us to give them a little bit extra boost here. They are asking us if we can do more. And again, this is something new. So we certainly want to sit down with them and say, well, what are you talking about? And how would this be? Is it slip lining this section? So we don't know that. But again, he's not saying that the infrastructure cannot handle it. And in fact, the only thing they've mentioned here is there is a section that can run at 70%, not full capacity, but 70% capacity. And this increase is actually quite small. If you look at a circle, you look at 70%, and you add this to that, you'll find there's very little increase in that depth of flow in such a pipe. So what's more important, let me just finish with that one last thought. What's more important to us is the smaller lines around us. That would be our initial major concern. And they've confirmed with this memo that that is not a concern for this development.
Yeah, I think that the characterization of new is maybe not the best word. I would say that the analysis shows that there is something to deal with. As in any new situation, the whole idea is that the town is looking at your proposal to understand it. And these are the deficits in it. And these things need to be dealt with. It has nothing to do with being new. It has to do with what the capacities are and what are the available solutions. So that's the way I look at it. And I think that's a distinction that I want to just let you understand.
Okay, that's a great point, Mr. Levy. Thank you very much. Okay, anybody else? And Mr. DeAndrea, were you done?
I believe so.
All right. Commissioners.
So I guess, Madam Chair, the question is, just to confirm that, Mr. DeAndrea, your intention is to meet with Mr. Feminella and figure out a solution, or are you going to or understand more about what he wants? And basically, you're going to come back in with a solution within this final site plan process. Is that correct? Ideally.
I would like to probably defer to Attorney Haslam this, but yes, the first thing I want to do is to sit down and say, where are you talking and what are you talking and what would be that process? We can think of ways to do it. Is there an old line somewhere where they need to slip line it or whatever? This is relatively new, so we want to be more specific so we can present this to our clients as to what this means to the project as a whole.
Okay.
I would agree.
Further questions? I'm seeing Mr. Wells. You look like you have a question. No? Okay. Mr. Barilak leaning forward. Question? Nope. Okay. Anybody else have questions right now of the applicants?
Are we going to talk about other issues right now?
We are, the one thing we're not going to talk about the historic. Is there another topic that you want to raise?
Madam Chair, could I ask about the tree thing? I know we.
Of course, please do. Please do. I believe we have trees here. Go ahead.
We came down to the question of basically the two trees that are at issue. One was near the loading dock, and the other one was quite near there with the apron. Mr. Housen, I think you were explaining.
Yes,
so
correct.
what was, and then you mentioned that you had 13 trees that you were going to be planting on your property. So I just want to make sure I understand this. So you're saying that what actually? I'm not sure what you're saying. I'm not sure. I didn't understand the conclusion of that.
Well, as I said, we met with the tree warden last Friday, discussed this. We shared our landscape plan with him. We told him that obviously we're going through the process with the commission and that the plans are going to change, but that this is what we're proposing at the moment. And we look forward to working with him going forward and getting his advice and counsel, in fact, on what kind of specimen trees we put out on our property to mitigate the loss of these relatively small trees that are on town property at the moment, and continue to work with them. And I explained to the clients that essentially, just with the demo permits, we don't think we're there yet to apply for demo permits while we're still working with the commission on the overall plan, and we think it may be premature to go in and ask for a tree removal permit. But I sense from the town planner that you, Katie, are that's what I'm looking for. You would prefer that we go in now for a hearing with the town planner as to the removal of these trees rather than later. That's my sense that I'm getting.
No, because actually the tree warden asked us the opposite. He would rather we clarify it with you as we discuss site plan and not push it into a hearing. Katie?
Perfect.
Yeah, I think the words that you're thinking that I'm thinking are very uncomfortable. Because for two reasons. One is that you just said that you told the tree warden the plan is going to change, but at the last hearing, I thought I understood that there's zero movement allowed with your plan, that this is the plan, it's not going to change. So I think, so sorry, go ahead. You want?
No, I was just going to say, you've also suggested in your staff notes that we go to the ARC to discuss our landscape plan as well. So I wasn't talking necessarily about the footprint of the building per se.
Okay.
Although that might change. It's more the landscape plan and concept. And also, if you were to say, for instance, we think your loading dock should be 10 feet to the north rather than here for whatever reason, there's a fire hydrant there or something like that, that might cause it to change as well. But
so I think to that end, that is why I'm uncomfortable, because I think we need to know from the tree warden, can these trees stay and are they allowed to go? Because maybe it is acceptable that 13 trees replaced to 2. I don't know what the plan is, but if for whatever reason through that public process, it's found that those trees have to come down, then you will have to revise your plan. And I think it's very bad practice to be presenting a plan that requires an approval from another agency. So I think you should have the hearing, and we should figure out what the trees are, because otherwise, let's say the commission moves this plan forward and then those trees make it such that you can't have the loading dock there, you're going to be coming back to square one with us. You'd have to change the plan.
well, there's a bit of a chicken and egg situation here, no doubt about it. But we had, and I've talked to Attorney Ranelli about it too, about what point in the process do you get what permits? And he's indicated to me that the case law indicates that basically you can decide what the order of your permitting is, but that's not usually the policy of the Planning and Zoning Commission of the town of Greenwich. And I know you may want to have this put behind you. So you can either condition it and we take it's a risk to us that we get permits for the tree removals, or we go in now and we post it and we have a hearing and we explain what we want to do. I should say that within the plan sets that you have is our landscape plan too, showing these addition of these 13 trees.
Right. Well, it was.
He was certainly receptive. I mean, if you go out on the street, as he did with us, and you look at these trees, as I say, they are enmeshed in the overhead wires, and they are not that substantial, for the most part, in height or in bushiness. They're not great. So I think he was actually keen on the idea that we could replace them with something more substantial, set back from the sidewalk and the power lines, and we'd have a better streetscape. But again, I'll defer to the commission of what you want us to do in this situation.
I mean, it came up on MISA, and we had done that during that process where we said subject to, or see you later, or deal with the trees. Not a good plan. Then we came up with a policy, where we said, let's do a preliminary, then you go to tree warden, then you come back to us. So right now, we had during Albert Orlando's thing there on, what was it, 62 Mason Street, we did a drawing, and that was important because it did actually change the location of the driveway, if I recall correctly. So I think it really, the practice as of the last 5-6 years is to deal with this tree issue before you get the final approval from the commission. And it works actually a lot better for the applicant, frankly. So it's to your benefit that we've come up with this process.
Okay,
If that's the commission's, the direction they want to give us, that's the direction we'll take.
Mr. Lowe.
Yeah, I wondered, can I shift topics here?
No, let's get the answer on this. I think I would like to follow Katie's guidance.
I'm for it.
Okay. I mean, she's got the experience on what have been the process issues and with this, so I think I'd like to follow Katie's guidance on this.
I'm in support.
Okay, there you go. Now we can switch topics. Nobody
I-
seems to be dissenting. Okay.
I wondered about whether or not you all were going to provide some shadow analysis.
Good recall.
The impact on the neighboring buildings, is that something that you all have performed to date or are working on?
Yes, we're working on it. And Stuart, do you want to address that topic? Stuart Johnson, again, the architect, they're working on the shadow study.
Sure, Chip. I'd be happy to. So we heard that coming from the board, and as Mr. Haslam had noted, we are currently developing a shadow study for the proposed development to analyze the existing shadow conditions of the existing buildings on the site and surrounding properties, as well as the proposed application. And we're studying that at the fall, the fall equinox, the summer solstice, the winter solstice, spring equinox. So we'll be prepared to share that here at the next hearing.
Okay.
And Madam Chair,
Yes,
we
sir.
have new regulation related to energy, and I just wonder if
They had already filed.
Oh, okay. I back up.
I believe they had already filed. They had submitted the filing. So you're grandfathered if you've already filed before P&Z changes a regulation. If you've already filed your grandfather,
Can we provide encouragement?
we could provide encouragement. So,
For
Mr.
our
Haslam, consider
encouragement.
yourself encouraged to talk about energy efficiency, especially
We'd be
because
happy to.
it heightens your affordability. Okay.
I would also like to, I don't know if I don't think I've seen this drawing, but I'd like to see the profile of this building with the other buildings from the street. I fear that this is the wedding cake scenario that we've had in town. This is more of like a sheet cake, but
So-
the effect where you have individual detached homes, and then all of a sudden you're going to have this
And
mass, which is double the height of any other building.
it's an excellent point.
adjacent to it. So I would like to have that kind of analysis and
a-
explanation of how
that's
how
a-
they feel that they want to be a part of this community.
Madam Chair, can I weigh in on
Well,
this?
hold on. Before you go there, what I was going to say to Mr. Levy just really quickly is excellent point. It is a greatly relevant point to the fact that this is a registered National Historic District and the scale of a registered National Historic District. And we have said this to the applicant. You are right, Mr. Levy, that we talked about the profile of the building relative to the fact that that's important. Okay, go Nick, go ahead, Mr. McCray.
Mr. Johnson, your drawings on A9, A09, and A10 show some of the adjacent buildings. If you could expand those elevations out so we can get a really good sense of the streetscape in terms of relationships between the existing buildings and the proposed building. Also, when you return with the shadow study, can you indicate the shadow study inside the courtyard of the building as well? And I would like, when you return, a very detailed explanation of all of the amenity spaces. I'm seeing full kitchens, grills, 10,000 living rooms, all kinds of things. I'd like to know and completely understand what this is all about, because a good portion of this first floor is parking, but it seems like a good quarter of it is this lounge, lobby, everything else. And I'm concerned that I have two commercial size toilet facilities on the first floor in this lounge. And I'm getting a kind of a weird sense that if I'm living in this, I can have this kind of a great party downstairs with every friend I've ever known, and would have kind of an inundation of more people coming to this building than what I'm anticipating.
Yeah, and I think we just have to make sure that this is, again, we got to bring it back to the health and safety concerns that exceed and environmental concerns that exceed. Okay. Does anybody have any more questions?
I have 2 quick points. So one is, thank you,
Mr. Johnson, go ahead.
Thank you for those comments, and we'd be happy to address those at the following meeting. I will just note, the building does have to comply with the building code as well as plumbing code. So, certainly based on the occupancy, we're providing the adequate number of fixtures for both men and women on the various floors. So that's what you're seeing, but we're happy to walk through the plans. If there are specific questions in regards to the amenity layouts, again,
I think actually it's an explanation because right around that commercial, those commercial restrooms, I'm seeing, a conversing lounge, another thing that's a lounge, a pet spa. There's a lounge at a front door, all kinds of crazy stuff that I'd love to know and completely understand, all of the tables and chairs and things that I'm seeing here.
Yeah, and they're great amenities for a new inclusionary multifamily building. And again, we're happy to walk through that.
Great, thank you.
Thank you. Any more questions from the commission?
Can I just clarify, Mr. McRae, when you were talking about
Katie,
the comparison of this building to a little bit, so you can see basically what this looks like relative to the other buildings, is that what you were suggesting? Or asking
Yes,
for?
yes. The provided elevations, they're actually colored elevations on drawings A9 and 10. They do show ghosted in some of the adjacent buildings along the street. I think it's actually just taking those colored elevations and moving left and right on the elevation to show more of the buildings on the street.
And that would be effectively what the shadow analysis would show too.
Exactly.
And actually, to some degree, but actually, these would actually show a relationship between the heights of the existing buildings surrounding it and then the new building itself. But in addition, actually, some of the shadows are being cast by the elevations. So it might help a little bit too.
Okay. We good? All right. So Mr. Hassan, how about we turn for public comment?
That's fine.
And then
Madam
we'll
Chair.
come back and do the wrap up. Okay, anybody who wishes to speak on this application, this is Church Sherwood LLC. Anybody who wishes to speak, please raise your virtual hand. Mario Capola, who is representing, I believe, the neighbors, I am going to call on you first as you are an attorney, and he would not be timed. And then
there's also another attorney, Madam Chair, Andrea Siska.
I'm not seeing Miss Siska. Maybe she'll raise her hand in a minute. Okay. All right, Mr. Capola, whenever you're ready, please go ahead. Hello.
Thank you. And if Attorney Siska is here, if you'd like to have her start first, because I know that one of our experts that we have here with us this evening, Steve Trinkus, had another meeting that he was trying to bounce in between this one and that one. So if she's here, she could maybe work better if she could go first, just because of his schedule. Otherwise, I could get started.
There she is. I got her. Let me see. She's in twice. Attorney Siska, would you raise the hand of the computer with which you wish to participate? All righty, here she goes. All right, so we will first turn, for the benefit of our court reporter, we are not calling on Mario Capola first. We are calling on Attorney Siska first. It's Andrea Siska, S-I-S-C-A, but you can see that, sir. All right, ma'am, please go ahead.
Good evening, Madam Chair and Commissioners. Thank you for the opportunity to speak tonight. My comments are very brief. I represent Sherwood Green Condominium Association. We would just echo the request for the shadow analysis. And also in reviewing the fire department comments, we are actually quite concerned about the lack of access on the north side of the building, given that our property is right up against, or the proposed building is going to be right up against the property line that is adjacent to our building. So that is actually a particular concern to my clients. And by my calculation, I believe there are about 70 units on the north side and interior to the north side. So meaning units that would be accessed from the north side of the building in the event of a fire where the fire suppression system was not sufficient. So that is of concern to us, and I'd like to understand, I think, better how that would be addressed in the event that the fire suppression system was not sufficient. And then the shadow analysis we look forward to receiving from Mr. Haslin prior to the next meeting. We'll reserve comment on that.
Great.
Thank
Okay.
you.
Thank you very much, ma'am. Mr. Capola, if you would go ahead.
Thank you very much. For the record, Mario Capola, sorry, I'm just getting my earpiece back in.
Somebody
For the record, Mario Capola, I'm a partner at the law firm of Bircham Moses with offices in Westport and Milford, Connecticut. I represent Town and Country Condominium Association. I also represent 4 individual SEPA interveners who filed intervention pleadings pursuant to Connecticut General Statute 22A19. Those individuals are Francine Gingras, Michael Santangelo, Barbara Muller, and John Romano. As you may remember, we filed individual verified pleadings to intervene along with a letter in opposition to the project prior to the Commission's first public hearing on April 12th. I understand that you're not going to be addressing the historic preservation issues this evening. We look forward to providing comment regarding those issues at your next meeting. Tonight we'll focus on the more technical aspects of the applicant's proposed development, namely the engineering and associated infrastructure. So I have with me this evening Steve Trinkus, a professional engineer who has provided the Commission with a report approximately a month ago, dated April 11th, 2022. You've hopefully had an opportunity to review his report. He has an impressive resume of professional credentials, especially in the area of stormwater management and drainage. He's a very qualified professional engineer to opine on the issues of concern that have been raised in his report regarding this project. At this time, I'd like to ask Mr. Trinkus to provide a brief presentation to the Commission and also to answer any questions that you may have, Madam Chairwoman, if that's okay.
Of course. All right,
Thank
go
you.
ahead.
Good evening again, Steve Trinkus.
Hello, Mr.
I'm a
Trinkus.
good evening again. I'm a licensed professional engineer with an office at 114 Hunters Ridge Road in Salisbury. I reviewed all of the submitted information with a focus on the site plans, the stormwater management report, the various documents required by the Town of Greenwich Stormwater Manual. There were many attachments with that. It basically there, and I know I also spoke with Scott Marucci, your town engineer, and I know Scott has provided a marked up plan. Many of the LID practices, primarily the permeable paver systems, there were absolutely no test holes or infiltration tests done in these areas. So the claims that were in the report that all this water is going to infiltrate, you're going to have reductions in runoff volume, are not supported by technical data. Also, as this is a developed site, the applicant is considering it a Class B soil, which is a moderately well-drained soil type. However, with all this development, these are more what we call eudorphan soils because they have been disturbed by the prior development, and they may not likely be anywhere close to a Class B soil, which is a pretty well-drained material. These could have a lot of restrictive layers due to compaction. You could have fill in these areas. And without test pit data, you have no idea what you're really dealing with on these permeable paver systems. The larger system that is on the southern side of the site, kind of opposite the main entrance to the building, there were a couple test holes there, but you had bedrock in one, and there was only one test pit, like at one end of a very large gallery system having dug thousands of test holes in my 40 years of practice, the dirt can change tremendously. And you need to have generally 4 deep test pits, on roughly the 4 corners, to get a representative idea of the soils, particularly in an urban environment. One test hole does not adequately define what the soils are. The other aspect of stormwater management is the building has both underground and underbuilding parking. Per memo from Connecticut DEP, which goes back to about 1988, but just 2 years ago, they confirmed that this is their policy. Runoff from underbuilding parking has to go through a hydrodynamic separator and then be discharged to the sanitary sewer system. You also have to have provisions, under the building for the water to get to a drainage system. You can't have a level basement floor because the water is just going to sit literally on the floor. So your underbuilding parking areas basically have to be graded to low points where you can collect.
Mr. Trinkaus, I'm sorry. Something you said threw me.
Okay.
We don't allow stormwater to go into our sewer system, into our sewage system. That's not what you meant, right? You meant into the storm
Well,
sewers.
actually, it's not what I mean. It's a policy of Connecticut DEP. So then,
right.
if that's your case, then I think there is a major conflict. But in any event, if it can't go to your sanitary sewer system,
it does not go. Stormwater in Greenwich does not
provisions.
go to sanitary sewer.
Okay.
Wait, actually, Mr. Trinkus, before you move on, this is a state code that says vehicular car garage is filtered and then is dumped into the sanitary sewer system. That's the Connecticut code?
That it's a memo from Connecticut DEP. Yes. I ran into this on a project in Westport where we had a similar situation of basically two layers of underbuilding parking. One was more underground and the other was simply under the first floor, which is the case here. And they required us to literally grade the basement levels to catch basins, to a separator, and then discharge the Westport sanitary sewer system. But if you cannot discharge to the sanitary sewer system in the town of Greenwich, you still need provisions to address water quality of that runoff, because cars are going to go in there with rain on them, snow is going to melt. You are going to have pollutants in that runoff, and that water has to go somewhere. It can't sit in your basement level, and it's got to be treated because it's going to have dirty stuff in it, primarily metals and hydrocarbons from the vehicles themselves. Regarding the potential conflict with DEP, I would perhaps maybe if I can find the memo, I'll be happy to share it with Katie. As far as that goes.
Yes,
it's
share
in
it
the
with.
policy.
Yes, Mr. Trinkaus, share it with town staff, because we will have to discuss it with the sewer department, because I think most homes in Greenwich have actually been inspected to ensure that stormwater is not going into the sanitary sewer. I've heard about it many times.
That's correct, but I'm just wondering, as a commercial garage,
we gotta see. Yep, we gotta see the letter, because
Yeah,
I'm
correct.
getting that there could be a fine point here from DEP.
Well, I think,
and-
if DEP says it's got to be done and
It's gotta
and
be done,
DPW
right.
No, and DPW says, yes, they're right. And this actually adds more to that I&I issue that we just talked about
Yes, sir.
significantly.
Go ahead, Mr. Trinkaus.
Madam Chair, you're right. DEP, or actually municipalities, don't want roof drains or footing drains going to sanitary sewer. This is specifically underground parking facilities.
Yes, I
That's
got
what
it.
the
We got
memo
that.
is
We
about.
grasped
So
that, sir.
I just want to, clarify
Yep,
that.
we did grasp it.
Now, the large stormwater system that is south of the building entrance really has three components. There's an underground gallery system. You have a permeable paver system that has a gravel base, and you also have a layer of gravel under it as a retention system. The gravel, based on the plans, is basically intersecting and connecting with all of these systems. So this entire system has to be evaluated as one stormwater management practice. The applicant just seems to be looking at the underground gallery system, but when you have crushed stone, the water is going to go into the gallery and it's just going to follow the crushed stone. The other issue is their outlet control structure, which is typically put after the gallery system. So water goes into the gallery system. You have a control structure that meters the flow out to reduce your peak rate. And you have basically the storage above it. They have the structure upstream of the detention system. And I've done this for 40 years. I have never seen a system like this. And basically the problem is they're assuming that the water that goes into the underground gallery systems is going to completely infiltrate. So therefore it's going to go into the gallery system, it's going to infiltrate, and that's it. And that's an erroneous assumption because there's no evidence to support it. And if that system doesn't infiltrate, it's always full of water. And when you have another storm event, there's no room for it. And now it's being discharged off site as far as that goes. There's a couple catch basins in the end of this parking area that are have 24-inch deep sumps. Those systems are only credited for about a 5% removal of total suspended solids. I believe the applicant used a higher value. Even a 48-inch deep sump, which is more common, is only 9%. So a lot less than what the applicant has submitted. So you're not going to meet the TSS removal rates as required by your manual. In addition, in addition to TSS, which is basically fine silts and sands, there's other pollutants in automobile runoff, primarily metals and hydrocarbons. They come both in particulate and soluble forms. And while the particulate parts of hydrocarbons and metals will bind to fine silts and clays, so if you trap those particles, you're trapping them. They also come in a soluble form, and they're not trapped. They're not trapped in a hydrodynamic separator. They're not trapped, in a surface system, and they're going to be discharged as far as that goes.
Yeah.
The applicant's proposing a couple areas of green roof. There is absolutely no information on the green roof system. There's no detail of it. They make a claim that that's going to reduce runoff volume. Green roofs only reduce volume by evapotranspiration from the plants. And when you have high humidity, and I'd go back to last weekend as a textbook example, you're not getting any ET as it's known because the water vapor content is already very high, and you can't, water vapor will not go up if it's very humid to start with. But there's absolutely no details on the green roof, but yet there are claims of volume reduction. So that's an unsupported claim. Because of the existing development, the theoretical increase is only about 5,000 square feet, but it is a common practice, especially with dealing with low impact development, that you treat all of the runoff completely to improve the situation over what exists, and that's not being done here. This is not really a lid plan in my professional opinion as an expert in lid, because it's a reliance on structural practices. You have the deep sump catch basins, you have the permeable paver systems with just layers of gravel. There is no filter course, so there's no water quality benefit to that. There are assumptions that it's going to infiltrate, which is not the case. And there's really no green lid practices being proposed on this site. And having evaluated your manual back actually before it was adopted for Katie's predecessor, Diane Fox, you're not getting lid on this project. This is conventional stormwater management, and it's not reducing runoff volumes, which is going to be conveyed to your town system, and similar to your sanitary sewer system, can overwhelm that system because of the volume. This is a lot of directly connected impervious cover. It's almost wall-to-wall property lines of pavement or roof. And you're going to have a lot of volume. You're going to also have a lot of pollutant loads that are going to be discharged to the site. So again, I think in Mr. Marucci's comments, he addressed some of the ones I also had, that there was information in the report citing other types of Cultec systems, which actually were not present on the plan at all. So likely a typo. In many cases on the erosion control side of the plans, you've got silt fence that is running perpendicular to contours. Well, silt fence always goes parallel to contours. If you run it perpendicular to contours, it provides basically a plane for the water to run along, and then it will overwhelm the erosion control measure at the bottom of the slope. Staked hay bales, while they're shown around catch basins, are one of the most inefficient erosion control barriers out there. They do not stop dirty water from getting into catch basins, especially during the construction period. So other alternatives need to be considered. Based on the plans, approximately 22,000 yards of material is going to be taken off this site. It's 17 yards of dump truck. That's roughly 1,500 dump truck trips. You know, what's the impact of those trips on the road? When are they going to occur? How is that going to affect traffic patterns, you know, on the adjacent roadways? That's a lot of dirt to take off of the site, as far as that goes. I found the construction narrative is very simplistic. For a project of this magnitude, you really need a much more detailed phasing plan. There is a tremendous amount of moving parts to this project, and the narrative is very oversimplistic for a project of this magnitude. But primarily my concern is that stormwater management system is not adequate. It will result in increased runoff volumes and pollutant loads being discharged to the town system, which goes contrary to your MS4 permit.
Okay. All right. Thank you very much, Mr. Trinkhouse. Mr. Capola, do you want to add anything?
I would, Madam Chairwoman, I'd like to ask Mr. Trinkhouse a few questions, and I also don't know if anyone on the commission has any questions of him as well. So I guess I could get started, and then if anyone on the commission has a question, I'd encourage them to ask him as well while he's here this evening to testify before you. Mr. Trinkhouse, just to summarize in layman's terms, you certainly addressed a lot of issues fairly quickly, and we appreciate you moving fast because it's a long night for everyone. But I just want to make sure that we understand what the salient points are from your review and analysis. So, in layman's terms, do you believe that the stormwater management system, as proposed by the applicant, will function as designed?
No, I do not.
And why is that?
Because of the lack of soil test data and the hydrologic modeling, which is required to prove that infiltration practices will actually do what they're intended to do by putting water back into the ground.
So essentially, is it your opinion that that the applicant's professionals have made assumptions that aren't supported regarding the ability of the water to infiltrate on site?
Yes.
Okay, so Mr. Trinkhouse, what I would ask you, and thank you for all the detail, and thank you for submitting the written. What you were just asked by Mr. Capola, our mandate, as you know, the burden of proof is on the municipality. This is an 830G application, you know that. What we have to determine is if there is an issue that exceeds the municipality's, quote, need for affordable housing in its importance. If you would follow up to the full report you gave us, and Mr. Capola could do the same thing, one of you, that's what we need to know. What are the consequences? Exactly the way Mr. Capola just shaped the question. What are the consequences environmentally? What happens? Why do you think that this drainage plan is a failure? And in what way does that represent for the town of Greenwich an issue that exceeds our need for affordable housing? Mr. Capola knows how that needs to be phrased. But if it's just hey, they're not doing low impact development, that's really not mandated by our drainage manual, as you well know, Mr. Trinkhouse, because I know you're very experienced. That's not mandated. We have a few different ways that the drainage manual can be met. More or less low impact is sometimes to the option of the applicant. Tell us where the major environmental, health and safety issues would stand vis-a-vis this application. And with that, Mr. Capola, I go back to you. You asked the clarifying question. I would say to you if you could further hone that in for us. And may I turn to the rest of the public comment now, or do you have more to add?
I have just a little bit more to add. And I actually had just along the lines of what you were asking, just a couple more quick questions of Mr. Trinkhouse, although it looks like we may have lost him.
No, I'm still here.
Okay, so Mr.
Okay, I just don't see him.
So Mr. Capola, how much longer do you expect to take?
I have a total of 15 minutes, 10 to 15 minutes. I'll try.
Okay,
to
well,
go as
you've
fast as
already
possible.
gone way longer than 15 minutes. I don't know what clock you're using.
No, I said from this point on, Madam Chairwoman, in our presentation, and from this point on, 10 to 15 minutes. And I would just respectfully point out that, again, we have party status in the application.
No, I recognize
so-
that, but okay.
I understand it's a long night, and
No,
so I
no,
will, I will endeavor to go as fast as possible.
Yes,
Um,
and
just a
yes, thank you.
couple quick follow-ups. So getting at the point that the,
Excuse me,
Yes.
Tom talking here.
Yes, Mr. Basili, please, of course.
We're getting on 4 hours. I don't like hearing. I want to go as quickly as I can. So just go so that
Talk.
it gets.
Thank you, sir. Yes.
Understood, sir. I'm used to being on the record, so I certainly will understand, appreciate that concern.
All right, thank you.
Along the lines of the point that the chairwoman was making, Mr. Trinkus, as a result of your analysis, what will be the increased runoff into the municipal, I'm sorry, as a result of your analysis, do you believe there will be increased runoff into the municipal stormwater system and the from this project?
Yes, I do, because the rate of runoff is not a concern. It's the volume of runoff that is a concern. And without evidence that water is actually going to infiltrate on this site, you will have increased volumes being discharged to the town of Greenwich system.
In addition to runoff into the municipal stormwater system, do you believe that there will be runoff from this project into the down gradient water courses?
Ultimately, if that's where the drainage systems go, yes.
And do you believe that there will be harm to the environment by increased runoff into the municipal stormwater system?
There's the harm to the environment is twofold. Increased runoff volumes can cause stream channel erosion, which destroys the native habitat along streams. Increased pollutant loads, particularly metals and hydrocarbons, are toxic at very low levels to the benthic organisms that live in the bottom of native stream channels. So there is an environmental impact from both water quality and runoff volume.
And would the harm be into just the municipal stormwater system, or also potentially into down gradient water courses?
The harm would be when it goes into the down gradient water courses, because the town system is generally contained within pipes. But when it's discharged to a wetland or water course is where those impacts would occur.
I'd like to have that recap in writing.
I'll be happy to do that, Madam Chair.
Okay, I think that would be important to have for the record. Go ahead, Mr. Capola.
Just follow up on an important point you made. Did you state that there would be a discharge of certain pollutants into the stormwater system or the down gradient water courses?
There will be increased pollutant loads discharged because the treatment systems proposed by the applicant are not going to reduce the metals and hydrocarbons to a level that is necessary not to have an environmental impact.
And what type of pollutants do you anticipate will be going into the receiving municipal system and down gradient waterways?
You would have what's called total suspended solids, or TSS, which is basically fine silt and clay particles from, organic debris being decomposed like leaves over the parking lot, sand from winter operations. With a site like this, you're not going to have really nutrients because you have very little green space around, but you will have metals and hydrocarbons from the movement of cars in and out of the site.
And do you believe that the discharge of these pollutants will have a negative effect on the environment?
Yes, they do.
And do you think that effect on the environment from the discharge of these pollutants into the receiving municipal system and/or down gradient waterways will have a significant effect on the environment?
It will over time. Pollutants, particularly metals and hydrocarbons, can what we call bioaccumulate in the environment, so the impact can become worse over time.
And my last question for you. Do you think there's modifications that could reasonably be made to the project that would resolve these issues that you've raised to date?
I believe they can, but it would likely change the development program the applicant desires.
What does that mean?
Possibly reducing the size of the building to provide additional room for stormwater treatment.
Okay. So is it your position that some of these issues could be resolved, but that in order to do so, more than likely the size of the proposed building will have to be reduced?
Yes.
And why is that? If you could just tell us briefly.
There's very little surface area that is non-built roof area on the site. So there's very limited room to provide additional stormwater management practices that would reduce particularly the metals and hydrocarbons found in the runoff.
Thank you very much, Mr. Trinkus. Madam Chairwoman, does anybody else in the commission have any questions of Mr. Trinkus at this time?
I do not, thank you.
Everybody's good?
Maybe to add maybe even more color to the idea of these pollutants. The state has standards on pollutants. Could you give us some idea of how this would, if these pollutants are go into the environment, what is the what does it affect? I guess there's the watershed. There's other things too. The state has ways of has standards, and there's a brownfield program. If you have an environmental 2 report that shows that you have some kind of contamination above a certain point. Could you go into that just a little bit in view of this particular project?
Yes, I can, Commissioner Levy. I mean, the major pollutants, as I said, really are, fine sediments and metals and hydrocarbons from the cars. Hydrocarbons is the occasional little drip of oil that basically all of our cars probably have on an irregular basis, but on a paved surface, when it rains, it washes off. Metals are pretty much from our brake pads. I'm sure we all wash our cars and our rims are covered in a black dust. That's basically zinc. Metals in the environment can be toxic to the aquatic organisms that are the bottom of the food chain that you find in native receiving streams, the benthic organisms. These are the little bugs that live in the gravel at the bottom of the channel. And over time, metal concentrations in runoff and the streams will build up and begin to affect, slightly higher on the food chain, but they also bioaccumulate in the species themselves. So similar to the issues that we had years ago with tuna and mercury, smaller fish, had, ate stuff that had mercury in it, and the larger fish did, and that the concentrations actually gets higher as you go up the food chain. But basically, the discharge of hydrocarbons and metals will affect the bottom of the food chain in your receiving streams. And once it gets in there, it's virtually impossible to get it out. And it builds up over time. So what you want to do is prevent it from getting in there in the first place.
One final question. Aren't we really talking about drainage and rivers, but it all ends up in Long Island Sound, right? So we're really talking about the impact on Long Island Sound.
Well, ultimately, yes, Mr. Wells, you are, but it's also the freshwater systems that are conveying the runoff, right, from the developed areas of Greenwich to the Sound. But yeah, the Sound is the ultimate receiving body.
Thank you.
Okay. Mr. Yeski.
Yeah, I understand we're going to get a transcript of this, but is it the intent of the folks testifying to do this in some kind of a consulting report? I mean, a little random here by coming in. Are you folks looking to submit some kind of a formal report based on credentials, the whole 9 yards, dealing with all these very interesting, impressive, complex issues, or is it just verbal testimony?
If I may, Mr. Commissioner Yeski, there was a report that was submitted over a month ago by Mr. Trinkus, which includes his professional credentials and his analysis of the project at that time. So that was submitted to the commission about a month and a half ago. Per the chairwoman's request, we could request that Mr. Trinkus provide an updated report as more information and testimony has been provided by the applicant.
Yeah, and
Well,
that
and very focused on 830G. Go ahead, Mr. Yeski.
no, because I think there has been significant new developments, particularly as it starts when you start dealing with the storm system, sewers, all of which tie back to his basic testimony that all this stuff ends up in this in our either storm sewer or sanitary sewer system. And as that comes out and the town decides what's a problem, that's going to try not to use puns here, but it's going to back up. And his testimony in the report seems to be get more highlighted, more interesting, in that that as these projects get more analyzed and complications arise, you go back into all these other reports and say, wow, they probably need updated. So just a thought.
Okay.
Well, thank you, and we'll endeavor to do so. And that last comment regarding the sewer just segues to another issue, if I could just briefly address, which is the sewer infrastructure. We did review the staff report from DPW that came in recently, and just two comments that concerned us. One, from the report, the proposed development would represent a significant increase over the existing peak conditions. It goes on to say portions of the collection system downstream of the project currently flow nearly 70% full in some circumstances. And there is an area that sometimes does surcharge. Another comment in the report was that the DPW has taken a position that the applicant would be required to remove approximately 146 gallons per day of extraneous flow. So far as what we've seen, the applicant has not presented any plan for removing the amount of extraneous flow that is being recommended by DPW. And I just think it's important for the commission to keep in mind that, and you may want to ask questions to your DPW staff about, what does this mean, this recommendation you're making? How could it be addressed by the applicant? What would happen? What would the applicant have to do to resolve this issue of concern? My assumption is that any removal of that amount of extraneous flow is going to require significant down gradient improvements to the sewer line, and those significant improvements will require a slew of approvals from DPW and other town boards and commissions. I respectfully request that the commission discuss that issue further with your representatives, staff in the DPW department. Simply stated, from our perspective at this point, based on what we reviewed from your own staff report from DPW, the current proposal does not adequately address the concerns raised by DPW regarding the sewer infrastructure. With regard to traffic safety, I just wanted to point out that there was testimony at your first public hearing from people who live in the area. You may have additional testimony this evening, and that I understand there's a professional traffic engineer who's providing his analysis, but respectfully ask that you do take into account the testimony that you get from people who live in the area about the current conditions, the current traffic conditions that are there. And I would just point out, as you know, there's narrow roads, and you have intersections already operating at undesirable levels of service. It's a level E service, which is the second worst possible level of service currently. Lastly, the applicant has addressed the issue of the use of Putnam Place. And I would just point out that the law in Connecticut by our Supreme Court in the cases Abington Limited Partnership versus Heublian, Heublein, and that's 257 Con 570. It's a 2001 case. And it provides that under no circumstances could an easement be construed to encompass after acquired property that if the result would be a material increase in the use of the subservient property. And from what we see, I respectfully disagree with the applicant's counsel. It appears that the proposed development would constitute an overburdening of that other parcel. So I guess that's an issue for the Women's Exchange, which is a underfunded nonprofit, to somehow try to address with legal counsel. But I don't think, I think it is an issue. And if the Women's Exchange retains professionals to assist it with that issue, I think that it's going to be fairly clear that, in fact, the proposal, the applicant's proposal now would violate the deed restriction, or sorry, I'm sorry, would violate the easement that exists over that property. Thank you very much for your time.
Can you
and
send us,
consideration.
can you make sure we have the case reference? I don't remember seeing it.
Yeah, we have not presented it before. I don't represent the Women's Exchange, but I'm more than happy.
No, you
to-
just,
I'm
I'd
more
be
than happy
curious.
to. Yeah, I'm more
just
than
send
happy
Katie
to.
the case reference.
That's
Just
right,
be
I'm more than
curious.
happy to send a follow-up letter as to that issue.
All right.
If it's
Okay.
helpful to the commission.
Okay.
Madam Chair, if I may just briefly.
Yes, Mr. Haslam.
Thank you. In the interest of time, this evening, the fact that I, for one, haven't seen this report that was supposedly filed a month ago with P&Z. I don't know if anyone on my team has, but we'll need time to obviously look at it, read it, and respond. And so we reserve the right to do that, either in writing or with oral testimony or both. I'd ask too that of Mr. Capolo, now that he's representing interveners, I have sent to him the supplemental materials that we filed since he came in with the interveners. And I would ask that he provide information to us in the same form or fashion. I think that is the correct way of handling interveners, and they're handling us. So I'd please ask him to share information with us that he files with the commission.
Mr. Capolo, would you be agreeable to share the information?
Of course. And by the way, the letter that we submitted a letter into the record on April 11th, 2022. It was a substantial letter, and attached to it was the intervention pleadings and also the report from Mr. Trinkus. I was away on vacation with my family the evening of that of the April hearing, but my colleague Matt Studer addressed the commission and made reference to the report that was submitted into the record at that time. But of course, anything that we proceed with filing into the record as we've gained intervener status, we'll of course send a copy to the applicant. We have not submitted anything since that date, so and we certainly would plan to submit a copy to the applicant electronically of whatever we put into the record.
Thank you. And lastly, Madam Chair, I would just ask to reserve my right to cross-examine Mr. Trinkus too at another date if need be. Otherwise, that's all I have to say.
We don't normally do that.
I'm just reserving the right, and I think the committee law supports that, but I'm just reserving it. We can make up a decision at the time.
We don't normally have the applicant challenge the witnesses, the expert testimony.
It's more, Madam Chair, that if one puts something onto the record, that Mr. Haslam wants an opportunity to speak to that, counter it.
Okie dokie.
Exactly.
Of course. Yes, that's different. The way you said it, it sounded a little different. Okie dokie.
Thank you.
Okay.
I'd also just for the record point, I do agree that with counsel that he does have the right to cross-examine a witness that would present testimony, especially an expert witness that would present testimony, since this is a record appeal and the only opportunity to do so is at this point. Once we get into a court appeal, the record's closed, obviously. So I agree with his position if Mr. Trinkus comes back to testify again as well.
Thank you. One of the things that Madam Chair is responding to is that we don't regard ourselves as legal judges, and cross-examination is typically not
That was the point.
a phrase that's used.
I was being nice. Okay. All righty.
Ask
Okay.
questions of the expert, Mr. Lowe.
Yeah, you just want to, what you want to do is have different statements. Okie dokie. You want to present your own expert testimony. Okay. Mr. Capola, anything else? And Mr. Haslam, you were going to make a third point that you got cut off on.
No, that was it, I believe.
Okay, you were in the middle of saying a third thing, but if it comes back to you, we're here.
Okay,
All
thank
right.
you.
Okay, Commission, I got a question to ask you. So we've heard from opposing counsel and proponent counsel, and now we have 5 people from the public with their hands up. I don't know if we have more people coming. So my question to you is, do you want to break now? We're an hour and 5 minutes overdue from our break, or do you want to finish this application now?
Finishes.
Yeah, finish this.
Yeah.
All right, okay. Just warning you that the chair is hungry. All righty, we're going to go on with public comment. Our first speaker is Mr. Stern. And is my clock ready?
All right, well, that was my question to you. I didn't want to interrupt you.
3 minutes.
Okay.
3
Go for it.
minutes. Patrick, you and I are going to move people in and out, and Mr. Lowe is going to have the hook. And again, I'm just letting everybody in the public know that it's just to make sure we're consistent on the timer. All right, here we go, Mr. Stern. It's a pleasure. And he's on his way in. And following Mr. Stern and Ms. Gingras, I'm going to bring you in already, is Francine Gingras.
Yeah. So yes, so thank you very much for the.
Hello.
Can you hear me?
Yes, we can. Okay, go ahead, sir. You may start now.
Thank you very much for the opportunity to speak, and I really greatly appreciate the thoughtfulness of all the commissioners, and also I very much appreciate your sense of humor, Madam Chair.
They say it's Mr. Lowe who's funny. Go ahead, Mr. Stern.
So I'm a psychiatrist. I live on Church Street, and my office is in Mount. And I specialize in depression and anxiety and their relationship to physical illness, having worked closely with internal medicine physicians for many years. And just in a nutshell, I think that the proposed development would have an adverse effect on the quality of life of the residents of this area. Specifically, there's going to be a marked increase, I think, in noise from the construction and also from the building. There are going to be all kinds of events like on the roof. There's going to be pickleball on the roof. Pickleball courts are very noisy. And increased anxiety does have an adverse effect on mental health, of course, but also on physical health. It increases the risk of like heart attack and stroke. And then I'm really glad that you're going to be getting a shadow analysis, because there is, very, very good evidence that shadows and darkness tend to increase depression. And depression itself, we know mental health is extremely important, but depression also has an adverse effect on physical health. And there has been a marked increase in depression and anxiety in Greenwich and Connecticut and around the world because of the pandemic. And I'm very concerned that the proposed development would further exacerbate that problem. So thank you very much.
Thank you, sir. Ms. Gingras, if you would go ahead and unmute, and the next speaker after that is going to be Sam Romeo, and I will bring you in now.
All right. Thank you very much, Madam Chair, Commissioners, and Katie, for giving us the opportunity to speak as this process evolves. My name is Francine Gingras, and I'm a resident and a representative of the Town and Country. It's a 100-unit condominium. We have over 200 residents who live directly across the street from such development. I'd like to focus on 2 areas this evening that will have direct impact, not only on our residents, but in the neighborhood residents. The removal of our sunshine and the increased risk caused by construction and additional traffic on our streets. The architects back on April 12th made it very clear that they were protecting sunshine for their residents. And I'd like to state that it is equally important, that sunshine is equally important for those of us who live around the building. We need to be considered in this plan as it evolves. It's not just about the developer's building, it's about the people and the community who surround this building. The Connecticut Environmental Protection Act, or SEPA, and I quote, Section 22A15, Declaration of Policy, it is hereby found and declared that there is a public trust in the air, water, and other natural resources of the state of Connecticut that each person is entitled to the protection, preservation, and enhancement of the same. It is further found and declared that it is in the public interest to provide all persons, not just the people in that building, but all persons in this neighborhood, with an adequate remedy to protect the air, water, and other natural resources from unreasonable pollution, impairment, or destruction. Sunlight is considered a natural resource. The revised architectural plan, which extends the developer's building with the archway and the additional 7 floors, will now remove morning sunshine from the 24 units that face the proposed building on Church Street and directly affect 47 people on this side of the building. Our northeast section of the building will be dark in the morning, as will all of the other homes on our side of the street. As the sun rotates, other parts of the neighborhood will also lose this natural resource. This will affect the lives of hundreds of neighborhood and residents. As Dr. Stern, who just spoke, science is on our side, and the removal of sunlight is not good for our health. As of yet, the developer doesn't seem to respond to the many requests of a shadow analysis. As for the traffic, let me just say, get to the facts. I agree with you. Here are some of the questions I have on the traffic. I live here. I walk my dog here. We need to be safe all the time, not just now, but during construction and post-construction. All of these timelines need to be considered.
Excuse me, Ms. Gingras, your time has expired. If you can wrap up in a few seconds, that would be terrific.
I'll wrap up, and I'm wrapping up for the entire building of 100 people. I didn't want 100 people speaking this evening, Mr.
Yes, ma'am.
Rose, so
Yeah.
just consolidate. So it's 104 weeks of construction, of truck trips, street closures, 1,500 truck trips is estimated. What about the additional 274 cars? These are questions that as you pursue your investigation on traffic, and their delivery, no one mentioned deliveries, the Amazon deliveries, the food deliveries, all of these habits that have been habit forming over COVID. We get trucks that stop on the street all the time. How does this blend into things?
Yes, ma'am.
Profession, yes?
I know. Your 3 minutes are up, ma'am.
It's now 4. Thank you.
Okay.
Thank
Anyways,
you.
please consider all aspects of
Ms.
traffic
Gingras,
as you review this.
Ms. Gingras, I believe you sent us a letter and the commission
Yes.
has seen it. Yes, ma'am. We've read it,
Great.
so we will, and it will remain in the record. Thank you, ma'am.
Thank you.
Mr. Romeo, if you would go ahead.
Okay,
See,
good
it's-
evening. Thank you.
I hate doing that. Okay, go ahead, Mr. Romeo. And the next speaker is Wynn McDaniel, and I will bring you in now, Ms. McDaniel. Okay, go ahead, Mr. Romeo.
Good evening. Thank you for the opportunity to speak. However, I has submitted written comments, so I won't read my written comments. I just want to make a brief comment this evening on this application. I'm the chairman of the Greenwich Communities, and I want to talk to the historic portion of this. I look at this and I redubbed this application. It's coming under 830G as the Cinderella statute, and her stepsisters who, try to get their foot into that tiny glass slipper, make it fit at any cost. I think this application is coming into the Fourth Ward. It's an historic district, and it's going to destroy the quality of the neighborhood and of the Fourth Ward. And I just hope that this application is denied and that the historic district is maintained. And I'll leave it at that.
Thank you very much, sir. Our next speaker is Wynn McDaniel, and after that is Steve Holopater. And if you would go ahead, ma'am.
Hello, Madam Chair and members of the Planning and Zoning Commission. My name is Wynn McDaniel. I am chair of the RTM District 7, but I am speaking tonight as a former resident of the Fourth Ward. I lived at 56 Sherwood Place for 14 years. I moved in 2003 to Glen Road just behind the hospital, but consider myself still part of the neighborhood. My regular walks take me through the Fourth Ward as I travel down Sherwood Place, Church Street, and William Street. While still considered central Greenwich, it is a quiet neighborhood where people know each other and say hello to passersby. We still frequent the William Street Park. My son still goes to the Children's Medical Group, and I shop at the Women's Exchange, Pinkies, and take my dry cleaning to Town Cleaners. We all know each other. It is a quiet and peaceful neighborhood and a nice respite from busy Greenwich Avenue and Putnam Avenue. Please do not change this by approving this large project, which will ultimately make the neighborhood more dense and busy, more like a city versus a unique place to live, especially if some of the apartments become short-term rentals, which is likely given the demand for rentals in Greenwich. The other item I want to address is that all of the condos at Sherwood Green, where I used to live, have skylights and small outdoor patios. As mentioned tonight and in the previous meeting, this large development will overshadow Sherwood Green, limiting sunlight into the units and their backyards. This will have a significant impact on the overall health of the residents. With no light, the rooms below the skylight will be dark and there will be no ability to grow plants, etc., in the backyards. One last item, if I have a moment, is on the traffic on Church Street. I'm a pretty cautious driver. When we go down Church Street quite a few times to get to our home on Glen Road, my husband, on the other hand, is a more aggressive driver. And when I'm a passenger in his car, I have to shut my eyes when we're going down Church Street. So I have to bring a little levity into this, but I have to tell you, it's the honest truth. With the cars parked on the side and the cars coming at you, it is a scary experience. And we've made it so far, but it is very, very tricky. So I give you my thoughts and my opinion as a neighbor and a concerned citizen of the town, and hope that I know that there are more items to be covered on this project, but I do not support it. Thank you.
Thank you very much, Ms. McDaniel. Steve Holopeter, you are next.
Hi, I'm Steve Holopeter. I'm president of the Sherwood Green Condominium Association, and I've lived here for over 30 years. There's one issue that I'm very concerned about. It's a vital health issue. When you're talking about 1,500 truck trips removing debris from the demolition site, you're going to be demolishing older buildings with possible toxic substances such as asbestos and lead that will come up and will be released in the air. We're in Sherwood Green, which is just adjacent to this unit. My family and I are going to be breathing in these toxic substances, and there's a tremendous amount of studies that say this is extremely detrimental to your health. It can cause cancer and many other diseases. We're very concerned about that aspect of this construction project. The other issue, which Winnie McDaniel talked about, was the light issue. This development is right on our property line, and we have a patio outside that we enjoyed the sunlight in the morning, and putting a 80 or 90 foot building up right on the property line is going to put our patio and everything else in shade. Is not, I don't think this was in consideration of the original residents of Sherwood Place. When we bought this, we depended on having a nice patio with sunlight on it. We all know the importance of the natural light as on our bodies and for health reasons. Another issue I'd like to talk about is the parking. I don't know, in their parking, just the parking spaces, there is, over the 30 years, it's gotten more and more congested on Sherwood Place and Church Street and around. When we have a blizzard and we have to clear the street for the plow, I got to drive 4 or 5 blocks to get another spot on the street. Adding all these 192 units is going to increase the traffic. People are going to have visitors who are going to have to park. So it's going to get more and more crowded, and there's no pickup, as I see, from the demolition of the dance studio and the doctor's offices, because they have ample parking behind the buildings and they're not parking on the street. Back on the lighting issue, the architect was very concerned about providing light for the new residents, but building this monstrosity in the middle of the historic district is just going to cast its neighbors in shadows. And I'm hopeful that people will look at that lighting issue. It's very important.
Good point. Yes, sir. Go ahead.
And
Mr.
the last concern I have is if we give approval for this type of facility in the historic Fourth Ward, it's going to open the floodgates for more developments. You know, people are going to come by and say, I got another 192 unit over here in the Fourth Ward. Well, you authorize this one over here, so you should be able to authorize my new project. And pretty soon, we're no longer going to have a historic district. It's going to look like Manhattan looked like, with a bunch of high-rise apartment buildings with no character.
Okay. Mr. Holopater, your time's up.
Yeah, I'm sorry. Here we go.
But I think you got all your points in. So thank you very much, sir.
Thank you.
All righty. Okay, Mr. Haslam, are you awake?
I am.
Checking, your lights were out. All right. Okay, so we've heard from the public. You've gotten a whole lot of input tonight. We are going to schedule a meeting just for this application where we can drill down some more, and we're not looking at a packed night.
Great.
It just enough detail, so we will work with staff on that. While we were going, this is a must close if you give us the extension on the 21st of July, and we will make sure we get at least one session in before then. And we will structure it. We will give Katie feedback individually on how to structure it. Do you want to add anything at this time?
No, except thank you again for all the time spent on this application. And we listened as well as spoke. And hopefully you agree with us that we're a little bit farther along than you thought last evening. I think we're all very familiar with the issues, and let's move forward together.
All right.
Madam Chair, we were going to have this on the June 21st meeting before the July. So we have it tentatively scheduled, but we clearly need to get something scheduled, I think, just to hear this application. But I think we should still keep the June 21st if possible.
Absolutely, absolutely. I think we need to make sure that all the issues are covered in great depth, so we don't have anybody saying that we've missed something important. There's a lot of complexity when you're doing a building this large in a town that isn't used to having buildings this large, and we need to make sure we've addressed it all. All right. With that, then we will leave this application open, and we'll see you real soon. And in the meantime, commissioners, it is now 8:22. Would you be willing to reconvene at 8:40?
Yes.
All righty, I will see you then, and we will proceed with Kima Greenwich. Let me just get rid of everybody here, move everybody out. Len, Stuart Johnson. Oh, you got them already. Tom will keep. Okay, we're good.
Or Mr. Haslam has a double header here.
Yeah, he looks very somber. Mr. Levy, I might have to call him.
And now for something completely different.
And now, and you're gonna, okay, hold on. I'm just checking in with Mr. Levy.
He's here.
He's there. He is? No.
Yeah, I don't see his face, but I see his camera.
But that's the problem. We all stay here. We all leave we
Oh,
don't
gotcha.
sign out.
Yeah.
So you don't know if somebody's really there.
Even when they're there, you're not really sure they're there.
Yeah, that's true too.
Did you ever see the movie Speed?
Yes.
Yeah.
You remember the trick that they employed by taking video?
There he
and-
is. Okay, good. All right, Mr. Levy, I was just calling you if you wondered why your cell phone was ringing. Okay, time's up, everybody. No more movies. No more fun.
Well,
All
I'm going
right.
to get back
Wait.
to Dennis's continuous loop though later.
Wasn't Arn here a minute ago?
Oh, he left.
All right. Um, all right, getting Arn.
We're okay without him.
Yeah, that's true. But then we could never seat him on if we hear it again. All right, okay. We'll start without him. All righty, folks. Our next application is Kima Greenwich for a final site plan and special permit at 8 and 10 Lewis Street. This is for the conversion of mostly New York Sports Club to a retail bakery, market and restaurant, and also Sophia's. And with that, Mr. Haslam. Hello, Mr. Wells, your timing is perfect. We had given up on you. Go ahead, Mr. Haslam.
Thank you. Good evening again, Madam Chair, members of the commission. Chip Haslam for the applicant Kima Restaurant. With me tonight is Bernie Adler, our traffic expert. And if you had questions for Bernie, and also Rudy Rydberg, who is our architect. I don't see Costa Giannopoulos on, but he is the applicant through the Kima name, and Jackie Kaufman is an attorney. I think you all know Jackie. She represents the owners of the building, and she's graciously offered to join us tonight. You're all familiar with this project by now, and we've discussed it in the pre-app, and then we had a previous final, which was converted to a preliminary. I just asked that preliminary file be made part of the record of this, so that it's not to prolong the presentation and discussions, et cetera, so that we can all know what was previously discussed, and then focus really on what the remaining issues are tonight and see if we can't somehow resolve them. As you know, under the preliminary, you had recommended that we agree to a limitation of 125 guests for lunch. And we agree to that Monday through Friday. You asked that we limit special events to 50. We've agreed to 100. And we would like to be able to have lunch up to 225 on weekends and dinner 225 Monday through Friday. We feel that not only our own traffic analysis, but also the analysis that was done for the town back in 2017, which I submitted into the record, supports the idea that the parking demand diminishes as the evening goes on, and the cocktail hour starts and dinner starts opening up on the avenue in Central Greenwich in general. And from your 2017 report that you commissioned, it would seem that there was more than sufficient parking at that evening time for them to recommend that you actually free up your liquor restrictions in the area, which is what you did. So I think that's supportive of our position that the Central Greenwich area can handle the 225 for dinner. My client wanted me to point out that he has 18 seats in 2 private rooms, that it would be very rare that those there would be a table for I think it was 10 and a table for 8 that would be dining in those private rooms on a regular basis, which should be taken into consideration. Also, we would be willing to agree to make sure that the retail establishments were closed at 6 o'clock, as long as the restaurant is functioning upstairs, so that that parking demand would disappear in the evenings, which I think I put down something like 60 spaces. Also, I did want to point out a correction. We did take away the 12 seats that we had initially in the marketplace. There are still 12 in the bakery, but no longer 12 in the market. So that would be a better function for the lunchtime hour. There's as far as the volume is concerned, we're not adding to the square footage of the building at all, but we have to level out the floors to make this restaurant work. If I understand Rudy correctly, there's maybe as much as a 3 foot difference or something between the 2 floors currently. So part of it is to resolve that situation. And also we have a kind of a signature roof that we'd like to put in, but we're not adding to the square footage of the building at all. It's just some addition to the cubic footage. You will not really notice that at all from the exterior. It would just be a transference in the interior spaces. So we think it will function well. We know you have your concerns about this. I thought of some other things I was talking to Attorney Kaufman about today, about what else you might do to assuage those concerns. One of the things I remember when I haven't done it in a couple of years, but would apply for the Hyatt's tent permit every year. And one of the requirements was that we had to give P&Z a running list of the functions that were coming up and how many were going to be in attendance, et cetera, so that they kind of monitored the situation. Now, I know that with the Hyatt, we had to reapply every year for the tent with staff at least. But there's something maybe in there that we could work out to make sure that your concerns about special events don't come to fruition. We've also already indicated that we would agree no weddings. But we do feel that special events are important to any restaurant, and that we know of no other restaurant in town that has a restriction on those kinds of events. So we would ask you to consider the 100 that we're proffering.
So why did you not pay attention to us? Just curious.
I have a client who wants to run a business and feels that these numbers are necessary for this business to actually be profitable. And otherwise, we're not going to be able to do the project, and it would be a shame to leave 26,000 square feet of empty space in the center of Greenwich until the next possible tenant comes along to Attorney Kaufman's clients.
Okay.
Mr. Haslund.
If I if I may add to that too, Madam Chairwoman Jackie Kaufman, for the record, I think that certainly the commission's put in a difficult position to balance the needs of the community and of the merchants, as also with the property owners. And that same conflict, I think, also exists for the property owners in determining what tenants are right. And there is as Attorney Haslund just mentioned, there is a level of faith and commitment that one needs to have in that tenant. And we, just as a tenant and owner, the commission, you all have the same goal, which is to see the building and the avenue succeed. And selecting a tenant that would potentially default on its zoning permit and then have to be receive a cease and desist order, an enforceability charge, is not in anyone's best interest. So an operator is going to seek out a location, as it has here, and design a concept that it can commit to. This applicant has made, or this tenant applicant has made suggestions for, I think it's met you in the middle on certain requests for conditions that really are not, or have not been consistently asked of other retailers and owners on the avenue. And that does actually create a slippery slope. I've been following as many people in the community
Ms. Kaufman,
have.
Ms. Kaufman, can you just stop talking just for a second? I'm sorry, we're getting a bunch of hands up from the commission from the time you started, and I think they would like to say things. Mr. Yeski was first, Mr. Levy is second.
Yes, I think we understand the balance between the owner and finding a tenant and the operations. And I think we've had a lot of discussions. Let me make a suggestion. We're really concerned about the volume here of traffic, seats, everything. We've resolved some of this in the past by having a phase in, a trial period, so to speak, where we agree on a smaller number, see how that works out. And if it works out, then you increase it. Is that something that's in the realm of possibility here?
I can't speak for Attorney Haslund's client, but I do not think that would be desirable for this under these circumstances. Someone has to sign a lease. And I believe that you asked me a similar question on a prior application, and it was a good dialogue. And it was, I thought actually it was a very healthy dialogue that we had. And at the end of it, the conclusion is that does not create a business opportunity that becomes reliable, that a particular investment is made both in a lease and a property by two parties. And if neither one of those two parties are in control of the outcome, it doesn't make for consideration is missing. Yeah, I don't think it's workable. I think that we need to agree to all those terms now.
Okay, Mr. Yeski, did you want to add something to that? Because your hand is still up.
Well, it is. I'll consider it down, but I think the other side of it is that we have a responsibility to the town and the regulations, and we're going to go back through all the detail of the traffic and whatnot, and we're going to open it up to public. I was just making a suggestion to kind of cut to the issue there, which is just the pure volume, given that we don't have any other restaurant this size in town.
Yep.
And the one other one we do is next door almost. And there's a lot of other restaurants there. So it's a concentration in a very small area. It's not so much even the dinner, because I think we could see after 6 o'clock what happens downtown. But during the day, and particularly on weekends, for lunch, I'm just citing that could be a real issue from a parking. It is a real issue from a parking and a traffic. So I was just throwing out as possible suggestions. I don't know. Attorney Haslam, maybe he has some thoughts on it.
Before we go to Mr. Haslam, Mr. Levy, I think I'd like Mr. Levy weigh in quick if it's on the same topic. That's what I should ask you.
Yes, I just wanted to get to solutions. So I mean, there are places to park. So if there are ways to deal with some of the more of the problematic parts of the tenancy, like large events, is there a way of managing the parking and having valet for events and think I'm sure there are opportunities to do things that do mitigate the problems by taking pressure off of the areas that we feel are most vulnerable to large events, say. But
And then
I think that one of the things you can do is take an issue and solve that one issue and move on to the next. There might not be a global way of dealing with this tendency. You might have to do it issue by issue. And if large events is one of them, let's deal with large events. If another one is you want to have 225 people come to dinner, and we want 125 or whatever it is, what is the solution? How are you going to accommodate that difference? I'm sure there are just ways to chip away at this so that the tenant can do business the way he wants to.
I really appreciate you framing that issue with that question, and I'm sure that Mr. Haslam and Mr. Adler can speak to that and answer that directly. I also have some thoughts, but I defer to them because I think Mr. Adler has some institutional knowledge about those. But those opportunities do exist, provided that one can find the parking offsite available within a certain area. So.
All right.
We did look into seeing if we could find parking off-site. We looked at Pickwick Plaza. They're very resistant to giving anything out. We looked into the parking at Town Hall. It's extremely expensive and it's not that convenient to the site. I suppose we could introduce valet for special events and have the valet find the parking spot for them. But it's tricky. And again, I'm not sure, particularly when you have a building like this that was deemed to be between the front and rear building lines back in the 60s, and it has been exactly a position as it is now since 1910, same size, et cetera, that it would have to provide a parking, whereas you have, as I said before, places like Le Penguin or Asiana that are not part of that arrangement from 1960 have no parking, and yet we need to find spaces for ourselves. But the other thing too is mentioned that there's no other restaurants like this. I happen to have a client who owns the Townhouse restaurant, and that's the folks that just came before you in the last application. And they informed me that they have 290 seats indoors that they seat for the restaurant. So that's quite a large restaurant in a little residential zone, and with obviously very.
You by any chance think that we were not alive when we did that restaurant?
I know.
You remember how insanely concerned we were about the exact same issues we're discussing with you right now. And this is a different issue. And I just want to go back to Ms. Kaufman's point that we are balancing the needs of the local neighborhood with theirs. That is actually not the case. if the town fails in general because of the success of your restaurant is going to end up failing as well. And that's the
Correct.
point that we've been trying to make to you. This is not about just balancing the community versus you. It is about doing something where you are an integral part of a community that is thriving. And I feel that you're not being responsive to these concerns we keep raising. And the very fact that you're saying, wow, we looked for parking and we couldn't find it, says we are right to be concerned. Because
That
if
parking
you were
that we
right
would
now,
believe in.
I've
I'm
thought
sorry.
about, so as long as I got the floor here,
I'm
and
sorry.
parking is the issue. What we thought about is where you could limit. Sorry, I need some water. Okay, where can you limit your events so you don't mess up the avenue?
Sales days are fine. The street sales in July, I've talked to client Costa about that. That's not a problem. We won't have any special events during street sales. The holidays are tough because obviously most of the restaurants, that's where they do their special events, is during the holidays. So we'd be unwilling to really limit ourselves in there. But if there are other suggestions that we can entertain, we'll take them up.
Let me jump in. Can I jump in, Margarita? So give you
Because I need to be rescued anyway. Yes, please.
recovery. Yeah. Now hold on. I've got technical issues.
Okay, I'm back to life. Sorry.
I'm sorry.
Go ahead, Mr. Lowe.
I had a technical. So, Mr. Haslam, I think you made a comment, and I may have the wording wrong here, but something along the lines of no other restaurants have had restrictions put on their events or some such thing, right? And then you just cited a restaurant which, from all appearances, you're proposing that we get rid of in a different development, but I don't want to go there. But doesn't the suggested scale of your numbers suggest that your client in this application needs to have large numbers? I mean, you're asking for them, and the hope is that if you build it, they will come. But what you're telling us, what I'm hearing anyway, is real estate is expensive. You haven't said that, but overhead is what it is, and we need the capacity to generate the volume to support this endeavor. Is that a fair comment?
I'm not a restaurateur. I'm just a lawyer. So I take from what my client tells me is the case to be the case. And for this large space, in order to make it work and not make it feel like it's half vacant and unwelcoming to the clientele, he wants to be able to fit it out. And one, two is the fact that it will be very expensive to fit out. He's intending to spend a great deal of money on it, and he has to get that return by making sure that he has the clientele coming in on a regular basis that supports those numbers. That allows him to be in a long-term lease with Attorney Kaufman's client.
Right. So, but in an ideal, perfect world, this would be great. That we, if the town can support such a space, wouldn't that be great? But now we have, we have obstacles here, and we're not hearing. I mean, I want to speak for everybody, but I'm not hearing any practical solutions to the very realistic concerns that have been expressed here. And I'm also hearing resistance to some of the recommendations we made. And now you've gone and explained part of it by saying, well, my client needs X to sustain this business. So I hear that. I got that. But where, what are we going to do? You've got not only just a square peg in a round hole, but you've got a very small round hole and an enormous square peg. And I don't know where, something's got to give, right?
I think I actually got a very enormous square peg is what I have, which is a very big empty building. And it's very difficult. You're not going to get another New York sports club moving in this situation anymore. And we thought the idea of breaking it up, initially we were just going to have a restaurant, breaking it up into bakery, market, and restaurant. I'm sorry, we were originally just going to have bakery and restaurant. Introducing the market as well, which would be more of a daytime entity, less traffic, et cetera, was a good thing for the downtown area and a good trade-off. What we could do, the CEO has said that he first came and opined several months ago that the Liberty Way was the ground floor and Lewis Street was the second floor. He's now come back and said that actually he thinks Lewis Street is the ground floor and Liberty Way is the basement. In either case, what you have is a conforming proposal to have the restaurant either entered in from Lewis Street with a stairwell under 103.1 to a second floor under his original opinion, and you've got the retail on the first floor, or you've got a situation where you've got a restaurant on the first floor, which is permitted, and you've got retail in the basement, which is also permitted when you only have 2 levels in the zone. So we could go at it either way. At the end of the day, though, what we are proposing is less non-conforming than the health club, whichever street you pick, it had 2 levels of health club. One of them had to be the ground floor, and that was non-conforming with your regulations. So we're taking a non-conforming situation and making it conforming. So that's a benefit. And I think too, just the nature of this mixed use that we're proposing together again with the retail that we already have on Lewis Street too. So remember, there's a lot of activity going on in this building that really helps the downtown area and will really help it once it's occupied. I think it's only going to be a benefit to this part of Greenwich Avenue, which doesn't have quite the same intensity of parking demand that the lower parts of the avenue do. So I think you're going to find it's actually going to be a very good tenant for this space, mixed tenant, I should say, and that it's going to function well. And I think it's going to be an improvement, really.
But the market will tell us that, all of us, right?
Yes.
I mean, and we can sit here and pontificate about it, but the market will tell us whether that's the case or not. And I'm not suggesting it isn't. But meanwhile, there are very real concerns about what to do about parking. And by your own admission, you and your team don't have any ready solutions for what we perceive to be a major stumbling block.
Well, I said we went out and we looked at leasing spaces from other property owners in the area. And Tom Torelli has been instrumental in that too. He's a commercial broker here in town.
Yep, we know him.
Yep. And actually represents MH Keller. And we really went and kind of like beat the bushes to see if there was something that could work by way and give some relief to the parking demand other than the municipal parking lots. And we really did not have any success, Mr. Lowe. We weren't trying to just blow off the commission. But there is public parking that's shared with everybody that agreed to that deal in the 1960s, as well as those people that had no parking at all, did not give up any part of their property, but still now use it for their restaurant parking or other uses, et cetera. What I think is really good about this building, it's a big building. It's 26,000 square feet, I think, plus or minus. You do have these mixed uses that aren't competing. The retail use in Lewis Street, not going to compete with this restaurant use. Certainly in the evenings, and that's the same thing with the uses down below. And there are different kinds of demands on traffic and parking. And I think it works well.
Yeah, but the problem is with that analogy is in the 1960s, there were only really 2 restaurants in town. But go ahead.
All right. So
I'm
first,
serious.
okay. So next,
I will
is
say
our-
that in the 1960s, at the
Ms.
bottom of the
Kaufman, Ms. Kaufman, just hold on a second, because Mr. Wells wants to ask a question. The 1960s, let's not get into that. Go ahead, Mr.
Yeah,
Wells.
I just want to build on a point
I'll
that
say that.
Peter Levy made a while ago, which was sort of chipping away at the problem, and just a suggestion. And regarding employee parking. Now, we all know why that's important, because the employees aren't there for an hour or so to pick up some bakery. They're there for 8 or 9 hours. So they're using parking for an extended period of time, much longer than any of your clients would be. I just throw this out, Island Beach, half of that parking lot is for hourly parking. You could park there for the whole day. Maybe encourage your employees to park there. Maybe you have a van, a shuttle van. Some might want to walk when the weather's nice to get some exercise, but maybe you have a van to shuttle them up from there. Because I think that would take at least some of the pressure off. So I just throw that out. Thank you.
Okay,
There's
then,
also the town parking at the Greenwich Plaza.
okay, another thing, I would like to do some drill down now. We got the comments from Beta. I'd like to address Mr. Rydberg, but your answer a little bit of a non-answer in there. So I'd like to get, then I definitely would like to get the zoning enforcement comments about, we're back to the first floor and the ground floor. The other thing is, I'm finding the duality of the attorneys a little bit confusing here. Ms. Kaufman is representing the property owner. Mr. Haslam is representing the applicant, who is Kima. Would you please tell me who is making the application and therefore who is the attorney? Because having both of you go at the same time is not our protocol.
I am the attorney for the applicant and I'm making the application on its behalf.
All
Kima.
right. So Ms. Kaufman is supplementing because she is representing the landlord. It would be helpful to us if we could focus on the applicant, because these are issues. I know, Ms. Kaufman, you are here to not just towards seeing the landlord's issues. And we do. We want every single business on the avenue to thrive, but that's why we're pushing so hard, because it's got to work for everybody. Mr. Haslam, where would you like to start? We can start with the Beta comments, which I feel were not fully addressed. I'm sorry, Mr. Rydberg, but Beta tells you, I'm scrolling, hold on. Why is it that it always takes so long? So it goes back and forth, but their comment, I don't feel we've given a full answer. It's once again, they say that the retail for the proposed bakery is not the most appropriate, as it underestimates the AM peak hour when most people want to go to the bakery. The second thing is the question about the fine dining. I believe, and whether that's actually the right one, and I think it goes right back to how much event you're planning. Mr. Rydberg, you then answer in generalities about what time people eat, what would be most, what one would expect, but you don't really touch on the question that keeps troubling us, which is exactly what Mr. Haslam has just asserted, which is, if you are having special events, you are no longer just a fine dining restaurant type of establishment, which is, I believe, what Beta was raising to you. Okay, I won't go to the ZEO yet. I think we should just do Beta. Commission, you good with that?
Yes.
Okay, let's do Beta. Who would like to talk about Beta? I guess that's going to be Mr. Adler. Mr. Adler, I've been pushing back on you on some of your assumptions all along.
Yes.
Mr. Adler, you're still muted. There you go.
Here. So the first question that Beta raised was specifically related to whether we underrepresented the number of trips that a bakery would make. We actually did an analysis of a bakery as part of a supermarket. In fact, if we read the Institute of Transportation Engineers guidelines, one of the components of a market is a bakery. So instead of taking the 7,000 approximate square feet of the market and the 2,000 approximately square feet related to the bakery and combine them to about the 10,000 square feet total, we would be generating less traffic than what would be generated by the two individuals. So we studied it again, and we feel that the trip generation based on our analysis is at least very conservative.
There's a part of me, so on the bakery, I don't really know how to say this to you. Are you foreseeing, when Beta says it understates it because it understates the AM peak, they're saying it's going to peak at a different time? Can you clarify that?
No, what they're saying, from my understanding of Beta's comments, is that the number of chips generated during the morning peak hour by a bakery would be higher than what ITE is saying. That's the way I understood it. I think they're saying that bakery in the morning is the peak time. Everybody's going out for rolls and cakes and et cetera. And the number of trips should have been higher than what ITE said.
Okay. All right.
And and our argument is there are a number of markets that include bakeries, and bakeries are major components of markets. And if you combine them and make it a larger market, one approximately 10,000 square foot market instead of a 7,500 and 2,500 approximately, we find that there are fewer trips than what we did. So the separation of the two generated more trips than if they were a combined store.
Okay.
And
All right.
I haven't seen Beta
Fine
said
dining.
they stood it. All right,
You're
fine
fine
dining.
dining. You're fine
But-
dining. They are once again, and are you still doing that credit you were giving yourself for
Not
the
for
past?
dining. Not
For
for
the, wait a
dining.
minute, you're still doing that pass by credit that I
We-
hated so much
we-
the last
we-
time?
I looked at it again, and first of all, we should have more probably called it a diverted link, because I know it's not a major arterial where you might locate
you.
a
There you
gas
go.
station.
That was my point.
But
Okay.
it is diverted off of
I get it.
the roads.
No, I get it. It's just that it's a teeny weeny little alley. It's not a road.
Right.
Okay,
And-
fine dining. Fine dining, Mr. Adler. I'm sorry, we're gonna go fast on you guys tonight. We're
no
just gonna
problem.
hit you with a lot of questions.
Right.
On the fine dining, again, the question, to what extent did you incorporate in your trip generation, et cetera, have you incorporated this whole concept of the events and how they're gonna fit?
According to ITE and the general description of a fine dining establishment, the most important criteria would be the amount of time that a patron would stay in that restaurant. And if they're over there for an hour or more, it's considered fine dining. But in part of a restaurant is parties. It could be a birthday party. It could be, just people celebrating. It doesn't necessarily have to be a major event, but parties are part of a fine dining establishment, and that is certainly included within the ITE. And we did not take any credit at all for
Okay.
fine dining.
All right. Now, you said, I'm going back and forth and I'm sorry. Did you address, I wasn't sure that you were answering Beta's question regarding the using Coffee Donut Shop.
I think I didn't answer that question because I think it's not a coffee donut shop. It's a bakery.
Okay.
It's a more upscale version of a Dunkin' Donuts type of thing.
Okay.
And I thought the description is contained in ITE about what we understand the applicant is trying to do. Our establishment is probably more appropriate.
Okay, next question, and I'm jumping fast. Only 10% of the business is during lunch?
In fact, I looked up the latest standard. It's probably a little higher, more like 20 to 30%.
Yes, thank you.
If we follow the 2011 report that was prepared by Fitzgerald and Halliday, they were the ones who came up with something in the order of 20%. And that was based on the 4th edition of Parking Generation. I just researched, because it just came to my attention, the Fitzgerald and Halliday report, and I'm looking at it, and the amount of trips during the midday is in the 50% range.
What was the date of that Fitzgerald Halliday report? It was pre-COVID.
2011.
Thank you. It's all a blur back then. 2011 and today, and our traffic is a hemisphere apart. I'm sorry, Mr. Adler. We're about to redo, and I want to go there with Mr. Haslam now. We're about to redo a downtown traffic study. Katie Patrick, Katie, are you back on? I know you had to take a break for a sec. No. Okay. So one of the things is we're at a strange place. We know our traffic has evolved tremendously. We know that the outdoor dining has changed all the flow. We know that everything about restaurants, everything about the avenue has changed. Katie, is there any, and Mr. Haslam, is there any precedent legally that if we if we learn something as we do our next downtown parking study and downtown traffic study, that when you come in, say after you've got a CO, we set a time frame where you come in after you've got a CO and we look at your metrics again relative to our new data. So that you adjust, you come in and you say, well, we're actually getting this kind of demand and this kind of business and this how it's gone. And we have the same kind of thing that when we say to people, come in and talk to us 6 months after you've opened. What if we did that in the context of new traffic data and parking data for the avenue? And we had a conversation about whether what has been decided for you is actually working for you and for the town. Could we do that, something like that?
Not really, no, but
Yeah.
but that kind of speaks to what Mr. Yeske was saying. You'd have to do it the other way around. In other words, start slowly and then go further. That would make sense, but to go the other way
A
around.
phase in, would you be willing? In
Yeah.
other words, the question to them is, would they consider a phase in?
Or Mr. Haslam.
Yes.
Yes, Katie actually had suggested something like that months ago to us, and would that work? And unfortunately, it doesn't. I mean, it could work for something like, you got a pop-up linen store that used to be over like in the old Van Driver building or something, because there's no financial commitment, both to a huge commitment in this case of fixing this building up, but also of the long-term lease, which you've got to have the landlord wants and the tenant wants, because he's put this investment in there. So it just doesn't really work.
What about some hybrid with what Mr. Yeske and Mr. Levy said, where you go with X, and then after you get to a certain point of capacity or a certain Y factor, then you have to do some valet or something along those lines. In other words, we have done that before. We did that with the UST building when they converted from one tenant to multi-tenant, where once they were 85% capacity, they had to initiate their valet plan. So you would have to actually have the contingency plan ready to go.
Yeah, I think the valet plan may be one of the most the most possibility here for doing something with.
Yeah, the biggest issue I see with that though is, and you've got a unique situation. I do understand that with the front and rear building line, but what you don't want to do is something that depends on town resources. In other words, if every business said, well, don't worry, I'll just use the town land to solve our problem, then that won't work. So it's got to be something ideally privately or that's practical. We have an app, we won't get into that, but you need something that would work. I know in other words, we've looked at ideas for valet in the past on the avenue. I think Saks was the one that kind of got furthest along, and because they do have a private parking area that they could use. And more importantly, I think an area where they could get they could do the valet operation, meaning, because if you have to rely on parking space 4, 5, and 6 to always be open, then you're going to run into problems because they might not always be open.
That's correct. You can't assume the use for valet purposes. There would have to be a space carved out. And if that space doesn't exist without depleting the parking bank, then it may not be viable.
Good point.
But how many employee cars do you have, to Mr. Wells's point? Because, if you analyze the actual demand of customers versus employees, there might be something in there that brings the overall demand down. If your employees could be required to use the town plan that's in play already, the employee parking permit system. I did talk to Lieutenant Gray, who said that there are still some available, some permits available for the what lot is it? The Lafayette Place lot, which is pretty close, very close actually to this site.
I don't know if we investigated that particular lot, but I know, and I didn't personally, but we did approach the now parking czar, for lack of a better word, about that, and it was just it was extremely expensive. prohibitively so per employee. But maybe there's something to do with Island Beach. Maybe you can do that and have a shuttle or something. I guess there's some things possibly worth listening. No?
Or
They want to develop Island Beach.
Oh, that's right.
But
What am I
there
thinking?
is,
But
there
there's
is
parking
permit
around.
parking.
I wouldn't
Yeah,
hold my
there-
breath on that.
There's permit parking at Town Hall, which could actually work because it would be off hours if it was in the evening.
That's what we were looking at, I believe.
Yeah.
All
That's my
right.
understanding.
So these are thoughts. These are thoughts that will work all around. It's just to come up with, and again, we want you to be successful, but not if you're going to bring down the avenue. That's just as simple as clear as that, because y'all won't be happy. And I got stopped on the street after saying this to you the last time. If it's Yogi Berra time and nobody goes, it's too crowded, so nobody goes there anymore, that line, that can't happen to the avenue. And that's the concern, because it'll bring you guys down too. It'll bring everybody down. Okay, so we've got Mr. Rydberg pacing. All right, Mr. Adler, did you want to say something? And I believe Ms. Kaufman wants
Yes,
to add
I
something.
just got a note from the applicant from CASA, and what his note was simple. A lot of employees take buses and trains.
Yes.
So basically what he's saying is
Shuttle
solving the parking issue on the backs of the employees probably wouldn't help because
No.
they don't have cars.
Okay, that's good to know.
That's
And
good
that's
to
it.
know. I will tell you anecdotally that is not necessarily true on the avenue. Katie and I once did a project where she and I walked down the avenue and talked to people, and the wait staff all told us that they were parked right in front of the restaurants because they might have to run an errand in the middle of the day. I'm just telling you. Okay, so that may be what his experience is in other places. I personally spent time walking down the avenue talking to restaurants right after lunch. And okay, all right. So we've got some ideas. Do you want to quickly go then to the comments that you've got from the ZEO?
No, other than I think I already addressed that. He kind of seemed to reverse himself from the previous comments, which were.
I was confused. Yes,
Yeah.
I agree.
So he had said that Liberty Way was the first floor and Lewis was the second. And because of that, we redesigned the restaurant so that it
Yeah.
complied with the new 103.1 by putting the staircase in the public area down the first floor. We can get rid of that, really. And if he's saying that now Lewis Street's the first floor, that's fine. We can, restaurants permitted use there now without having that public space down the bottom area. And the retail is permitted too. So again, I was just making the point, and he goes on to say, maybe it should be considered under 6-141 in this case. And I would tend to agree. If that's what you're going to say, again, we're taking a non-conforming situation and making it conforming as to the use.
All right. Okay. Okay. Commission, anything else?
Mr. Haslam, something just to keep in the back of your mind. We've had a lot of discussion of seats in the restaurant. We have other uses. Maybe something to keep in your mind is maybe the area of each one of the uses is adjusted, i.e. if the bakery is a certain amount of square footage and the restaurant's got too many seats according to what we're seeing, maybe the grocery gets bigger. So it reduces the seats, but you still have a viable use of the grocery store, as opposed to say, maybe what we're thinking, it could be a detriment of a very large restaurant. Maybe the grocery store is a more of a benefit to the area. So
You
just
suggesting,
something
Mr. Macker, then have the grocery store on two levels as well?
however Mr. Rydberg can do it, but maybe the grocery store is bigger and the restaurant's smaller. I'm just thinking, looking at three different spaces and three different uses, if you would. Maybe one can get smaller, another one has to get bigger. That way you're kind of, working it around. So you're kind of addressing what our concerns are by doing that.
My client is a restaurateur, not necessarily a purveyor of products, but he just thought that introducing these other two uses would be good and having the mixed use with the tenant uses too. But in any event, thank you for the suggestion. We'll take it into consideration.
Great, thank you.
Commissioners, anything else?
Oh,
Okay. Anybody from the public wish to speak on this application? This is Kima Greenwich. Yes. Mr. Vignarti, I am making you a panelist now. Vidyarti, my apologies. Mr. Vidyarti, if you would go ahead. If you would unmute, Mr. Vidyarti. There you go.
Okay, can you hear me?
Yes, sir.
So I have a couple of questions about this. I own Le Penguin Restaurant on Lewis Street.
Mm-hmm.
As part of this application here, will this space also have a bar?
Yes.
Yes, I believe it's
Yes,
in the
it will.
plans already, yes.
Mr. LaRoe, would you kind of throw up the floor plan so Mr. Vidyarti can see it? And Mr. Vidyarti, you go ahead with your questions and we'll get the floor
So
plan
my
up for
question
you to
to you
look at
then
it.
is then, what are the requirements currently for a space as far as parking? I know that there are parking load requirements for a bar, right?
Okay, so the question is, Mr. Vidyarti, what happened, and you may be aware of this. The merchants on the avenue and in other districts of town agreed to sort of do combined parking to create, I'm doing the shorthand version, guys, to create the municipal lots that, for example, are where this location is. And as a result, the compromise is that there is no required parking for the buildings that are between the front and rear building lines on the avenue. And so the bar, so you have no required parking. There's some technical arguments that have been made by staff that you could maybe require parking, but the truth of it is what it is. You have a commercial parking, you have a municipal parking lot, and that's what you got. So there is no required parking for the shops on the avenue, which has been a problem with some of the bigger uses. Okay, go ahead for your next question.
So the next question I have for you then is, I heard the suggestion of possibility of once they reach a certain capacity of their valet plan kicking in. Right?
Yes.
Now, if that's a thought, if that's a consideration, obviously the valet then, considering there's no other place for them to park, they would be using the municipal lots. Correct?
Well,
if a valet
yes.
plan kicks in and the valet is taking a car from a guest that is parking at the restaurant,
Then
the
you
valet's
would
got to have some place to park.
Right.
And
Right,
if
and
he's
that's-
parking in a
and they
municipal
would
lot,
find-
it was that.
No,
I'm
no,
sorry,
no, Mr. Vidyarti. So the whole point was they would find a place to take those cars that was not in the municipal lot. That was the whole idea. Now, I know that could
I
be,
just wanted to be clear on that. I just wanted
Yeah.
to be clear on that because
Yes.
my understanding was that municipal lots cannot be used for valet parking.
That's right.
correct. So you
Okay.
would be freeing up the municipal parking.
After what the suggestion was, the suggested use was after 85%.
Well, we
No,
left
no,
it to them. We,
Justin, no,
we left it totally to them. We said, think about these as ideas. Again, we're still concerned. The other thing that we've said, and I didn't flesh it out, the one that I came up with. So Mr. Vidyarti, I'm just going to segue away from you for a second. What we were saying what we said in our briefing session yesterday is pick the peak pressure times. And just make sure that you don't have special and big events during the peak pressure times in the area. Because you know what, Mr. Applicant, you're not going to have enough parking. During sidewalk sales hours, you would be hard pressed to park anywhere in town. And your business will not do well if you try to have an event that night or that day. But so pick the events where you pick times when you really would circle around the peak pressure. That would be very helpful and it would help your business thrive. Okay, Mr. Vidyarti, what else?
So now it brings me to the question of lunch service. I heard that they had said something that their lunch was going to amount for about 10% of their business.
Yes, and then they said maybe 20.
So I own Le Penguin, and the lunch service amounts for about 30% of my business. And
I know it
between
does.
the hours of 11 and 3 on Lewis Street and the municipal parking lots, it is a virtual parking lot of traffic.
I know that.
It is a virtual parking lot of traffic.
No,
There
we
is
know
just no
that.
way to get around. especially with the dry cleaners and people backing in and out of the dry cleaners spots, because they've got to head into the dry cleaners and back out of the dry cleaner spots. And the race to find parking spaces in the municipal lots is an absolute disaster zone currently. I've had a restaurant there since 2013. And in the last 2 years since COVID, with all the expansion and the new people that have moved into town, it, I would say, is throwing out a number about 40% more than what I was used to seeing it in 2018 and 2019, traffic wise.
Yes, sir.
So
You
that's
got it.
my
You're,
two,
yep.
that's
Yes,
my
sir.
2 cents.
I think you're agreeing with us, so I'm going to thank you for your comments, because a lot of the merchants are just kind of trusting us to handle this, and we thank you for coming in and saying this. So I'm going to remove you, okay?
Wait a second, Madam Chair,
Wait,
if I could. Would you please ask the owner of the Penguin, first of all, how big in square footage his restaurant is?
Tiny.
And secondly, how many people does he seat at lunchtime?
Am I on mic still?
Yes, sir. Yes, you can. How many seats does your
I have
restaurant
49
have?
seats. I have 49 seats indoors, and I'm currently trying to get a permit to do an additional 24 seats outside. But our restaurant seats 49 people indoors.
And what is the square footage of that restaurant?
Total, including the back kitchen and the whole thing, is about 1,800 square feet.
Thank you.
It's small. It's a small restaurant. I mean, we recognize that, but the point is, a third of his clientele does regularly have lunch there. Now,
And the point is further than that. The point is that even though 30% of people that are coming to the restaurant to have lunch have an impossible time parking. I've got customers that give up after the first or second go around of not being able to find parking, and they call the restaurant to see if they can reschedule their reservation.
yeah, I know.
So this happens on a regular basis.
Especially
Not to mention the number of angry phone calls my office receives, the reservations office receives, because guests have no place to park and they're freaking out on my reservationist.
So, so Mr. Vinyarty, would we get done with our parking study? We're going to make sure we reach out to you.
I would
Okay.
appreciate that.
All right, sir. Okie doke. Oh, we got to get that done, you guys. All right. Okay. So that's it. Does anybody else from the public wish to speak on this item? No. All right. I think you guys have some things to consider from the commission about, again, how do you make this work better? I don't want to get into all the technical things about the 141 and all that. I'd like this to work for you. I'd like it to work. I'm glad that is it Mr. Costa? Or is
No, it's
Costa his first?
Costa Giannopoulos.
Okay, so I'm glad he's here and hearing it. I want him to know we support his business and we want it to work, but we have these ongoing concerns. Anything else? And so you know where we're saying to you, where could you give us days? Where could you get? Dennis, you had one other point you wanted to make that I'm not hitting. Days, flexibility on the valet parking, to consider valet parking, days that you would avoid events, a capacity number at which you would go wider open, that you do not quite a soft open, but at least not go to something where you move in slowly.
No, I think we got him. I mean, a soft opening was what I was thinking. The lunch, it just occurs to me that the lunch on the weekends, 225 people, that's a bottleneck. The dinner on the normal days, you might be able to get away with more than what we were recommending, because I agree, after 5 or 6 o'clock, some spaces. Now, the owner of the Penguin may not agree with that, but the upper part of the avenue starts closing down. And I walk the avenue a lot too, and I do talk to a lot of the other owners there. But the hybrid, where you have, I don't know where to put the valet. I've got a note here, valet to wear, that kind of thing. But employee parking, a little bit of everything around. You could kind of customize the operating. The question is that something that the applicant is willing to consider at this point in time? No weddings, that might help. I think
We
you said that.
no weddings. Yep.
Yeah, they did.
And stuff like, it's that weekend lunch that bothers me. Now, maybe we should talk to some more people that own restaurants there. Because that is a real difficult time.
Yeah, by the way, Mr. Haslam, Mr. Yusky is our informed source on the avenue and the times of day of traffic. Yes, he's laughing. He walks the avenue in its entirety every single day of the week.
Come
So-
on, you're exaggerating. You're exaggerating.
Okay, he probably only does it 6 days a week, but what he's telling you about what he sees on the avenue and what he and we're always asking him what he's seen because he has a very good take on the pressure on the avenue. Do you guys have anything else for us? Nick and everybody else, did we hit enough of the items that got raised?
Yeah, because I think actually your ARC's kind of taking a peek at this. Health Department wants the food service package prior to the building permit, which is standard. Engineering had some questions, but I believe Mr. Haslam's been addressing those.
Okay,
Sewer was doing the acknowledgement letter, that kind of stuff.
okay,
Did that.
yeah, so
Well,
you did that.
We
Yeah,
were,
there-
I mean, we were encouraged by the briefing session yesterday and some of the comments, and particularly from the chair about how do we make this happen. We're encouraged again tonight in the comments to the only difficulty I think we're all struggling with is how do we make it work? So we'll go back to the drawing board and try to get creative and see what we can do. We're taking your suggestions again in the advisement. So thank you again.
And is there any parking? Now, I guess it's really inconvenient, but is there any parking at the train station at night since the theater's gonna close and everything?
I mean, the other problem with all this too is that the zoning requires that parking has to be within 1,000 feet
know
and
that.
under the same ownership. So, you know,
But
it would
but
also
remember,
require-
but there's
We're
no
not required to
parking.
have parking.
There's not any required parking is their main argument. So because of the front and rear building lines. I mean,
But the parking's
staff,
gratuitous.
I mean, staff was making an argument that they do have a required parking because if you combine the buildings, but in any event, we're just trying to get to it. I mean, we know we're trying to get to a solve.
Right.
And you're also pressured, the next one, and we won't see this, it's an admin, is, you got the Jean-Georges place coming in at the bottom of the avenue. That is going to make, I can tell you that the cottage, the new one, the Westport one that now is here in Greenwich, they're booked a month out. I
Wow.
talked to the owner the other day, they're booked a month out. Okay, so it's really popular place to eat. I believe that Mr. Konstantinopoulos will be successful here. We just have to make sure he is. Because there's going to be a lot of demand. Okay, Mr. Rydberg, I'm not touching your architecture, okay?
I wish I was a young man in Greenwich in this day and age, rather than back when it was only Bob Forrest's townhouse in Portofino was the only game in town.
Mr. Haslam, you didn't have any money to go out to eat back then,
That's
so
true,
now
I didn't.
So you were saved.
you were saved. All right, you guys. So we'll see you when you come back. Just tell us when you're ready when you've got some ideas. Talk to Katie, talk to Patrick.
Okay, we'll work on it.
So, Madam Chair, I think if we're going to continue this tonight, we need to continue it, please, to a date certain. If we can continue
It's
it.
very
No,
only Patrick.
we
Only
can't do
Patrick
that.
gets to do that. It's really hard. He's in trouble tonight as it is. It's 9:40 and we are so far
It's a
behind.
procedural requirement. Chip and
No,
Lucira.
We will
Yeah.
get you on a meeting as soon as we can.
Yes,
Thank you.
ma'am.
The procedural requirement is that we do it within the timelines associated with the application. So when we get it on a tentative agenda and figure
We'll
it out.
do our best. Thank you, ma'am.
Thank you again.
Thank you.
Oh, boy. All right. Okay, so for our next application, we have New Greenwich Park LLC, 51 Weaver Street. This is for, I'm gonna say this right, the boot camp,
Barry's Boot Camp.
Barry's Boot Camp.
Is that what
Now,
it's called?
I don't, all right. And
Maybe it's Barney's.
it's Brad, and there's Mr. Tessie, who's probably in Florida.
What's he wearing tonight?
Hold on. And Mr.
We haven't
Mulder.
heard from Mr. Tessie in a long time. I thought he retired.
I know. I told you we were gonna see him. Hello, Mr.
Coat and
Tessie.
tie.
Unmute yourself before you say anything, because otherwise we'll ignore you. All right. Okay, folks. So this is New Greenwich Park LLC, 51 Weaver Street, for a final site plan and special permit. It's our application number 9. They are going to change the use to a fitness center. Go ahead, Mr. Tessie.
Okay, well, I have a jacket and a sweater on, so you know where I am.
In Naples.
My team's all going.
All right. You actually came north?
Just to see you.
We're
Close in
deeply
person.
honored. All right. Okie doke, Mr. Tessie.
Well, thank you. Here, well, you introduced me already, and I'm here with Mr. Molnar, as you can see, who is coordinator for Mr. Ferrari. Well, when it comes to about all of the projects we work on. And I don't know if Ron Riemann, Kevin, I don't know if you've heard whether Ron was going to be able to make it. You're muted.
But you can keep talking.
No, I
Ron
will.
was unable to get here.
The reason why I asked about Mr. Riemann is that we received this afternoon comments from Beta. as you probably-
Yes. Okay. That was where I was going to open.
Time.
So
And,
if you want to open there.
Well, that's why I asked whether Ron was in attendance. Originally, he had some other bookings, but was going to try to make it. So I don't think he's here. I can comment a little bit about those comments. I think a lot are really addressed in his report, and there's also the history of what's been going on both on the Office Park property and 581, 585 West Putnam Avenue. Just kind of starting from the beginning and see if Ron does show up
He's
here.
not going to be able to get here, Mr. Tessie.
No, well, that's,
Okay.
okay. Well, again, I think I can make a few comments there and put things in proper perspective, which I don't think necessarily they have. But that's my opinion. We're making an application on behalf of a tenant, a prospective tenant in what's called Building 5 at Office Park. We kind of previewed that we were going to make an addition to that building when we were finalizing the 581 residential building, where we asked the Planning and Zoning Commission to approve a lot line adjustment between the Office Park parcel and the 581 parcel for the specific reason of coming before this commission with an addition. So here we are at that regard. The tenant is Barry's Boot Camp, which is a very currently popular, I call it a workout facility. I don't know if any of you took me up in my letter offer to view the site. Essentially, what they propose to introduce here to this property is essentially their classic workout system, which consists of treadmills and then essentially weight training, combined with weight training and flexibility training. It's all done at a fairly high intensity level. The floor plans that we sent, I think Patrick, I don't know if you disseminated them to all the commission members, lay out 45, I'll call them spots. And they consist of, as I said, treadmills in specific pad locations or stations for the class participants. There we go. And that's on the bottom, they're on the bottom of the screen. On the upper part of the screen are spaces, they're not laid out yet for men's locker room and women's locker rooms. Again, this is an intense workout situation. So the estimate we were given is we articulated in our letters, both mine and the letter from Collier, a traffic engineer, traffic and engineering company, is that the class sizes are 45 maximum. And if you count up, you'll see 45 spots there. If you, at the bottom of the screen, they estimate a lower portion of the participants or participation, more like about 60%. analysis done in our parking study and our traffic study broke it out in terms of the smaller percent in the full capacity, taking no credit for that is on the site, specifically 581 in the future, or for any office workers. Which clearly one of the reasons for this on an attractiveness basis, Mr. Ferrari, was to have another amenity on site to promote office park for office tenants. So we do think there would be some, but there was no credit at all taken by Mr. Riemann in his traffic analysis in those regards. Insofar as the parking situation, I know there was some question about the capacity of the garage and the access below.
Where people were going in and out. Nick,
Yeah,
do you
they're
want to
going
hit
in
that
and
and
out
make,
in-
yeah,
into
Nick,
the
do you want to
garage.
hit that? Why don't you clarify that for Mr. Tessie?
Yeah,
'Cause I think he-
it's my understanding that actually it's the fitness area addition off the building, and then the first bay inside the building is the floor plate, and it's accessed from an exterior doorway at grade. Is there access from inside the building or inside the garage to this space?
Yeah, Kevin can answer that, but yes, go ahead, Kevin. Muted still.
muted, Kevin. Mr. Molnar.
I keep doing that.
Yeah, it's okay. A lot of us do.
On the pond level of the building, the space where Barry's is going is accessible from all of the existing cores within the building, as well as the parking, enclosed parking area on that level of the building, which contains 66 spaces. The core, which could take you vertically down, will also give you access to another 130 parking spaces directly below. Some of the parking spaces are literally directly below their space.
Right, of
And-
the existing building. The
So-
addition
So
built
to
on-
Nick,
built on a slab.
the question you
so-
asked in the briefing yesterday.
Yeah, I think because this is the concern I have is that we in the site plan that we had, looking at that in the staff report, the most convenient parking was the adjacent site, the adjacent new site with the apartments. And I was trying to figure out, okay, if I was going to be coming to here, where would I most conveniently park to attend a class? And
They
I was
won't be
having
permitted. That's an easy answer. They're not going to be permitted to park on that site. That's for residential use only. In fact, we went over that, the 585, I'm sorry, I keep saying 585, 581-585 application when we were talking to you about the lot line adjustment in our site plan. And we pointed out, and I believe it's part of the condition of the approval, that there'll be an easement, that there is an easement agreement that will be in place between those two parcels, whereby those particular parking spaces that happen to be partially or wholly technically on Office Park would be for the benefit solely of the 581 residents. And it's interesting because I saw the cover, and saw the cover in our cover, the architectural packet. We have this nice looking couple walking across the parking lot.
You got it. And we're all wondering what you're doing. Okay.
And I laughed saying, oh, well, I guess we could take credit for two people anyway, who are going to make their way from the residence. to
So
the-
it's the pond level, Mr. Moeller. That's the garage. And then
Yes,
there's one.
there's another level below that as well.
Right.
Okay. And I see the plan here. I guess you're into the, I guess the north quarter, kind of walking through the building, and then you're into a back quarter, and you're in Suite 105, which I guess is the fitness area. Okay.
I'm gonna Scroll through
Right.
it on my screen here.
Right.
But what you're saying sounds very familiar.
I think that is right.
Okay. Great.
Matter of fact.
Now, I just want to make sure, Mr. Chester, I understand this. The classes are 7 days a week, plus or minus 12 hours a day.
Yes.
15 minutes apiece with 10 minutes in between.
Yes, and I wanted to speak to that a little bit because I know there's some concern. If you notice in our parking analysis from Collier, Mr. Riemann,
Well,
they're
it's-
looking at a full, if we went to 45 plus three to five employees, you need 90 some odd spaces, which we have to double up, in other words. I mean, that's the worst case. And so we've got that, first of all, in that building. We did a parking study in the building. And as you read, I'm sure you all read, we've got a surplus of about 160 spaces in that building alone. On the entire Office Park site, it's probably more like 500. But right there concentrated inside the building for easy access. Everybody's very comfortable. There's plenty of parking. Now, from a traffic standpoint, so I'll just delve into that. As you see, there are lockers and locker rooms, and I can assure you there'll be showers. And what you're going to find here in this type of situation, which may not always be the case for class situations, is that a lot of people are going to, during those peak times, if you will, which are really morning, you know what it is. It's relatively early in the morning and it's after work. Those are the two areas, late afternoon, early evening, and morning, early morning, where you have the larger classes. You're going to have people who aren't just going to come in 45 at 1 and the other 45 are leaving. You're going to have people sporadically leaving because you're going to have people, a lot of people are going to be taking showers, simple as that, and getting ready and leaving. So you're going to get a decent flow. It's not going to be necessarily 100% concentrated. So I wanted to point that out and also just point out again, or emphasize again, we did all worst case analysis. We asked them to do that. And from a traffic flow standpoint and from a parking standpoint, we really believe it works. And I think it's backed up by the numbers, the general statistics and the specifics for our sites.
Okay.
Where
Go ahead.
There was mention made, because we thought it was appropriate to make that when it comes to the West Putnam Avenue entrance and exit, if one ever gets built. We committed on the 581 application that there would be a second look process. Right?
Yes.
And if we need be. So we thought it was important, again, to just remind everyone, we're all aware of that. We always said we'd stand by it, and we'd stand by it, stand by it here. I don't think this is going to be the determining factor on that. It'll be ultimately when we get the residential building going. I think Kevin's finally, did you get your building permit, Kevin?
No, we're still struggling through some conditions by a certain commission.
We're getting there. So probably be a couple of years. But Barry's Boot Camp by then, hopefully, if we get this approved, we'll be up and running. There is a build out. It's probably going to take about 6, 7, 8, 9 months, but Kevin may think longer to get that all done. But
Mr. Tessie, quick question.
At that point in time where there may be an issue on East and West Putnam Avenue, we're prepared to address it as we were. I just wanted to again confirm that.
Mr. Tessie,
Go ahead,
quick
Mr.
question.
Bless you.
Mr. Bootcamp's focus is the focus more on the population of the office park using the facility, or is it the focus on anybody and everybody?
It's in anybody and everybody situation in terms of the lease doesn't restrict or could.
Yeah,
because we
but
can't.
there's no
Go ahead.
There's no gym facility in Office Park at the moment, correct?
There was a fitness center there, smaller one. And this is essentially like Kevin's going to replace that with a.
There's an existing amenity fitness area within the office park that's still there, operational today, and will remain. It's a small cardio area, a little bit of weight, very small.
Okay.
Okay.
I'm saying this, just getting back to this, 12 hours a day, 7 days a week kind of thing.
Yeah.
That even as just a gym someplace, that seems like an awful lot of hours in
Well,
classes.
Again,
So,
what I was
and let me
saying,
just
what I was
add to
explaining
this,
earlier was that,
Mr.
go ahead.
Mr. Tessie, if I could, in addition to what Mr. McRae is asking you, there's a secondary thing, which is if you staggered the classes more, if you could do that, and this is the big question. What Beta raises isn't about parking. What Beta is raising is the operational safety issues at the intersection, what the level of service is, what the impact is for people using the drive, and would you give the level of service analysis for the driveway at Valley? And it is, if you find that there is an issue, the simplest thing would be to, I think the hours are okay. If you're not disturbing those residential uses, your hours are going to be okay, but you may just need to gap it more so that you're not having the traffic, all the in and out happening at the same time, as we know happens otherwise. That would be, so these questions that Beta's raising are really about the intersection and the traffic and what the impact is going to be as the classes go in and out. That's the more urgent. Then you add where Nick is going, but you could resolve Nick's layer of questions if you answered the Beta questions. Does that make sense?
Well, I think the Beta questions, first of all, they're all answered because there was analysis on a bill, no bill basis.
Not for the
by
gym, there
Collier
wasn't.
In their report.
Yes,
Yes, they did
but
that.
it doesn't give you the level of service
Yes,
for.
it does. There's a level of
Oh.
service given with
No.
every intersection, but I think you're raising Valley
No,
Drive.
this is not, we've
You're
got this.
However, I will agree, I don't believe there is a level of service given
No.
for the Valley Drive, for the
No,
Valley
sir.
Drive. For the
I didn't find it.
I just said, I think you're right.
Yeah.
The
Yeah,
Valley
first you told me I
Drive
was
is the
wrong.
only one.
Yeah.
I don't think we've ever necessarily done it. It did a level of service analysis. But again, Ron's not here to answer that. He can respond to it. I think that, you're talking, we were proposing a 10-minute gap, which is their norm, as I pointed out. I think you can have a lot more people taking showers, so you're not going to see the in and out.
But
on
Mr.
that,
Tessie,
specific basis.
10
but
minutes?
That's just my opinion.
Right,
Go
10
ahead.
minutes in between classes. So if I have 45 people in a class,
Yeah.
class is over, and I have 45 new people showing up.
Yeah.
I have how many people changing, getting into a shower, et cetera, and you're telling me that they're going to be in and out, they're going to be showered and changed and out the door in 10 minutes.
No, I'm saying the opposite. I'm saying they won't. I'm saying
They won't.
be
They're all
they
gonna
won't.
be there.
I'm saying the opposite. I'm saying a lot of people will not be going within that 10-minute period because a lot of those people will be going in 20 minutes or 25 minutes. There's
So
gonna
may
be
I-
more of a flow because they'll be taking a shower after the
So
class. That's what
may
I'm
I-
trying to say. Which
Okay,
is
so may-
better. Which is better
Hello?
for flowage.
Mr. Tessie, may I just suggest to cut
Sure,
this
go ahead.
off? Could you just prepare the answers to what Beta is asking, and then you can do your narrative in terms of Beta's questions?
Well, I'm sure you don't mean me, but you mean Mr. Reno.
No, I don't think I mean you.
Right.
Okay, so if you guys would do that, it's too bad he couldn't come, but if you guys could do that, then we could address the issues that are outstanding for us. Because Nick, I think that addresses what's the parking demand, how is the flow of the traffic, because he's going to talk about what happens to the intersection.
Well, there's only
Yeah.
that one additional
Okay.
intersection.
All right.
What else?
okey-doke.
The parking shouldn't be an issue, as we pointed out.
Right, okay, so if you
There
would
was one-
address,
I just want to respond to a couple of points Patrick made, just for the record. He's right. He had 4 points on the first page. I'm not going to belabor the evening, because I know it's long. But he's correct. The overall site plan for Office Park is dated a few years ago. So we haven't updated that. So it doesn't show the lot line adjustment. That's number one. So we can get that corrected. Regarding the 2010 decision, I can report to you that none of that infilling was done, Patrick, in any of those deck areas. And that approval is long since expired. And I don't see, we talked internally, Mr. Ferrari, at this point, given the overall office market, doesn't believe he would be coming back asking for something like that. Guess that would be good for the town if he did, but that's the answer on, actually, that's number 3.
Or conversion of some of that office space to affordable housing would be pretty cool too.
Right now, we're looking at certain things, but I think it's one step at a time for them. We've got that 581 site.
Yeah.
And so that's going to take a while, and we've got an application before you for building 8 that'll
Okay.
appear soon, where he just needs to do some work on that. So he may get to it there. But
So,
those are
Mr.
the only
Tessie-
points I just
Okay,
wanted to answer. I saw where sewer department basically just said, submit our letter saying we read his memo. And then we'll deal with the rest after zoning permit or during the building permit zoning permit process. And I saw that the ZEO didn't have any comments. So you're right, that pretty much leaves us with addressing Beta.
Yep,
And
and-
ARC, Kevin, do you want to give a report on ARC to the commission?
We
Yeah, we
had
can-
our first meeting last Wednesday. They got us on the calendar. And I think everything went relatively well. I'm waiting for the action agenda to get published to make sure my recollection is as good as theirs. They basically asked for more documentation, a site section cutting through this site and a few of the others, and an overall site plan encompassing approximately 4 to 5 acres around our 1,600 square foot addition.
okay.
Madam Chair, I've seen the draft minutes. I could say that those are almost identical to what's going on. And it does ask that the applicant returns. So it's not, they're not final comments, but there's some work that's being requested.
Okay. All right. Okay.
So
So,
I just one quick question, then I'll stop. So with regard to ARC, because we really didn't talk architecture with you all tonight, you're just going to defer to ARC on that, or is it?
I
It's a
cannot
little
make
clear to
you,
me.
I cannot make you that promise with Peter Levy and Nick on the commission. I absolutely cannot.
Is that
make
an indictment or a compliment? I'm not sure.
I cannot make you the promise. If ARC does something that Nick and Peter both hate, you're going to be cooked. But if you can just work it out so that everything is good. So far, nobody's done anything anybody hates. I'm more focused on, I want this to work for the intersection. We handle safety concerns at Valley. I'd like you to come back on that, and we will ask staff to stay in touch with ARC.
Okay, well, we're not going to need much time to get back to you, so if we
Okay,
can get on
well,
the next available agenda, hopefully.
We
it's this
will,
year.
of course, accommodate you on the next available agenda.
Good evening. Thank you
All
for
right.
your patience.
Thank you. Fly home safe.
I'm here.
Thank you, sir.
Bye-bye.
Good night.
All right. Okay, goodbye, Mr. Molnar.
Bye now.
All right. All right, okay. Our next application is Xiaokui Qin and Hui Wen at 1 Florence Road for a final re-subdivision on a 28,754 square foot lot in the R7. And the applicant is
John Hegney,
Mr. Hegney,
he should be transporting himself right now.
transporting. Okay, he has been beamed up.
Thank you, Scotty.
All righty.
I would be
And then-
back.
All right, okie dokie.
Good evening, Madam Chair, members of the commission, John Hegney for the applicant, Xiaokui Qin and Hui Wen. This is an application that should be a property that is familiar to the commission. We started this project back in 2013 with a lot line revision. improving the building lot that is now 1A Florence Road from the lot that is currently 1 Florence Road. We came back to you in 2016 seeking re-subdivision of the property to create a new lot. At that time, we were trying to coordinate some development efforts with our neighboring properties. And we have come back to you with a plan that we think will work for the site. The new lot that we're proposing to create would not actually come off the end of Florence Road where the rest of the properties have ingress and egress, but would come off of the corner of Sunshine Avenue and Bonwit Road. Our property actually takes its proposed frontage from Sunshine Avenue Extension, a paper road that was created and recognized by the town with the recording of map 3148 in the 70s. I'm sorry, the 50s. Back in 2016, Mr. Maitland asked us how we could use that paper road as
Exactly.
justification for our frontage. And
Yep.
we told him that we were going to do some research and get back to him on that. It's just taken us a little longer than we anticipated.
Well, yep. And you withdrew the application at the time.
That's correct.
And you had some outstanding other issues. Okay, go ahead.
So Connecticut case law states that there's an implied easement to use roadways shown on a map to access a public highway, even if the roadways are not developed at the time that the lots were created or conveyed. That's a quote from the Lake Garda Company v. D'Arche. It's a Connecticut Supreme Court case from 1949, 135 Con 449. As I noted, we obtained these rights when that 1950s map was recorded in map 3148. Our property is shown adjacent to it, and that is where we're deriving our frontage on this re-subdivision. I will note that we have private easement rights for ingress, egress, and utilities, some of which we are using. In particular for ingress, egress, and electric and telecom. In our discussions with our neighboring properties to the west, which had been formerly owned by the Princiati family up until the beginning of this year, we have been discussing sharing development efforts. And so we are proposing to bring in sewer, gas, and water in the Sunshine Avenue Extension area. We have seen the comments from DPW.
Yes,
It's
good.
not that I disagree with them. It's just that I think they're premature. Yes, the town charter says that anyone who is going to be serving 5 lots needs to meet the town's roadway standards.
It does indeed.
However, I would say that I believe that responsibility is going to fall to the successors entitled to the Princiatis. Based on the trustee records for Mike Jones and Vicki Johnson at Ivy Barnum and O'Mara, my guess is that Melissa Clawberg will be very capable of answering those questions when they go to develop those lots in the future.
Okay, I believe that that's not how it reads because we are home rule for subdivision, as you know, and therefore I believe that on subdivision we can require that. And actually, Patrick, you and I talked about a subdivision that doesn't even have 5 lots and it was taken at town standards. I'd like to research that myself because I believe that we have required it within the subdivision in the past when the subdivision goes to serve 5 lots.
Well,
So I would like to, as I said, I would like to check that. I'd also be interested very much, Mr. Hegney. I'd like to revisit this question of using sunshine. There's a bunch of comments in here as well, but I'd like to revisit that with town council.
Happy to provide him with the research we've done.
I'd like to see that the case law, that case that you cite, and I'd like to revisit it with town council because again, we are home rule for subdivisions. And therefore, I just want to make sure that this is consistent with our subdivision standards. Well,
As our discussion from earlier today, we did say that we were going to focus on feasibility rather than actual development. And I'd be happy to do that, but I also think that feeds into delaying applying the charter provisions in this situation. We are looking at a situation where a majority of the 5 lots that would be utilizing this access way, which is only shown as a feasibility, could be done at a later time
Yes,
with a different developer.
I understand that, but as you know, it has to be feasible. And so therefore, since it has to be feasible, I'd like to run it by town council because I've got some questions on the feasibility is what I'm saying.
I would hope that. I'm happy to have a town council weigh in.
Now, while you're doing that, you're gonna get us in the numbers that your FAR will remain compliant on 1R.
It certainly will. We can
Okay.
provide those numbers. We figured that we would not give you the information last minute this afternoon, but happy to provide that to staff so they can take a look at
Okay. And you should give us some sense of landscaping since the subdivision regulations, as you know, do require that you have, do have some requirements of you.
I understand that. I would say that in this situation, I think we're actually doing a better job of complying with 6-297 and preserving natural features. The area
yes,
that we've
but we would
designated on the
yes,
property is actually mostly ledge.
Yes, but
So
you haven't
planting that might
actually,
not make the most sense.
but you haven't given us a plan is what we're saying.
I'm saying that because we haven't provided the plan, it's because of
Okay.
the ledge in the proposed open space.
No, actually, so you kind of have to comply with what the regulations ask you to do, not just tell us why you're not complying with them.
Again, happy to put that together for you, Madam Chair.
Okie dokie, thank you. All right, those are my questions. Anybody else?
Mr. Hagney, is there somebody from the DeAndrea office with you?
Mr. DeAndrea, I hope is in the audience and he is available to answer any questions on
Yes,
this.
Mr.
We
DeAndrea
did
is here.
submit to Mr. LaRoe a markup of the plans just to facilitate answering any questions the commission may have.
So I'm looking at the proposed development plan, and I just want to make sure I understand this correctly. There's a significant retaining wall, I guess, to the east side. And then it looks like there's a drainage structure under an easement onto the lot of 1R. That it looks like it's goes to a Cultec, and then the Cultec drains into looks like the existing drainage structures for lot R. Is that correct, Mr. DeAndrea?
While Mr. DeAndrea does get set up, I think I can confirm that that is correct, Mr. McRae. We are showing the drainage coming down through the existing 1 Florence Road, Lot 1. And I'll let Tony take it from here. It looks like he's ready to go.
All right, Mr. DeAndrea, please go ahead. Mr. DeAndrea? You've got your hand up. You need to unmute, sir. Mr. DeAndrea? Oh, I thought he had this finally. Mr. DeAndrea, unmute, please. I'm asking you to unmute.
He's got an internet problem.
Uh-oh. Okay, so when DPW is concerned about the Sunshine Extension infrastructure, that's what you're asking, isn't it, Nick?
Well, no, there's 2 parts of the infrastructure. I've got infrastructure, drainage infrastructure that goes off to another, to the adjacent property and then drains into their drainage system. And then I've got, I want to understand the driveway to the proposed dwelling goes down and connects to a shared driveway out to Sunshine. And we've got a right of way for ingress, egress, and utilities, but I'm not too sure whose right of way that is. And maybe Mr. Hagney can actually kind of explain how that works.
Happy to clarify that, Mr. McRae. The existing easement on the south end of the property, which we're using for ingress and egress, is an easement over 48 Sunshine Avenue. It's a shared driveway that currently supports 46 and 48. The easement would allow us to use that for ingress, egress, and all utilities. Again, we are planning on using it for our driveway, and as well as our electrical connection because of the existing poles that run in that easement area. Due to the location of the sewer, water, and gas, we have been in discussions with our neighboring properties, formerly of the Princiati family, about bringing up those utilities through Sunshine Avenue Extension. In the event that that utility design does not work, we would obviously take advantage of the easement rights. However, we believe that it's a more cost-effective way of developing the site, especially giving or coordinating with that neighboring property, because it would benefit them in the future as well.
Okay, just a quick question. The Princiati property, is it large enough to actually add more houses?
Can I answer the question?
Yeah, great.
Now that I'm on the phone, because I don't know whether or not I'm being allowed to come in, but let me answer
No,
the question.
Mr. DeAndrea, we let you into the meeting. You have been a panelist and we have been calling on you to talk for the last 10 minutes.
I've been trying to speak for the last 15, but
Okay,
let me just
well-
answer some of the questions. I would also like to ask a question to clarify something. To answer Mr. McRae's question, yes, we are connecting to the drainage system on other parts of the prior subdivisions that we anticipated from the beginning. So we've been working on this, as Mr. Hegney pointed out, for a significant number of years. We've had a master plan, and we've been working very hard and diligently to implement it. And as you noted in the DPW comments, there are some minor concerns, that's it. But otherwise, the concept is acceptable and it's going to work. As Mr. Hegney pointed out, we contend with a certain amount of ledge on the property. We're aware of that. And we've implemented areas and features in our drainage system that are standard and regularly accepted. What I would like to have clarification on is what exactly is the concern, and are you clear on how the existing driveways access across portions of Sunshine Avenue Extension? We tried to highlight that for you on the schematic that I sent this morning so that you could clearly see where the existing driveways are. And they do enter into the intersection of Sunshine Avenue and Bonwit Road or Avenue. Another point to be made is that, as I count them, if you include our current lot, the maximum number that we would have is 4. And I don't know that you can predict exactly what's going to happen on the remainder of the Princiati property, but I have studied that, and it may very well be that only one lot will be proposed on that. Perhaps there would be 2. And I agree with Mr. Hegney, as happened in the past, when you develop that property, you would have to do more to satisfy DPW and commission requirements for how much and how wide that roadway or driveway might be.
So that just triggered my memory. Patrick, there was a 3-lot subdivision that I asked you about a few weeks ago. That subdivision had the potential, I believe, the reason that it was required to go to full width on the access road was because it had 1 lot remaining that had the potential to subdivide again. So I can't remember what you answered me about that subdivision, but we should dig it out and look at it. It was in 2005.
Silk Road, is that what you're talking about,
Yeah,
Madam
I'm talking about Silk Road, and I just remember the
So
commission.
that lot, yeah, that condition over there was that the part of the parcel of land that was touching the road was not wide enough to be subdivided 3 times as a rear lot. So
Right.
they created a road, and then they were able to create a street, and then
Yeah.
therefore three fronting lots off
But
of a cul-de-sac.
I believe that when we have had that situation, we have looked at the ability to further subdivide. Mr. DeAndrea, you're getting to a whole bunch of stuff that I'd like to talk to Mr. Wetmore about. Both you and Mr. Hegney have touched on things that I'd like Mr. Wetmore to brief us on as soon as he's looked at this.
Okay, understood. And what we are clearly showing is that there is already use of a portion of the right-of-way that was previously defined on a map and recorded as part of a subdivision. That roadway right-of-way is the only thing that could provide access to that parcel at the northern end of the current terminus of Sunshine Avenue Extension. Another point to be made is that the driveway serving the fronting lot of Princiati on Bonwit does not have access physical from the Sunshine Avenue Extension. And I don't think we can presume that that's going to be the case, that you're going to change that and come off of Sunshine Avenue Extension.
Okay.
Mr. Hegney or Mr. DeAndrea, I think the question that and I'm not trying to put words in the commission's mouth, but I'll say it in my way.
Yeah, go ahead.
Why are you designing infrastructure for lots that aren't being built, but not all the infrastructure? So you're running all the lines for the water and the gas and et cetera, but not the roadway. And so, it's not that this lot, needs that for its own development. So I think it's a little confusing.
I can answer that question very, very succinctly. Recently, and I don't know if I can pronounce the name correctly, but let's say Zhang, which is a neighbor of Mr. Nguyen, proposed to install a sanitary sewer lateral for his own home. It was initially designed, and not by our firm, but it was initially designed for a 6-inch sanitary sewer lateral. And when they started construction, sewer department decided that it would be okay if they just put in a 4-inch pipe. And what that did was it created an extremely difficult situation because of the amount of rock that they had to chop out. And in addition, they brought in utilities. So now what happens is we are confronted with a very expensive, difficult, and disruptive to everybody installation if we were to place the sanitary sewer connection for the new home adjacent to one that was already blasted in rock and is also sitting next to a gas and a water line. So from an engineering standpoint, it's a very good design to take it over an undeveloped property. And in accommodation for the neighbor, bring in the water line and the gas at the same time.
So Mr. DeAndrea, I think we still go back to, we'd like to talk to Mr. Wetmore about this. Do you guys have any more comments on this application?
And Mr. Hegney, I don't think you answered the question about ownership. I mean, I understand your rights to access and et cetera that you're explaining, but what about work and who has the authority to do these improvements? I don't know if I saw that in the history of the project.
We have reached out to the representatives at Ivy Barnum and O'Mara to coordinate with that. I would say that if they are willing to permit us to do the work, then I believe we would have no issue doing that.
Okay.
So you're saying that the Princiati property or the heirs of it are the ones that have the rights to do the work in the right of way?
Based on my understanding of the title, yes.
Okay. Thank you. I think that was the question that we had.
Okie doke.
Madam Chair, I would just note that, and I know that the commission has seen these issues before. When it comes to an application, you have to take it at face value. You can't assume future development. You can't assume future violations. So I would say that based on what we're presenting the commission this evening, again, I respectfully disagree with what Public Works' position is here. I don't believe it's appropriate to impose these requirements on our project. Again, it would be on the future developers of the Bonwit properties.
Okay. Your point has been heard. All righty. Do I have any comments from the public on this application? Again, this is 1 Florence Road. Okay, no. Okay, so I think Patrick, Katie, the work is up to us for this. A lot of the work is up to us is we need to get to Mr. Wetmore and lay out what our concerns are about the paper road and also what DPW has raised and how we address that. All right. Okay. Thank you very much, Mr. Hegney. Is this the last of you tonight or will we see you back?
You get the varsity team later this evening.
Oh, okay. Wake him up. All right. Thank you, sir.
Thank you very much, Madam
Right,
Chair.
thank you, everybody.
Good evening, Commissioners.
Thank you.
Okay, we got to go backwards in time now, folks. I hate to do this to you, but before we end the meeting, oh, Mr. Basili, that does end the public hearing.
Oh, what was that? Oh, yeah, okay, sure. Yes.
All right, Mr. Basili, that ends the public. It's going to say it in all the transcripts, right? Mr. Basili, that ends the public hearing.
Sure.
Thank you,
All right.
sir. Bye-bye.
You're
See you soon.
Good night.
All righty. So now we're
Mr.
going to
Hagney,
go.
we're going back to number 2, just so you're aware.
So now we're time traveling.
Yeah.
And it's Mr. Bender.
It is.
All right, I got
Actually,
it.
number 4, but all right.
Oh, I
Is it number
apologize.
4?
Thank
Yeah.
you. It's 2. It's
Okay.
2 Southwater.
It's two Southwater, and we both got confused at the same time. All righty, I'm starting to fade. Mr. Bender. If you just unmute, you're good. You don't need to worry about your camera. And you're probably tired from listening to us all these hours.
It's only 5 hours later.
Yeah, I know.
You don't want to see me on camera, that's for sure.
That's all right, Mr. Bender. It's good to see you or not see you. Okay,
Yep.
so here you are, and we're very sorry, but it was just once we'd opened the public hearing, just didn't want to, because then we got to stand down. All right,
Yep.
so here we go. We're back to you and your proposal for the deck. And we
Correct.
had several questions for you.
Okay.
I'm going to go with the most important one first, which is this question of the substantial improvement. Actually, I'd like Katie and Patrick, either one of you to do that. And then
I
also
looked into that today.
Oh, good.
Go ahead.
Go ahead. Hey, if you looked into it, you're good to go.
Yeah, I did my homework today. Honestly, I thought the meeting was tomorrow, so.
Okay, well, that's all right.
It will
As long
be in
as-
a few minutes here.
As long as we showed up tonight, it's okay. And you got in here,
Yeah.
so you were good.
Yeah,
Okay.
so I checked with Jessica today at the meeting records. Technically, I can show you on my screen if you can share the screen.
You normally can't
But
because
we
whatever
did,
you,
we
but just
checked on
tell
all
us
the
what you
per-
found.
We checked on all the permits. There was a permit in 2012 for 30,000, and one on 1996 for 60,000. So that's a total of 90,000. And then the tax card shows the valuation on the building itself as like 900,000.
So you should be good.
So we're less than 10%. So we should be good on that.
Okay. Now,
And the elevation of the basement and the first floor, do you have that, Mr. Bender?
That is, well, the elevation of the first floor is above the floodplain. I think the elevation of the basement is still below, but if we don't go over 50%, we don't have to get into the flood improvement or the flood.
Right. Well, yeah. If both floors were above the flood zone, then we wouldn't have to go into that discussion either. So,
But that's existing. We're building a deck that's level with the first floor. So
right, but again, it's connected to the structure, so it becomes like an addition. So, I think you've answered the question. So,
and then have you put in an application to the health department?
actually, we did. I ran into Michael Long today too because
Good.
I mentioned to Patrick that I thought we had discussed that with him. His concern was that we were increasing the seating, which
You're not.
which we're not. Seasonally, we're replacing
Okay.
basement, the lower level seating with the deck seating. And there's actually less seating on the deck now with the reduced deck. We took the bar off. So we don't have a bar there anymore. And we do just have 74 dining seats out there. So the parking requirements for that ends up being 89 versus the original 101 that was, grandfathered with the original restaurant there. We went down from 166 dining total, and the existing bar in the building itself was 35. So with the 20% of 15, we end up with 89 required parking spaces, which is 12 less than what was originally grandfathered, so to speak.
Okay.
So that's the only issue is maybe when we go back to the winter where we don't have where we put the seats, all the seating back in the basement. The required parking is 99 versus the previous 101, which was grandfathered. So if we have to take out, a couple of, a table 4 or whatever to bring it back to the compliant parking space requirements, we'll do that too.
I didn't follow that.
Huh?
That you would bring
The
it back.
original parking for
Oh, okay, got it. Yes, all right.
was
Okay.
101, and currently Macelleria is 99.
Okay.
All year.
Okay. Do we need this? How do we need the substantial improvement thing put together? Does it have to count the cost of the deck? Does it have to be a written submission? And what has to happen?
It is so they're able to get their own appraisal, or they can use the towns, the tax assessors data, and then
I
they
can show that to you too if you want.
Thank you.
I can fill out the form. I can bring in the tax card.
Okay.
Yeah.
On my screen now is the building records.
Okay, keep going, Patrick.
So then that as Mr. Bender has done the research, you would provide the cost associated with all the permits pulled on the building, and they would be contrasted against each other, and it's a math problem. If that number of the cost of work doesn't exceed the 50%, then we are in compliance, and the addition can go on. And that would also include the work proposed when that proposal comes to the desk of the zoning.
But we have to leave it open until you have written satisfaction.
I think it sounds like he has that information. So if you could put it together, yeah, it would all
right.
be part of the.
This is something that we have been kicking around for a long time, this application. This is one that I really feel like I would like to, and I'm just going back to this. We can get an extension, but it's a must decide tonight. Could we get this onto our next agenda? And as you've also got to promise not to overload us like you did tonight.
Can we start at 2:00?
I'm like, yeah, I mean,
Those
how
are
early
mutually, those are not the question, Madam Chair. Those are
No, just keep in mind, I'd like to point out that when I came on this commission, the meeting started at 7:00. If it went to 1:30, there would be mass defections. We're now past the 1:30 mark of the old hours.
Okay, poor little Patrick, we've beat him up. Okay, so this, I feel badly because.
I am not poor little Patrick. I think we have to do something about this.
So Mr. Bender has been with us several times. I think we're almost to the point where we've got things solved. I'm looking at Nick because Nick, you made some points about the landscaping yesterday.
He's added in switchgrass along the seawall, tall grasses. I guess it looks like a couple of things around the to the backside of the trash, the dumpster.
Yeah, around the compactor there.
Okay,
Yep.
yeah. And I had seen, and I'm not too sure where I saw it. I thought you had actually taken out one of the spaces and planted a tree in the middle of the
I
asphalt.
think he did.
Yeah,
But
we did that, and when we went back and forth with ARC. They said, you know, it's all right to take that out if we just add 2 more trees along the Mill Street side, which we did.
All right.
Okay.
Property line there, we had a couple more there.
Well, we could always make that change at the end. The key is we need his substantial improvement. And we just need the sign off from Michael Long that they did talk in the hallway and he's cool. He doesn't want an application anymore.
Well,
And
but I mean, I don't want to, you know, I don't want to.
yeah, so we'll just have Michael Long
So
confirm, no problem.
We'll reach out.
We know him,
Yeah.
and we get along with him, and we'll just say to him, hey, are you okay with where it is? So if there's room, this is an application I think we could do quickly at the next meeting. So I'd like to accommodate Mr. Bender, who also patiently sat with us for 6 hours tonight.
I
Don't
don't
miss it for the world.
Oh, yes, I know. We're for so much fun. Mr. Levy?
Could somebody explain to me the bales of hay?
The what?
The bales
Bales.
of hay.
Soils and erosion control. It's the part of the construction detail. When they start digging, they don't want the stuff to leak into the water.
Right, but it's combined with the planting bed, so I wasn't.
Oh,
quite
no,
sure.
no, it'll get removed when it's when the construction's finished.
Yeah, once the work is over, then we take it out.
Okay, so the deck.
Unless you want to
coming
keep
up-
it.
Right. The deck will accommodate the existing parking. Underneath.
That's what I'm seeing on his plan is that there's 4 spaces under the deck. And it's high enough that the cars can get in and out.
I was just wondering, I don't really see a parking plan that shows the columns.
Yeah, I see
Curious.
it's on SP1. The columns he's using a lot of steel, so the columns are far apart, far enough to actually get a car in and out. If you're good without hitting anything.
Okay, just
We spaced them, hopefully, you know, accordingly enough. We had a much bigger cantilever before. We reduced that and we reduced the foot. Still work.
Okay, all right, so Patrick's gonna try to accommodate you at the next meeting. We meet on Tuesdays only, Mr. Bender,
Right.
and we meet at 4 o'clock until we start meeting at 3.
Say that again?
It was a joke. We meet at 4 o'clock, okay?
That's
So
okay.
Don't be late.
No, I just got to make sure I got the right date.
4 o'clock on Tuesday, and they will make sure you know, as soon as you've got your information into Patrick, he'll reach out to you or something
Okay,
like
so
that,
there's no
right?
way if we submit this digitally in the meantime, that we can move along. But
No, because we got to have a hearing, so we'll put
But
you on
do-
as soon. Go ahead.
Submit it in
Do submit
advance.
it, yeah,
Don't submit it at the meeting. You got to submit it ASAP.
yeah.
yes,
Give
of course.
it to us
Yeah.
fast.
I was ready
Okay.
to submit it by tomorrow, but
Yeah, well, no, to do it by tomorrow anyway, okay? Get it done.
okay.
You know what our mothers always told us?
Yep.
Don't do today what you can do tomorrow. No, just kidding. Get it done.
I
And
will.
we'll accommodate you as quickly as we can.
Great. I appreciate it as always. You guys are great.
Thank you, Mr. Bender.
Thank you. Have a great night.
All righty, now we're going to go to the discussion items. And Mr. Hegney is on his way in. Okay, Mr. Hegney, whenever you're ready, I'll start reading it while you're coming in. Okay, so now we're going to go to the discussion items. Our first item is County Realty Company for a pre-application review at 241 West Putt, which is to change the drop-off area and the canopy at the Porsche dealership. Mr. Hegney, how would you feel if we just jump in and give you some comments?
Oh, that's fine. I did listen to the
Okay, so you know where we are.
yesterday, and there were a couple of things I just wanted to say. This canopy was constructed after approval in 2012, where we moved the drop-off from the east side over near Edgewood Drive to the west side so that the traffic would be coming off of the Post Road. The what we're looking to do here is deepen it by 15 feet so that we can accommodate 6 cars in 2 rows. These are automatic doors that open when the car comes up to the drop-off area, and close automatically as well after the car is pulled in. They have valets that take the cars away. So the idea of there being a backup onto the post road is highly unlikely. I would also add that a lot of the customers have their cars picked up, because that's one of the things that
No,
New
we know
Country
that.
provides for Porsche.
Yep, we've heard this a lot from you guys. So, Mr. Hegney, the 2 key concerns, I'm going to give you the most important one first. We are still really wanting to ask this question since you have a site plan before us. We felt it was fair game. The pickup and drop off of your delivery vehicles, of your car carriers. We are more concerned that the car carrier situation is not going to be impacted or worsened, because we've been fighting everybody tooth and nail on that. We'd like you to talk to us about that when you come in for the application. The second thing is to look at the parking lots that you have on this one for the change in the access, and just confirm to us that you're not going to be tight for parking, because that's why we keep being told you have a problem with the car carriers.
So adding the 3,000 square feet that this would be, enclosing the canopy area and deepening it by 15 feet would require us to have 60 parking spaces on site. Back in 2006, we actually got approval for stacking of cars to add
We remember that.
And,
Katie mentioned it yesterday.
And with those, we would have 87 parking spaces on site.
And are you going to do that then?
Yes, that will be done as part of this plan now.
Okay, that would be very helpful. All right.
On the drop off, I'll just quote the commission's condition.
I would call it delivery, vehicle delivery. When you say drop off.
Yeah, delivery is the better word, and the one that was used by the commission in 2015, and I'll quote, "All deliveries shall take place in the designated location on Edgewood Drive as previously approved." New Country Porsche is the only vehicle dealer that I'm aware of that has the right to do this. None of the rest of them do.
And we would never do it again, just so you know.
I understand, but it was an acknowledgement at the time that this was done years and years ago that you couldn't accommodate them on this site. Whereas when we came in with Audi, we had to drop the curb and expand the
Okay.
and so, but when I saw them when I drove by yesterday morning, they were on site at Audi.
Yes, well, this is another one of the things that we do all the time. We drive up and down West Putt and we look.
Mm-hmm.
Okay, because we work this significantly and we want to keep the car carriers off of the post road. Okay, so those are the key concerns the commission had. Do you have any other ones, people?
I think, sorry, go ahead, Nick.
Go ahead, Katie, go ahead.
Well, I think, I mean, it's more than just a concern in this case of this drop off, because when the loading area was created in the first place.
Okay, so wait, Katie, Katie, differentiate between service drop off and the vehicle deliveries.
Yeah, I think I obviously
don't say drop off.
But since this is a pre-app, I'd say I think your client should look very seriously at changing that. And I'll my reasons why, but it's based on the history. At this point, I think it's now a changed environment, and your client should look very closely at that, as opposed to just, oh, can you think about it kind of thing. Like, you really need to change that.
All right, I wasn't going to put it as strongly, but I'm going right behind the town planner. We really don't like having that drop off. I'm sorry, the car carrier there. So then the question is, can you redo the site plan? Can you take a look at your site plan? Since you're going to have the 87 parking spaces on site, can you figure out how to accommodate your car carriers on site?
I have asked our engineer and landscape architect to look at that. They were not encouraged by the initial results that they had. I will ask them again.
Tell
I
them
think
that the commission is very negative because Katie and I will lean on everybody. No, just kidding.
And these are very fancy cars. I'm imagining that they're handled in such a way that they're not used as, the way some of the other dealerships would. I mean, they seem like specialized vehicles that are on smaller carriers, etc.
So they get essentially 8 deliveries a month of cars, and it takes about 2 hours to unload each of the deliveries. So we're over the course of a month, they're occupying this space for 16 hours.
Right, and it's not a great condition to have any carrier out there for any period of time.
And all the people who live up Edgewood, they just
See, I don't think it's not Porsche that's making this issue. It's that there are other car carriers that are using it. It's people getting their own cars picked up or delivered by private car carriers, and that there are car carriers queuing in the neighborhood. I think that's what really bothers everybody. If there's one car carrier in this particular location, I don't think it causes any issue for anyone in the neighborhood. It's that they back up and that there are other either dealers or private carriers that are using this.
But it was created at a time prior to everyone coming in and doing new site plans and getting the drop off done on their own property. And Porsche should do the same. Everyone else has done it. This dealership should do it too.
Except this one,
limit the loading zone and create a safer condition for that residential neighborhood.
Okie dokie. Mr. Hegney, it's just been.
we'll continue this discussion.
And continue the discussion, but bear in mind that every single time we talk to somebody, they go, "Oh, we don't know when the car carriers are going to come," and it's really. And we spent months trying to get the car carriers off of the post road. Okay,
we need to
so
eliminate the loading zone.
okay, so you know what the issues are for us. Does anybody else have any major issues?
No.
No. Okay, we good.
Mr. Hegney.
What was
late?
Okay, first Nick, and then Levy.
Mr. Hegney, is there overnight drop off? Bring my car, leave the key in the drop box kind of thing?
Yeah, they check you in afterwards.
There are a few people that do that. Most people are reluctant to leave their Porsche, even with the key in the key box, out at night. So
even though all over Greenwich they leave the Maseratis
unlocked.
Yeah,
and they leave the keys in it. Yeah. It does happen on occasion, but those are infrequent.
Okay. All right.
Okay. When you return, I'm failing to see how the 2 doors, the sign that's out there, and the curb cut all align. I think a really good considered effort of actually trying to get that to work, because as I see it from Google Street View and the plan you have it, as I bring my Porsche into that automatically opening door, I got to scoot around the sign and jump the curb to get in.
I don't want you to do that with your Porsche, Mr. McCoy, so we'll make sure that works.
That'll be wonderful. Thank you.
And then if you could differentiate or explain or denote the car display in the front versus.
Oh, thank you for remembering that.
Parking.
Thank you for remembering that. The car display. Yes, thank you very much.
Yes, it would be nice just to see it, a clean version of how it works, so that we understand, will you be parking any cars in front of those doors at any particular time for display? Is there any queuing issue as a result of that? I think Mr. McRae mentioned that before. Just so that we are clear on how it actually works.
Great.
And I understand that this is a way of creating a nicer environment for people dropping off cars. It's indoors and so on. It makes sense.
Just because
it looks better.
All right.
Yes.
Okay, that's just because I'm not a very intelligent commission member. Is that front asphalt area supposed to be display or not?
There are parking spaces that we did show on the as-built.
I has 2 spaces, but is the rest of it,
And a handicap.
yeah. Something else to resolve for us, please, when you return.
Okay, understood.
Okay. Do we have any comments from the public on this application at 241? 241 West Putnam? No. Okay. Mr. Hegney, are you staying with us for the next one?
I'm done. But
I
enjoy
don't,
the rest of your evening.
well, that's the thing is I don't see counsel for,
Mr. Haslam?
he's not here.
Not here.
Oops.
Is the Armory one we're gonna do?
Yeah.
But I'm not seeing Mr. Haslam.
Well,
I thought it was Mr. Cohn who was handling that.
Well, there's nobody here regardless. There's GCTV, Jenny Larkin, Joe Pecora, Leslie Yeager, and Michael Bender, who probably doesn't mean to still be here,
And our esteemed commission.
and us.
Then you can take the rest of the evening off.
Okay. All right. Okay. Well, I'm going to move you out so you can go take the evening off.
Thank you. Good night,
Um,
everyone.
Did Mr. LaRoe just call us the steamed up commission?
esteemed.
Esteemed.
Esteem?
Steampunk. The
Okay, you
steampunk
guys.
commission.
So, Mr. LaRoe and Ms. DeLuca, would you do us a favor on the applicant for this discussion item? Would you kindly pass on the feedback that the commission gave at the briefing yesterday?
Absolutely. And
And
I
and
think
the-
they were there for it, so hopefully they're not looking for additional comments.
Okay, and just let them know that
apparently
we,
not.
that we have some concerns about the architecture and that we absolutely would be looking to protect the entire armory structure. Full stop. And
She
would
said
it
that
we-
in such a pleasant way.
yeah, because I didn't want you
He's
guys to
good.
go. So,
Words,
Yeah.
I don't know if you feel comfortable opining on this, but the one plan had like a front facade, like a facade. So you're saying no, the whole building, right?
I think we want to keep the whole bill,
Main-
what we said
maintaining the
yesterday, which is
the
all that
building.
can be passed on to the applicant because the applicant isn't here, so we can't open the we can't have the discussion item. I would
Yeah.
just say relay the contents of the
Uh,
briefing.
Should we give him a ring, see if he's,
No,
I could send
No.
him,
God, no.
no.
It's like
Okay,
11
just
o'clock.
saying.
If I was sweating bullets that I wasn't going to make 11 PM for you guys and we lucked out.
It's the wrong number, okay, to be focused on. Okay, these meetings should not go to 11 o'clock.
Okay. I'm just slowly getting better. If I can beat 11 PM, you can give me 10:57.
I
If we-
don't know.
if
You
we
guys
beat
start
9,
Is this meeting over?
Members.
Yes, this meeting is over. Katie
Yeah.
and Patrick are going to pass on the feedback. Everything we said at the briefing session is the only thing that can be discussed now on this application. But I think that's sufficient that we had concerns, quote, about the architecture and that we support the HDC rather than do the ghost structure, that we would like to see the whole building saved, the entire structure. That's what we said yesterday at the briefing.
Got it.
And we don't have anything to vote on, correct?
No, there's nothing to vote on.
Which is
Okay,
going
well,
to
I'm
be very sad the next meeting because it means we're going to be slammed with decisions. And there you go. Patrick, last thing, the 207 Byram letter, did it go out? Because Marisa's out and
It
I
would
don't know
go
if
out, the decision.
the decision letter, she sent us the draft to review. I just don't know if somebody remembered to send it.
I don't even know if I'm on the email for the draft. So if someone could send
I
it,
can send you the draft and just make sure it's been sent.
technically it can go out tomorrow. So we're not in the
Okay, so I will send it to you right now. It's fine. I didn't have any comments on it.
Yeah, I sent it back okay. I sent it back to Marisa okay.
Okay, but
Yeah,
she wouldn't have gotten it.
She doesn't
Okay.
usually need me to help her,
No.
so that's why she didn't probably put me on it. So
No, okay, I will send it to you right now.
Okay, this has been great fun and we'll
It
see
was
you.
great. See you guys soon.
thanks, everybody. Bye.
Thank you.
Bye.
Good night.
Good night.